Well, good evening. Happy Friday, everyone. It's 8:35. So we're doing okay on timing. I do know that as of the time that I'm starting this live stream, I know that the jury, I believe, in the Sarah Boone case has been out and away for going on a little over an hour and a half at this point in time. So I have the stream pulled up to the side, and we're gonna figure out what's going on as soon as I can get everything up and running. But how we doing? How we doing? Where are you tuning in from? What is going on? Apparently, I'm getting reports that the verdict is in. Let's see. I've got Core TV stream pulled up. Let's check another stream. How's your week? What's going on? I had artwork and stuff to show. Let's see. Pull up the live stream. Double check the reporting. See what we've got going on. Let me double check. Do we want to be on the Core TV or do we want to be on a local channel? Should we check in on Scott? I don't think we should. I don't want to do that. So let's go ahead and pull this up. No, don't crash. Please don't crash. I need you to work tonight. Audio boosted. I was getting reverb for the on channel. That's what happens when you have it on in the background. So let's pull this up and have it along. So when we get news of the verdict and when they bring them all back into courtroom, we'll be here to watch. All right, there it is for now. So while we're waiting on that, how's your week? What's going on? How was everything? I know that Court TV is saying the verdict is in. I have been watching. Hour and a half, by the way, does not look good for Sarah Boone. If that really is the verdict being in, that does not look good at all for Sarah Boone. Hour and a half. I can't imagine that comes back quick, and that's a not guilty. Yep, Kathy Russin's reporting that there's a verdict in. So it looks like we didn't even have to wait till 9. Oh, we've got a shifting of the camera. There's a shifting of the camera. It says verdict. Can we get the jury in, please? Because I'd very much like to, what do we do? If we get the verdict, do we go back and recap the closing arguments? I think we have to. I think we really have to. Because I was very curious on closing arguments and how they would go. And I will say, Cacciatore, I loved the closing. Loved it. Phenomenal. Owen, I thought his closing was going to be, well, essentially what it was. I thought a lot of people would be pissed off about it, and they were. And then we had the rebuttal close by Jay, and I didn't get to see all of it, but the snippets that I saw, holy smokes, that was kind of odd. In either event, I don't know that. I mean, the closing was a lot better than the opening. Those videos, though, towards the end of the trial, I think is what broke the camel's back. Now I got to close the poll. Close poll doesn't make sense right now, does it? So let's see. Still waiting on everything to come in. We've got Court TV up in the corner over there. Go ahead and make sure I can close that poll. We're not listening because it's not fair. 852 of you voted. You know what? 81% of you were right of the 852. However, I think some of you might have known the news beforehand. What is hanging in that? We had the, look at this. What is that hanging? Like right in the seal of Florida. What are you? It's like something hanging from a chandelier. From the chandelier. So waiting on the verdict to come in. See, that's not funny. Microphone? No, it's not a microphone. There's no way that would be a microphone. I think it's a fan cord. It's got to be a fan cord. People saying that was fast. I wasn't expecting tonight. I think it's about right, honestly. this trial went a lot smoother than we all thought it was going to go. The trial itself was run in a very streamlined process. This judge was not playing around. So the judge was all about it. You know, get in, make your arguments, put the evidence on, get out of there. Less than 2 hours. It's not that complicated. It really isn't. People think it is. Now, here's the thing. It could be an NG. I don't think it is. It could be a lesser included. They could go back and they could have basically said, we're not going to go on the top charge. We're going to go on the lesser included charge. Actually, let's go ahead and do this. What we've got from the jury instructions, let me pull that up real quick because I know that they were given 4 possible ways they could have voted in the jury pool. Let me see if I can't find that jury form because I know that it was moments away verdict in Florida versus Sarah Boone. All right, they could have gone murder second degree. They could have gone manslaughter in the second degree, felony culpable negligence, or not guilty. All right, so the two lesser included in the murder second degree were manslaughter in the second degree and then felony culpable negligence. So culpable negligence was basically what you did was you violated a duty, therefore you're liable in the resulting injury that occurred thereafter. Well, criminally responsible for it. But they all wanted the murder charge. And I don't know. I mean, the way that they went at this, I was worried about Owen, the way Owens gave his closing argument. We'll recap in a little bit. But I was pretty sure that the way that Owens boxed him in, it was all or nothing. Like you either bought his argument hook, line, and sinker, or you didn't. And by the end of that trial, I didn't feel like a whole lot of people bought that. Oh, there's a head. We saw there was a head. We saw a head. We saw a head move. Saw a head move. You guys, I know that there are multiple people streaming at the same time. It's not going to hurt my feelings if you go one way or the other. I will be here for a while. FNF is not a short-lived live stream. We've got a whole lot to recap. We've got a whole lot to go through in this particular trial because I have not been able to dissect any of the closing arguments yet. And we really, really need to. People are now messaging. We have a verdict. We have a verdict. We have a verdict. Yes, I gather that. I thank you for the messages, all of you who sent them to my phone, but we do know that we have a verdict. Right in time for me to show artwork. Look, I got pretty artwork today. We got very pretty artwork. It was a gift. I loved it. It was fantastic. So there's your little positivity before we find out whether there's been a verdict. Or no, we know what the verdict is. To those of you saying fast can't be good, not in this case. I thought, honestly, I really thought that they were going to go back and that they were going to look at I thought they were going to look at the text messages. I really did. Because those message exchanges, I thought they were going to go back and find it. But what really, those rebuttal videos that they played in closing arguments, they were it was something else. I'll tell you that much. I don't know how it made you guys feel, but it didn't make me feel very comfortable. It was kind of a lot of what we see a whole lot of what we get to see in domestic relations litigation. Oh, shaking camera. Oh, who's complimenting the arc? Yeah, that's Mini Mischief 2. Spooky, lovely art. It was phenomenal. Mini Mischief 2 brought that home. I got the gift. It was phenomenal. I loved it. Come on. Bring in the jury. Can we have the jury, please? We'd like to see the jury. Well, not see the jury, but we'd like to hear from the jury. It'd be awesome. They're probably giving the individuals. You know what? Let's go ahead and do this. Because we know that we have a verdict, we'll go ahead and put a poll up. And we'll give you guys the exact same options that the jury got. How's that sound? I think that's what we do. Because we're just waiting around for the jury to come back. It doesn't make sense to really start into anything when we know that they're coming back unless we have a specific time in which they are coming back. And I don't believe that we do at this point, just that we have Sarah Boone being transported back into the courtroom. Mhm. Very soon, verdict to be read. Yes, we know this. We very much do know this. Because we've all been waiting for this. Very much. So as we're waiting for this one to go along, let's go ahead and see. We've got a mistrial request. That was earlier today. Text messages. And let's see. Sarah Boone. See if we can get the jury instructions up. And while we're doing that, pull this up because we can do the things. Look, you know what? What's great is the internet has. I'm not going to say it out loud. I'm not going to say that out loud yet because we don't know if that's been the case or not. There were some decisions made. Didn't really agree with them. Okay, what's the verdict? Verdict predictions. Guilty, second degree murder. Guilty, second degree manslaughter. Guilty, culpable, negligence. And then last one, not guilty. So we've got our poll. There you guys go. So you can start voting in that while we're waiting for everything to come in. And see, everyone's voting right now. Second degree, second degree, second degree. Who's one of the live reporters on the ground right now? Because this is one that I haven't. Wait, judge is on the bench? Where's the judge on the bench? I don't see the judge on the bench. I'm live. Judge on the bench. Why is Core TV lagging? Hang on. Let me switch tabs. I'm there. You're not missing yet. I'm listening. You guys hear it?
Would like to rise during the jury coming in. I'm asking if there's any way we can take off the handcuffs and the waist chain so that the jury wouldn't see it in case there's something wrong with the verdict form or, there's an issue, which sometimes happens, but that's my position.
Okay. I've been advised by the sheriff that during the reading of the verdict, due to Miss Boone's status as an inmate, their leg irons and the cuffs are to be attached.
Well, she's going to stay seated.
That's fine.
Mr. Beck's going to stay seated.
I would ask for all to remain seated, and could you remind everybody in the gallery that there should be no emotional
I
reactions.
was just about to address that, sir. Thank you very much. All right, members of the jury, my understanding, or members of the gallery, good evening. My understanding is that the jury in this matter has reached a verdict. I don't know what it's going to be until it's read. If you are unable to contain yourself emotionally and you're going to react in any way, be it in joy or in sadness, I'm going to ask you politely to excuse yourself at this time.
And the poll.
There cannot be any emotional outbursts when the verdict is read. Does everybody understand
second-degree murder?
I see everybody nodding their heads. Okay. All right, State, are we ready to bring in our jury?
Yes, Your Honor.
Defense, are we ready to bring in our jury?
Yes, Judge?
All right, let's go ahead and bring in our jury. Everyone will remain seated.
Do we need to hear the pager button? Can we not, Judge? Let's see. Go live. Hang on. There we go.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes, sir.
All right, members of the jury, you may be seated. Thank you. Members of our jury, good evening. I understand that you've come to a verdict in this case.
Yes.
If you could please hand the verdict form to the deputy, please. Thank you, sir. Madam Clerk, if you could please publish the verdict.
In the Circuit Court of the Ninth Judicial Circuit in Orange County, Florida, case number 2020 CF 2603, the state of Florida versus Sarah Boone. Verdict. We, the jury, find the defendant guilty of murder in the second degree as charged in the information. So
Second degree.
dated at Orlando, Orange County, Florida, on this 25th day of October 2024. The form has been signed by the foreperson.
Madam Clerk, please poll our jury.
Juror seat number 1, is this your true and correct verdict?
Yes, it is.
Juror seat number 2, is this your true and correct verdict?
Yes, it is.
Juror seat number 3, is this your true
Yes,
and
it
correct
is.
verdict? Juror seat number 4, is this your true and correct verdict?
Yes.
Juror seat number 5, is this your true and correct verdict?
Yes.
Juror seat number 6, is this your true and correct verdict?
Yes, ma'am.
Members of our jury, again, I want to thank you for your time, your sacrifice, and your attention in this matter. I know that we spent almost 2 weeks together and it was not taken lightly, and I really appreciate the time and the effort and the sacrifice that you put into this case. I want to advise you now of your final instruction. Members, ladies and gentlemen, I wish to thank you for your time and your consideration in this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak to anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. With that, members of the jury, again, I thank you for your service. I'm going to ask you return to the deliberation room. I'll be back there shortly with your jury certificates, and thank you.
Certificates.
Ms. Boone,
Yeah,
jury has spoken in
put it
this
to-
matter and has found you guilty of murder in the second degree. The court adjudicates you guilty of murder in the second degree. As this is your first felony conviction, you are entitled to a pre-sentencing investigation by the Department of Corrections. Mr. Owens, are you seeking that in this case?
Yes.
Okay. State, I will order the Department of Corrections to prepare the pre-sentencing investigation. State, for the purposes of sentencing, do you anticipate eliciting any testimony from, be it the victim's family?
2 or 3 victim impact statements, sir?
Okay. Mr. Owens, do you plan on presenting any evidence during the course of the sentencing hearing, sir?
Probably some testimony from Dr. Harper.
I'll talk
Okay.
about a jury
All right.
statement in a minute. We'll go, guys. I see the question.
How
We'll go
long
through
do you
this.
think, State, that you would need?
You mean timing-wise, or are we thinking?
A quantum of time, sir. Yeah, well, normally it takes about 30 days or so.
Yeah,
I'm
so
confirming with
3 days,
Anita as
3
to
days.
availability. I just want to know from your side of the ledger, how much time? Okay, 15 minutes. How much time do you think you're going to need to produce anything from your side of the ledger, sir? Mr. Owens?
I'd say 30 minutes.
Okay.
30 to 45.
So if we set this for an hour, that would be sufficient.
Party agreed.
Okay.
State agrees.
Is that sufficient, Mr. Owens?
Yes.
Okay, all right, give me a moment.
They usually don't mention them. I'll talk about it again. I'll go over the question.
Ms. Barrios is checking. Just give us a moment. We can set this matter for 1:30 in the afternoon for sentencing on December 2. State, is that acceptable? It's a Monday.
I have a status here, but I'll make it work.
I can move it to later if necessary.
I'm co-counsel on it.
Okay, defense.
You know, 1 minute.
Yes, sir.
That's Monday, December 2 at 1:30.
Yes, sir.
I can be here.
Ma'am, you've been adjudicated guilty. I now remand you into the custody of the Orange County Jail pending sentencing on December 2 at 1:30. State, anything else we need to address?
Not from the state.
Defense. All right, thank you very much. We're off the record.
Off the record. Okay. Guilty, second-degree murder. All right. So there's a bunch of questions. I know there's a bunch of questions, so let's go ahead and get to those. We're going to watch Sarah go ahead and get led away. And that is done. So right now, trials are bifurcated into 2 parts. There's the guilt phase and the sentencing phase. The guilt phase is the adjudication. It's the finding of the guilt, whether the person is or is not guilty of the offense charged. After the adjudication of guilt, there's a secondary phase, which is the sentencing phase. Sentencing is dependent by state and by jurisdiction. So some sentences, for example, if this were a capital offenses in Florida have to be, the sentence is delivered by a jury, I believe, as the jury is one who adjudicates the sentence. But given that this is not a capital offense, the sentence will be determined by the judge. The judge ordered a PSR, that's a pre-sentencing report, that's going to go through and discover a background of all of Sarah Boone's, look at her criminal history, her ability to, be accepted into the system, the likelihood of recidivism. Basically, they're going to try and determine what the appropriate sentence is going to be for her. Now, her charge, I believe, is facing from anywhere from 16 years to life in prison based on the conviction of second-degree murder. So I don't know what the PSR is going to discover, but we shall see. You said that you saw the prosecution really says they don't need a whole lot of time. They really don't need a lot of time for this one. It's going to be pretty straightforward. They've presented all that they really need to, and everything else is going to be pretty much presented in writing. They said 2 to 3 victim impact statements, very likely to be family that's going to get up and testify to the impact that the loss of George is on their family and their household. Sarah Boone has the opportunity to present evidence of her own. So her being shackled, led back through the courtroom. What are we doing here? Wait, what are we doing here? Oh, they're fingerprinting. Got it. Okay, that makes sense. Minimum is 22 and a half years. Minus the 4 already served. That sounds about right. Well, no reaction. I didn't expect a reaction, to be honest. I don't know that we would have gotten one. We'll see. Let's go ahead and answer some of the questions because I saw a bunch of those flying by, and we'll just keep that up in the background. I know that there's probably going to be some statements in the aftermath of this, and I will ask people to go ahead and keep track of that. Please don't post breaking news or anything. I have several channel mods who do a really good job of keeping their eyes on stuff, and I'm pretty sure that we're going to see what that's going to go after the fact. I don't know that the defense is going to give a press statement or not. I'd be surprised, to be honest, but Mr. Owens is really... She doesn't seem phased at all. She had to see this coming, right? Right. Really? She had to see this coming. Yeah. That's... Well, there we are. Back to the seal. So, people were asking several questions about the makeup size of a jury. The sizes of juries varies based on state. You know, most people hear this whole 12 jurors, 12 jurors, 12 jurors, unanimous. While that might be common, it's not technically required. Florida is one of the jurisdictions that uniquely has a 6-person jury for most criminal offenses, except for capital, which I believe is 8 or 12. 12, but they don't have to be unanimous. I think it's Florida. For example, Virginia, we have 12-person juries for felony cases, and for misdemeanor cases, if you want a jury trial, it's a 7-person jury. So the number of jurors depends and varies from state to state. Florida, 6-person jury requires unanimity, and it didn't take those 6 individuals very long to get to that unanimous verdict. So the other question I saw in the floating around the chat was, what's a juror certificate? A juror certificate is you know what? It's this. It is, I have served on this jury. I have done my jury duty. I have done my public service, and it's signed by the judge, and it shows the dates. It's a little memento of the service that you perform. Honestly, what you get most out of it is the judge coming back and thanking you and giving you the time and thanking you for the service. I mean, serving on a jury is both a responsibility that we have, but it's also something that's remarkably ingrained in our Constitution. It's a very unique system that we have. So it's really important that we celebrate jurors and the jury system. So there was a point in time during this trial where Judge K made the comment. It was at the start of today, so I might go back and find that, where you had one of the jurors come in having observed something over the course of yesterday. And that juror there were some additional questions asked of that perspective, or that juror. I think it was number 2. I don't know if it was number 2 or not. But they said that there was a domestic incident that occurred outside in the courthouse. And they had to bring the juror in to ask some questions to basically determine whether that view, what the juror saw, had any impact on the ability to be impartial. If a case involving domestic violence between interpartners. And of course, you're going to have a question as to whether during the course of this jury trial, a juror is walking around the courthouse and they see intimate partner violence right in front of them. yes, that could taint a jury pool or the jury. So there could have been a change of jurors at that point in time. But what ended up happening was the juror was brought in for questioning, and the juror was, they went ahead with it, but the juror was allowed to remain seated. And in remaining seated, as the rest of the jury came in, everyone else in the courtroom stood. All the individuals stood. And the juror who was seated in the jury box went to rise, and the judge corrected, and the judge says, no, you don't have to rise. We rise for the jury. And it was a clarification because they are the adjudicator of fact in these particular cases. It's important that we do that to honor the jury system and make sure that it remains intact. So I'm just looking for this additional part. Owens is talking. See if I can't find. Let's see, where is he talking? Where is it? Court TV? No, it's got to be local news. Where's Tampa? We'll get to it, guys. All right, let's tell you what. They're not going anywhere. In 1 second, I'll find this. If we can find the live feed. WFPS. Okay, looking for the live stream of James Owens. There we go. Hang on, bear with me. All right, I've had it. Let's pull this up and see what he wants to say, and then we'll go back. We are going to go back and watch these closing arguments because I do actually want to see. I didn't get to see the rebuttal closing. I didn't get to see the rest of James Owens' closing statement. Me get small.
Intentional act.
Okay, let's go to the beginning.
And speaking with reporters. Want to jump in here, Garrett Weimer. We appreciate you watching. James Owens speaking with reporters. Let's listen in.
In shock. She said she would call me tomorrow morning, so we'll talk some more after she's had some time to think about it. I've had some time to think about it, but we're obviously really disappointed. We did the best that we could, in the time that we had to prepare. Sarah really liked the team, and we all got along with the 3 lawyers and the other 2 girls that have helped the other lawyer. 4 lawyers working on the case, and Sarah was, as you know, really happy with us. And, we had some disagreements about how the case should proceed, and Sarah, is opinionated, and some of the things we considered, some not. But ultimately, I think she was happy with the defense. It just didn't go our way. As you know, these trials, you know, a murder charge is a difficult case to beat, and there was some strong evidence that the state used, obviously, and we just, for whatever reason, the jury didn't consider some of the things that we felt like should have potentially been defenses, the justifiable use of force under the battered spouse syndrome. But for whatever reason, you know, we respect the jury's decision. You know, they've been here for 2 weeks. Took us 4 days to pick the jury. And so I'm sure they did the very best that they could under the circumstances.
Was it her decision to not take the plea deal? Or you think she regrets it now?
Yes, it's her decision.
I don't.
You better
think
say it was her
she would have
decision.
Taken anything. You know, I think she wanted, some clients, they want their day in court, and I don't believe she would have taken anything. I felt like the state should have probably negotiated a little bit more, but they were firm on where they were, and Sarah was firm on where she was. I just think.
Why is the state going to negotiate? Why would the state negotiate any more than they did? They were willing to give, I think, 14 years, which would have been what? Put her, no, the latest deal would have had her at in what, 5 years? I'm not ripping Owens for the job he did. I'm not. I'm frustrated sometimes because the disconnect that existed when he was giving his closing argument seems to still be existing now. I don't know that played well for the jury, especially a particular juror on the jury. We'll go back and call it. But it was 15 years in time served, I think. So 15 years, and she would have had already served 4 of those. So she would have been out, but then additional credits, so she would have been out in 8 for. Why would they negotiate beyond that? Why would they negotiate beyond that? They just got a murder charge. They just got a murder verdict in hour and a half. So I don't know. Katrina Bunny, the full verdict was murder 2, guilty. That's the only charge they needed. Murder 2. They didn't have to go to the lesser included. They didn't have to go beyond that because they said murder 2.
You know, she was convinced in her mind that that she felt like, you know, she felt like she didn't intend to kill George, and that this was just a circumstance because they were both intoxicated. Things happened that, you know, it was just really unintentional act. So I think she felt bad about any kind of a murder conviction or pleading to any kind of a murder, that she was somehow criminally responsible for George's death. And I think that's where her mindset was. And, you know, I think she would have gone to trial even without lawyers. You know, she was ready to go to trial pro se. I think she was happy we came in. We worked as hard as we could. We had about 45 days to get ready, and we did it all that we could. So I think she feels good about our efforts. We put everything out on the table, just like any other contest. You know, you do the very best you can, and then you have to accept, you know, the decision by the jury. We respect the jury and appreciate their time and attention on the case.
Will you be representing her on her appeal?
No.
Yeah, no.
No,
Trial
I'll be
attorney never.
representing her at her sentencing, but not the appeal. I think she would qualify since she's indigent for court-appointed appellate counsel.
Yep.
And those guys, that's all they do is appellate work, and those are probably the best lawyers to handle something like that. But we're, as I said, really disappointed. Sarah is kind of in shock, but you know, we respect the jury's decision. Thank y'all so much.
Thank you.
Okay, so there's Owens' statement. Now, some of that obviously don't really love. Some of that obviously is somewhat okay. Let's kind of break it down a little bit here. Was there some comments that were pretty misogynistic? Yeah, there kind of were. Do I think that he did the best job he could? in this particular case to put on a defense and tried to get Sarah a defense to which she was lawfully entitled and to which every defense lawfully entitled? Absolutely. He keeps saying 45 days because honestly, I don't think I've ever heard of a murder defense going forward 45 days. That is wild. 45 days, and he lined up an expert, the expert that came in and testified and gave Sarah a shot. I mean, they got to that self-defense instruction. So the legal wins that he lined up and he actually got in this case are largely also because Kranick was being very careful in the case itself to preserve the record. Did a pretty damn good job. I mean, damn good job. I don't really like his style. I didn't really care for a lot of the words he chose, but I will say that he put on a defense and he went with that defense. And there wasn't a single ounce of doubt in his voice, whether he believed it or not. I don't know if you guys caught in that statement that he might have been saying some words that he didn't fully believe in. It's his job. That's the job of the criminal defense attorney. They have to put on a defense for their client. Zealous advocacy. And it's important that the person that gets up and stands up in your defense, whether everyone else in the world hates you or doesn't believe you're entitled to one, it's important the person that stands up and makes that defense for you puts their full heart behind it. And it was very clear that Owens did. Did it rub a lot of people the wrong way? Abso-freaking-lutely. Yes, absolutely. There were times when I was screaming at the top of my lungs, but Sarah Boone got a defense, a very capable defense. Now, why don't trial attorneys act as appellate counsel? First and foremost, because one of the appellate issues that's almost always brought in criminal defense trials is that lovely issue we like to say, ineffective assistance of counsel. And if you were trial counsel, you can't necessarily, well, if you're trial counsel, you can't really put into an appellate brief, dear appellate judge, I was trial counsel and I was ineffective and an idiot, and therefore please say that that was reversible error and give my client a new trial. No, can't do that. Not allowed. So usually, not usually, but there will be appellate counsel. It will be a appellate counsel, very likely appointed and paid for by the state. So also appellate counsel, you know what's interesting about them? They don't have to deal with the client. They don't. Sarah Boone, I mean, very largely doesn't get to decide what appellate issues she wants to present. That appellate counsel, same zealous advocacy exists, and they are required to kind of push every envelope on the appeal to try and get a new trial. Is any of that going to happen here? No. Kranick was remarkably careful with the record. I don't see any issues for which an appeal can be, you know, I don't see that going anywhere. Not at all. So guilty in an hour and a half. Guilty in an hour and a half. So what do you guys think about that? Ask some questions. I will get to those when we get through some of the super chats. And what we're going to do is go back and watch some of that closing argument again, because especially Cacciatore's argument. It was Cacciatore, right? I said it right, right? It's not just like chicken Cacciatore. Cacciatore, that's his name. I hope it's correct. So we're going to go back and watch some of that because I thought his closing was remarkably organized. I mean, it was one of those that it spoke to me as a trial attorney. I liked the way he did it. It was very structured, very organized, went through methodically the different elements and then had the right emphasis when he needed it. And then Owens had the opportunity to get up, and I don't know where the hell he was going at all. But we're going to see. Josh, thank you for getting memberships. Very much appreciated. Thanks for being here. Jen P, thank you for being a member for 16 months. My gosh, help EDB reach 800K before the verdict. I don't know if we can do that. Let me see. Where is she now? I know that she was streaming this trial every day. I don't know how she streams these trials all day long. I'm exhausted. I had court. She's 798,000. Let's see. She has a little ticker on her channel, so I think we should be able to see it. $7.99 right now. So there we go. She's doing great. She's rocking it. Baby Gator, thank you very much. Oh my God, I literally just finished watching Replay Crew with EDB from today and came here to find the verdict. Yep, the verdict is in an hour and a half. So I don't know that she even got through questions by the time the verdict was read in. Or did she? I don't know. I was in court for 2:00 motion, so I was able to watch some of the prosecution. I was able to watch prosecution closing argument. And then after my motions were done, was playing Zoom on 2X, watching some of the defense closing argument, and then I wasn't able to watch a rebuttal close before I had to, scoot, take the kiddos to get some dinner. So that was my goal, was to watch that and then to sit down here, get that queued up. And as I'm getting it queued up, everyone's saying there's a verdict in. So the ADHD brain panics, not having the live stream up. It takes a minute or two to get into the swing of things when it's night. That's why FNF usually takes 30 minutes before we get to the subject, because you take a little while. Heather, thanks for becoming a member. Much appreciated. Fiona W., thank you for the 10 gifted memberships. That's awesome. Cherry Mills, thanks for being a member for 21 months, almost 2 years. Congratulations. Sandy, thank you for gifting memberships. Very much appreciated. Narcissistic, tuning in from Central Florida. This wait is rough. The wait was not that rough. An hour and a half is not a rough wait. Spawn Point, thanks for becoming a member. Gen V, I get to buy my very first new car. So excited. That's a really fun process. That's an awesome process. I missed that. That was so much fun. So my first car was a 1998 Honda Civic. Silver Honda Civic. I think it was the LX. It had just the radio, not even a tape player. And I remember that I had to go and buy one of the little radio transmitters, we used to keep in the car, and plug it into your CD player that would skip every 2 seconds. So you'd be playing the CD player, the radio transmitter, and you'd be trying to line it up, and it would cut in and out like crazy. I love that damn car. Well, it was a great car. One of the very best friends I ever met. One of my very best friends I met as a result of that car. Particularly locking my keys in the trunk of that car, and with his assistance and a coat hanger that we found in our coach's car, breaking into the trunk of that car. It goes to show you the security of those vehicles back then. I was breaking into my own car. It's not illegal. It's completely fine. Thank you, Gene D, for becoming a member. Carolyn Knight, thank you very much. This is the best news I've had all day. Quick verdicts are good because you're not sitting there pondering and the jury gets to go home and everyone has closure. Shannon Rose, thanks for becoming a member. Mispronounced name. Sarah had a reaction. Watch it back again and watch Sarah's jaw tighten up. I think she genuinely thought she was going to be found innocent. Mispronounced name. You know what? I'm game. I'll do it. Let's see. Let's go back and watch and see if we can't see when that jury verdict is read again. Because I imagine a bunch of people will probably also, because it flew by with the speed it did. I mean, it was done in like a second. The judge is no joke. Where were we? Mm-hmm. And for those of you asking, yes, Ian said he'll be along. He'll be along at some point in time. He's been busy. He was live streaming earlier. Did Court TV really play this music the whole time? That's really annoying. Look at this. Just 11-hour stream. No way. Did that part get trimmed out of the stream? Or did they cut to a new feed? All right, let me pull this down. Let's find the other one. Let's see. Now I'm curious. My brain is now remarkably curious. Tell me they privated that thing. Or trimmed that part out of their live stream. Looks like they did. Jeez. Let's see. Look, who made me do this? Mispronounced name? The spinny wheel be upon ye. So let's see.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? Members of the jury, you may be seated. Thank you. Members of our jury, good evening. I understand that you've come to a verdict in this case.
Yes.
If you could please hand the verdict form to the deputy, please. Thank you, sir. Madam Clerk, if you could please publish the verdict.
In the Circuit Court of the Ninth Judicial Circuit and in Orange County, Florida, case number 2020 CF 2603, the state of Florida versus Sarah Boone. Verdict. We, the jury, find the defendant guilty of murder in the second degree as charged in the information. So say we all, dated at Orlando, Orange County, Florida, on this 25th day of October 2024. The form has been signed by the foreperson.
Madam Clerk, please poll our jury.
Juror seat number 1, is this your true and correct verdict?
Yes, it is.
Juror seat number 2, is this your true and correct verdict? Yes, it is. Juror seat number 3, is this your true and
Yes, it
correct
is.
verdict? Juror seat number 4, is this your...
I didn't catch that the first time. Whoa. Bro was eager. Hang on.
Juror seat number 3, is this your true
Yes,
and
it
correct
is.
verdict? Juror seat number 4, is this your true and correct verdict?
Yes.
Juror seat number 5, is this your true and correct verdict?
Yes.
Juror seat number 6, is this your true and correct verdict?
Yes, ma'am.
Members of our jury, again, I want to thank you for your time, your sacrifice, and your members of our.
Was he the only male?
Juror seat number 2,
Yes, it
correct
is.
verdict? Juror seat number 1, is this your true and correct verdict?
Yes, it is.
Juror seat number 2, is this your true and correct verdict?
Yes, it is.
Juror seat number 3, is this your true and
Yes, it
correct
is.
verdict? Juror seat number 4, is this your true and correct verdict?
Yes.
Juror seat number 5, is this your true and correct verdict?
Yes.
Juror seat number 6, is this your true and correct verdict?
Yes, ma'am.
Members of our jury, again, I want to thank you for your time.
5 females and 1 male. Who picked that jury for the defense? Why did they think that was a good idea? Well, there's your hour and 30 minutes. Look, this might be a whole lot of speculation, but the stats are pretty resoundingly clear on this one. Female jurors tend to be pretty harsh on female defendants already without bringing in any domestic violence issues. Well, I don't know that that was the right move. That just sounded like a terrible idea for the defense. What? Oh, looks like you got some other interviews. Let's catch these interviews because the Owens finished talking. Who thought that was a good idea? Allison Vandenberg, I did see your chat. We're not going to say the son's name. Nope, we're not going to publish the son's name. Yes, he's a minor. We're not going to say the son's name. Yep. Caden Banford, I was at a DV rally demonstration thing, not real TV. It was a DV rally demonstration thing, not real TV. Not real DV. I don't know that I'm not going to go that far. I think that relationship was pretty damn toxic. I've seen enough of those to kind of realize that there was probably toxicity in both directions. That was not a healthy relationship for either of them. Just because he's still blaming the time he knew he couldn't get a continuance, shaking my damn head. I don't fault him for that. I get it. You do what you can. You push what you can. She needed an attorney. I'm glad he was there. It probably made the trial a million times smoother having defense counsel present. This trial was done. Took 4 days to select a jury, 2 weeks total. So you're talking about 6 days of testimony total. That's pretty remarkable. So it was a very efficiently run trial. Chris and M96 Owens called the women girls twice today. He did. What a misogynist. I will say I don't like the words he said. He gave her a defense. Just because Owens is 2024, stop being unwilling to accept that women can harm men, it's sexist and perpetuates this kind of issue. That he needed to say battered wife a million times. He was never going to change from it, and any defense attorney in his position would have done the same damn thing. They absolutely would have done the same damn thing. It's the same reason why he referred to her as Sarah versus Ms. Boone versus the defendant. It's his job. It doesn't seem comfortable. It might rub people the wrong way, but his job is to try and to make her appear to be the victim and weak and the non-aggressor in that relationship. Does it feel icky? It can, absolutely. Trace Fagan, some Florida companies require the certificate to get paid. See? Look at that. So you come back and you say, I served jury duty. Here's my certificate. Please give me my money back or give me money. Thank you, Tracy. Very important information. I, for one, would love to serve on a jury. I will never be given that opportunity. I don't think until I retire, maybe even then. Just because Sarah's team did the best they could with what they had. I just wish Owens would stop throwing Kranick under the bus when he brings up the time. I don't think you're going to make any progress to Kranick. Oh, it reminds me, I had a trial. I had a trial 2 weeks. So, oh my God, I had a trial a month ago. And it was a condensed timeline. We had 1 day to put the trial on and not a whole lot of time. So opposing counsel in their closing argument makes the argument, where is this person? We didn't even hear from him. I get up there and say, well, there's a reason you didn't hear from him, Judge. I had a day. I don't fault the court for that. It was my choice in how to use the day, and I used that day as I chose and saw fit. Well, what does the judge do? But when the judge is reading their ruling, and I had it coming, the judge is reading his ruling. He says, I had to make a comment. Mr. Morton made a remark on the record about that seemed to imply that he didn't have sufficient time. I will say that both parties were given equal time and they had the ability to choose. And I knew what he was doing. It was basically to preserve the record so that I couldn't come back later and make some bullshit argument that I didn't have enough time to put my case on. It was just annoying. I don't know if I was more mad at myself or mad at the judge, like myself for making the comment, knowing that the judge was going to come back and do that, or the judge for making the comment in response. Just felt annoying. Yeah, I'm going to blame myself for that one. That pisses me off to walk into that one. That was a rookie move. Either way, I don't think Kranick preserved that record pretty well. It's like Delic Yoda, it seems to me the judge really did go out of the way to make sure bases were covered so the appellate court would have little issues, in my opinion. Yep, it's a very cleanly run, cleanly preserved record. Dr. Bullbutter, I'm so angry with Owens' victim's family crying. Look, these things are tough. Defense attorneys have an unenviable position of being the bad guy and having to say the things that are pretty aggressive. So, but I can see how that would rub you the wrong way. I try to give warnings to people when Owens was about to give up giving his closing argument. And I try to give people warnings that a lot of what he is going to say is going to rub you the wrong way. The absolute wrong way. Oh, sorry, Caden Banford. I misheard you the first time. Kaylee, I was there that day. The first 6 picked paddle number order, become those deliberating. Alternates were all the higher paddles. Full was 6 men, 8 female. But from my recollection, as they were going and picking the 6, they still had strikes and back strikes, and they could have gone forward. Now, unless there were all ladies lined up in the forward, because they were going progressive in number, they had sufficient peremptories. I think they had as many peremptories as they needed for alternates. So they had 8 alternate peremptories. And I don't remember how many peremptories they had going in. I think they had 6 each. So they could have struck for any reason whatsoever. When juror 13 ended up on there, because juror 13, they could have gotten off for cause, because juror 13 said that she was a victim of domestic violence and was going to be a witness in a case called by the state against the aggressor. Why you didn't strike her for cause, I don't understand. It's a massive risk. And Caden Banford, thank you for clarifying. No, it was a DV rally demonstration thing the juror saw, not real DV. See, that is even more impactful if it would have swayed their opinion one way or the other. I don't know. So let's see. There was some more statements given, so let's see what we hear.
Where things stand right now, it is 9:12.
Come on.
Coming soon. Is that going to be also on 303 still? Okay. So we apologize here. You're just seeing some of the behind the scenes stuff as things happen. So
No apology necessary, sir. Me. All the time. You're apologizing for that?
our crew is heading over to the courtyard right now where the state attorney will be speaking. You heard from Sarah Boone's attorney just a moment ago,
Right,
and we are going to shut up. It looks, and let's listen in.
Yeah, it's my big head fitting in all these lenses. That's what we're saying. Okay. All right. Everybody ready?
Yes.
All right. All right. So today, as many of you know, Sarah Boone was convicted of second-degree murder of her boyfriend, Jorge Torres Jr. You know, these events stem from an incident from February 23rd of 2020, where she zipped her boyfriend up in a suitcase in what she claimed to be a game of hide and seek. And 2 videos were introduced from her where he was begging for his life, and a horrific turn of events. And she didn't try to let him out. She didn't do anything to help him. She just went upstairs and went to sleep. And so this is a very horrific homicide. Nobody really should have to endure this type of struggle and fight for their lives and have to die alone, begging for their last breath inside of a suitcase like this. And the jury did amazing work. I'm thankful for our chief of homicide, Will J., and our assistant state attorney, Dave Cacciatore. They did amazing work. Some of you caught me in the courtyard. I was like, I get briefings about it every single day about what they've been doing, but we're excited that they were able to bring this home with a victory because today justice was served with the conviction of Sarah Boone for this very a horrific homicide that occurred. And so if you have any questions, I'm going to turn it over to
So
them.
strong. Oops,
Oh,
sorry.
Oops.
Argument, clearly the jury did not buy
Correct.
it. The argument was self-defense and battered spouse.
Correct. And so we're going to turn over to Will and Dave to ask all specific questions as to all the defenses, and because they did all the great work. So
It's pretty clear. Like, hey, I'm the elected DA. I just manage these guys. These guys are the ones in the trial doing the thing. So he's like, you guys answer the questions. That was loud. That was loud. Wow. All right, let's hear Mr. J. He's gonna give us name. You know what? That tie is a choice. Whoa. My dude. Oh, my dude. Wow. I will say that is great. Is that? It almost looks like there's kangaroos on it. What is going on? If that's his lucky tie, then that's his lucky tie. It's got to be his lucky tie. That is the only reason someone would continue to wear that tie.
Thank you. Yeah, so like the defense, can we speak about that? I know the jury obviously did not buy that. They came down with that second-degree murder charge.
Correct. Yeah.
Well, how does that make you feel? Did you get a chance to speak to the family?
Yes, we're very happy to gain some closure for the Torres family and some justice for George.
Strong closing arguments from the both of you.
Ma'am, you don't have to scream into your microphone. Can we just... Now I see a different version of the tie. What is going on, Mr. J? Also, can we do away with the single Windsor knot? The half Windsor, rather. Can we bring back the well-tied ties, please?
Today, what do you think, like she said, this case means for the family and getting justice for George Torres?
I think after 4.5 years and the numerous delays, I think they were finally just happy to see this case go to trial and be able to put this one in the books.
What do you think the appropriate sentence should be?
We'll reserve comment to the sentencing hearing.
Did you expect the verdict to come back that quickly? I think it was an hour and 20-something minutes. Very fast.
Should never have expectations.
What do you think about the case law with respect to Martinez? I know there was a strong...
Dude, this is the best interview ever. This is great. Will J was like, well, we're not going to say shit about that right now. We don't have expectations. We just... I mean, Cacciatore looks like the happiest human in the world. Will J is like, get me the hell out of here, bro.
Strongly worded letter you all signal you will be sending. Is that right for judicial review higher up?
Can't really talk about future legal arguments.
How was it in the courtroom
Great.
between you and James Owens? There's obviously moments of tension and then also moments of levity. Was this different than a typical battle that you go into?
I wouldn't say it was different than a different relationship than with most defense attorneys.
What would you say to the jurors who were here for about 2?
Ouch. Was that like sideways shade? Cacciatore, what did you say, sir? It's not different than relation with most defense attorneys. I mean,
Different than a different relationship than with most defense attorneys.
What would you say to the jurors who were here for about 2 weeks on this case? It was a long jury selection and then, of course, a lot of evidence to look at and all of that. What would you want to say to them?
Just thank them for their service.
Will, did you know that it was George Torres' mother who broke down in court today, and that was the reason for the bit of an outburst?
I was made aware afterwards. It happens in these cases.
Do you have a chance to talk to her and say something to her?
I have not yet.
How about you, Dave?
I spoke to her along with the rest of the Torres family after the verdict. And just listen to them.
A strong rebuttal yesterday from you
This lady is killing me. Just hold the microphone further over here.
guys. What do you think that evidence showed the jurors and meant for this case?
Not going to really talk about the evidence.
Final question from me is, are you stunned that she did not take that plea deal?
It's not for us to say.
Thank you, gentlemen.
Thank you, guys.
Thank you.
Sorry. You guys been here for a long time.
Yeah.
But thank you for coming. Thank you for covering the case.
Okay, thank you. Appreciate it.
Those are some of the best remarks I've ever seen in my life. Is there ever a more like FU statement from an attorney? This is the best. This Will J is, the man talked nonstop in court, but you get him outside of court in front of a camera.
And just listen to them.
A strong rebuttal yesterday from you guys. What do you think that evidence showed the jurors and meant for this case?
Okay, first of all, I love that they said a strong rebuttal. The rebuttal was basically just playing Sarah's own words back. And the expert.
Not going to really talk about the evidence.
Final question from me is, are you stunned that she did not take that plea deal?
It's not for us to say.
Thank you, gentlemen.
Well, okay. Why does he look like he lost? He really looks like he lost that trial. Sir, you just got a guilty verdict in an hour and a half. You got to be kidding me. What happened? Why are you upset? I don't get it. I'm so confused. Okay. So mad. He's like, I don't give up. Okay, Cora Savage, thank you. I think a lot of strategy was pushed by Sarah, including the female jury. The problem is battered part seemed to fit George better, and she's unsympathetic. It's a risk. I don't think you put that risk on. I made the comment earlier this week. I don't think you put that risk. You don't take the risk whatsoever. Gracie C, glad she's found guilty. She's manipulative. Even the remarks were it was retaliation, not defense. Alan Muller, sword mage. I get the sense that the only path Owens saw was to get one juror on board with the battered spouse, leaving time to prepare for retrial. Alan, I can see where you come with that, and thank you for the super chat, by the way. I just don't think that you were going to get it, especially not with, he knew those videos were there. He knew all the videos were there, the back and forth. And the best thing you get out of the back and forth is the understanding that there was a mutual back and forth between the two of them. In which case, a lot of what you're saying is out the window. Plus, you go back to the events of that night as testified to by Sarah Boone herself. And it's not, there's no imminent, there's no fear. There's no imminent fear. There's no action that would have caused that fear. So it just didn't make sense. Cindy Collins home from ER after a cat bite. My gosh. Meds and tetanus shot. Hopefully you feel better. Cat bite, my word. Cats are all trying to kill us. Melissa Webb, there's a whole lot going on in that tie. Yes, there is. There absolutely is. H Scorpio, someone give that man a Snickers and a shot of whatever. Pour him a cocktail. Crazy by proxy, it's been a crazy long day. He's just exhausted. I agree. And he's not, he's clearly not one for the cameras. He wasn't showboating a lot at all. So it was something else. So I brought the jury back. The jury's sitting behind me. Emily's juror bot is here. Six-person jury returned a unanimous verdict. Sarah Boone guilty of second-degree murder. And you're right, Morgan. I see the comment you're making here. There shouldn't be happy DAs after a murder trial. I agree with you. There should be relief that the jury came back the right way. And maybe that's what we saw. I mean, it's a lot of emotional offloading after a whole trial that you've been through. So it's something else. At least they don't have to pat themselves in the back like some attorneys we've seen after a trial. I feel like all attorneys do that. I feel like I've done that. I feel called out. Lion at heart, that tie was a gift from a kid written all over it. Could be. In which case, I love it. It's phenomenal. Yeah, the jury's back. At least partially. I still have to fix a bunch of stuff, but still got to get a bunch of that underway and corrected. So why don't we do this? I would like to go back and watch some of Cacciatore's closing arguments. Particularly a little bit of, oh, Chris and I heard that there's some bots for the auction. I can't wait to see them. It's going to be phenomenal. So let's watch some of the closing arguments again, because for me, I don't know that a lot of this came down to the closing arguments, but closing arguments either seal the deal. There's really not a whole lot that they change. See, I like civil closing arguments. Let me tell you why I like civil closing arguments. I had trial Wednesday of this week. We'll talk about that later because there's a story from that trial I want to tell people. Because the story is so worth it. I learned a new trick. And the new trick is a new trial trick. And the trial trick resulted in the best cross-examination I've ever had in my entire life. Like the most ruthless cross-examination I've had for it was just an hour of cross, but it was annihilation. But I had a closing, and what I like about civil cases is you're closing in front of a judge largely. And when the judge is on the bench, the judge is very clear right off the bat. Some of them are, where you begin the closing argument, and then within about 2 minutes, the judge cut you off and said, so here's where I'm looking at this. Like, I'll let you finish your closing argument, but these are the issues that I have. And then you get to address the issues and raise the points and make the argument. And I like that because you get the verbal statement from the court telling you, I would like for you to navigate to these particular questions. Instead, with the jury, what you get is several faces looking back at you, and you have to speculate as to what questions they have that you need to answer. And the only way of going about it is trying to imagine the questions that you would have at the result after that trial and trying to close all those little gaps, which in this case, I think Cacciatore did a phenomenal job at. So you have to anticipate what the defense is going to bring in their closing, but you can't let that distract you from what you're going to bring in your closing argument. So we talked about this when we did opening statements in this case and how I thought William J., maybe didn't hit the mark with his opening statement because he was too much focused. He had too much focus on what the defense was going to say and didn't know what they were going to say at the time. He made his opening statement. We made the comment that he was kind of disjointed, all over the place, like he was raising an issue before it was an issue, and it seemed to have thrown him off his game. And that is when anticipation can turn into paralysis by analysis, and you then go ADHD brain, you're all over the place. You lose your narrative. Conversely, what Cacciatore did in his closing argument, I thought was remarkable. He knew the defense's claim was going to be the battered spouse, and he knew that he had an obligation, given the instruction, to have disprove self-defense beyond a reasonable doubt. So what do? You tackle the worst parts of your case head on, and you do it in a very straightforward manner, but you don't let that become the forefront of your case. You start with, this is what happened. Then, after you have clearly established what happened, you drive a stake through any argument that they have that what happened was self-defense. Then you ask the jury to give you what you want. So I thought he did a really good job at this. Torin, saw you in here. How you doing? Donate a silk tack-dye braid. The auction, phenomenal. Also, clean bill of health today. Way to go. Gonna upgrade dust collection to cartridge filter and celebrate. Torin, you let me know which cartridge filter you're getting because I need to upgrade the dust. Is Mischief still watching? I hope she's not in chat. Please don't be in chat. No one tell on me. I need to upgrade dust collection. I need to upgrade dust collection. I need to upgrade. I need a smaller system that has more power. Right now, my system is disjointed. I have fan motor with a bag filter, which is not. I mean, I got kids coming to that shop. I got to get a cartridge filter, and then I've got a secondary separator, but there's a disconnect between the two of them by about 6 or 7 feet. I have a tiny shop, so I need to get just one single unit and then pipe it. That's my ADHD brain. Sorry. That made me think, though. I wonder if anyone has a sale this weekend. Returning to the thought. But I'm glad to hear that you've got a clean bill of health, Torin. That's awesome. Great, great, great news. So let's go through some of this closing argument because I honestly thought Cacciatore for everything that, I mean, it was textbook. His closing argument was textbook. And the perfect amount of tone, pace. He did a good job. For my liking, oh no. Oh no. Did she hear that? Shit. Yeah. I thought you were asleep. Oh well. Dust collector. It's small, it's compact, it's not something that's going to, break the bank, and it's good. This is for the health of the children. It is for the health of the children. Listen to the people in the chat who are going to echo that actual sawdust contains carcinogens. And if you don't collect the dust at the point of the dust coming off the wood, then those carcinogens are in the air. And we don't want the children inhaling those things. So we need a higher powered dust collection system to capture that. Right? Got to protect the little lungs. That's what we're going to do. Now, it's Bath Company. I saw there's a lot of donations. We're going to be organizing those. I'm going to talk with Ian about how we're going to organize those. So, I've got a lot. I'm going to talk with Ian about how I'm going to organize those throughout the week and how we're going to get them sold. Because I know that there's also been some friendship bracelets that Mischief has made and that Mini Mischiefs have made that they are going to donate. And I have to figure out if I can get the lathe fired up, which might mean dust collector hooked up to the lathe fired up so that I can get some pens donated as well. So we shall see. We shall see indeed. See, everyone's agreeing with me. Everyone's agreeing with me. Safety first. Absolutely. Safety first. It's exactly what we do. So, closing arguments. Let's listen to Mr. Cacciatore because I think
You listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have open closing arguments.
First comment, first observation, great move. Pulling it out of the box. Everyone knows it's in there. The jury's sitting there and they're staring at the box going, it's in the box. It come out of the box, pulling it out of the box and not just placing it wheels up, but placing it laid down on the ground, just like the jury saw it in the video. So draw the connection immediately to the video on the ground. And we all remember the measurements of that thing, 28 inches by 20 inches by 8 inches deep. You know why? Because I will not forget that part of the testimony. I won't. Just the size of that suitcase and remembering the dimensions of that suitcase.
This is a box. This is the box where George Torres was killed. It's a small box, 28 by 20 by 8 7/8 inches. George Torres was zipped up in this box. George Torres took his last panicked breaths in this box. The medical examiner explained to us that with each breath George Torres took in, there was less oxygen in this box. George Torres was murdered in this box. Ladies and gentlemen, on behalf of myself, my trial partner.
Love it. I love it. It's a choice. It's a very unique style. It's a choice not to do the whole thank you for your service. Thank you for listening to us this entire time. Thank you for all of this. Because what was the last trial that we watched that didn't feel like there was any damn connection? You know, it was Karen Reed. Karen Reed, where Lolly gets up and Lolly goes through all of his remarks. And did you feel anything? Did you feel like he felt anything? Did you feel like there was any mention of John O'Keefe during that trial? Like in a serious, in a very serious fashion, in a somber fashion, right? It felt like we had lost the mark. Yes, the defendant is the person that is on trial. That's the person from whom you're seeking accountability. But the focus needs to be, first and foremost, in my opinion, I like this style. Remind the jury of the gravity of the situation. So basically, standing there, and the first thing that he does isn't to do the whole recitation of thank you for your service and the time being here. It is to force the jury's attention directly on the victim. The last breaths, and then bring it right in the testimony. The medical examiner explaining how every breath that was taken, there was less and less oxygen in that space for him to use. Calling it a box. Later on, he goes in straight attack mode, calls it a makeshift coffin. But it was a great tactic. So punchline, then go bring him in and say, thank you for everything you've done, for being here on behalf of myself, the state of Florida.
We thank you for your time and attention in this most important of trials. We now have the law
because it is
from the judge in this case. This is what our duty is to follow. And let's have a discussion regarding that law that we've just been read and given. The first section of note we're going to come to is called Introduction to Homicide. But this being a legal document, written by a bunch of lawyers who you've seen for the last 2 weeks arguing with each other. Pay careful attention to ands and ors. Remember, if an and is somewhere, we're going to need both things or all the things, and if an or is there, then only one of those things we're going to need.
Does this sound juvenile? Does it sound very minimized? Absolutely it does. Is it really effing important? Yes. And did I appreciate the fact that they went back and they went back and the first thing
Ambush.
he starts with is pay attention to this statute and the ands and ors, because there's a difference between an and an or, and there's not enough attorneys who focus on that damn argument of you don't need both, you just need one, or you need all of them, right? It's important to go back and do that. What?
I think a lot of lawyers make a tremendous mistake on that, just as you mentioned, because if you only need one of those things, then tell the jury you only need one of those things, because it's an easy way to get an accidental bad verdict. And I mean, you want to focus on that more if you're the side who benefits from it. Because like, if you're the side who, who needs all the things to prove your side, then you're like, we'll just ignore that. But if you're the side that only needs one thing, then absolutely hammer on it. So also,
and you also have to appreciate the use of not just the use of props, but the use of multiple forums. Like, so you use different forms of media, right? So you use actual written words on a screen. When you have it up there, you have some jurors who are connecting with the reading, and then you have other jurors that are listening to what you're saying.
I don't necessarily like that because what's his dude Owens has some props, and Owens manages to fumble his way through everything, and to absolutely suck at it. You've seen Owens's clothes, right?
I saw the beginning of the close, and
Rob,
I know. But I need to see it. I need to understand it. I need to see how bad it was. I saw the beginning of it, and it started bad with the multiple improper arguments.
Rob, I have a question for you.
Yes.
Let's say that you lift the garbage out of the trash in your kitchen.
Yeah.
And you know the liquid that sometimes the bag leaks out and leaves in the bottom of the garbage can?
Got a better one for you. Yeah, go.
Are you like, I need to know how this tastes, or can you just be like, no, I'm good. I don't like, that's a thing I could just take your word for. Because that's kind of what this one is like.
I take your word for it. That's the thing. Like this, I don't. So one of the kids this past week, I'm convinced it was fucking intentional. I'm convinced it was intentional. Their bathroom, there's clogged the toilet. Well, who in this household cleans clogged toilets?
I'm guessing it's the guy wearing the hat.
And it was so clogged that it felt intentional, to the point where there was no other way of getting it unclogged than to go in there, shirt up over the face, and just is that Owens' clothes? Like when you're just using the plunger so aggressively that it's like splashing and not pleasant. That's the clothes.
There's a point where he says, "I don't know what to say."
Cool.
There's a point where he says, "This is in my notes somewhere," shuffles papers for a bit, and then goes,
"Oh, I saw that part. I saw that part. Yeah."
There's several points where there's a point where he says, "The prosecution says X," and the prosecution objects and is like, "I didn't actually say that." And then on the prosecution's like, second close. Like we've had close, we get second close because the prosecution gets the rebuttal there. They're like, now I'm going to say X. That thing I objected to because I hadn't said it yet. Now I'm going to say it.
Okay, now I need to see it. Now I need to see this. So I thought Cacciatore did a good job because
he did a great job.
It was very organized. And this is your textbook close, right? Combination of law, facts, you go back and forth and you try to apply the facts when the law is on the screen. So you bring the law on the screen and then you go back and you say, what facts did you apply to that specific law? So then he brings up the video.
Also, for the people saying the bots, we'll do the bots when we've got full screen, not part screen.
For everything you've done to me. Shallow. For everything you've done to me. Shallow. Fuck you. Shallow. Fuck you. Shallow. Stupid. Shallow. That's my name. Don't wear it out. I can't fucking believe it. Seriously. Yeah, that's when you do when you choke me. Shallow.
And I just saw somebody in the chat mention that I'd missed a question from them, so I am finding that question. It was in my spam, and I'm answering it.
So here's the disruption. Part of family leaving, which I get.
Oh, I get the family leaving.
Yeah.
I don't know what happened because they kind of cut it out.
Did you hear? But you heard the argument after this, right?
I heard the argument afterwards, and honestly, I wouldn't have made the argument.
No.
What I might have done is I might have gone in and said, Your Honor, I just appreciate if there could be an instruction to the jury to disregard that.
A curative or something that just recognizes that certain things happen in the gallery, but that people are supposed to keep their cool and.
Yep, and maybe a direction to the rest of the gallery. But yeah, apparently I'm seeing the chat saying mom broke down sobbing. No shit. Why wouldn't you break down sobbing seeing your child's last moments of begging for his life?
And hearing that that's my name, don't wear it out.
Yeah. I made this comment on Twitter, but I'll make it here as well. The good news is that people aren't going to wear out her name anymore.
I know.
Because she's going to be referred to by inmate number.
The rest. Yeah. Yeah.
Yeah, I think Owens trying to go for the Owens, like, it was the first moment that I thought Owens was like actively playing dirty. As opposed to just do it. Like, you got to do the best for your client. And you know what? If he'd gone up and he'd said, I need a mistrial because that was prejudicial, I would have thought it was a bullshit argument, but I would have been like, okay, fine. You know, every defense lawyer has had to make a bullshit argument at some point in their life, right?
Yeah, but he comes in fire and brimstone.
He comes in, not only says that, but he basically
accuses the prosecution.
I see somebody saying I'm a bit loud, so I've turned myself down a bit. He accuses the prosecution of being in on it. Yep. And if I was the prosecution, I would have been like, I'm asking you to reject this argument, and I'm asking for, a gentle sanction. I would suggest in the amount of $500 for the implication.
It should have just been like, that can't happen again. But we'll get to it real quick.
Yeah, I mean, just the suggestion that the prosecution engaged in that kind of misconduct without a single iota of evidence?
He did that a lot, and it kind of started pissing me off about the accusation of misconduct. There are prosecutors that you can throw that shit at. I don't know that William J. is the one that I would do that with. I think that they've been kind of playing above board for most of this. There's been some stuff that I've been kind of pissed at, but
I would
for the most
never
part-
pull that unless I had the receipts.
Yeah.
And if I have the receipts for that, I'm like, Your Honor, we're going to need a day. We're going to need a day because I have to go to war on this shit. So, yeah.
So, but they do, the family leaves and we get the video, it comes back.
Did the family leave of their own volition or were they asked to leave?
I think the prosecutor probably turned around and asked him to leave.
Yeah.
I think the defense drew the attention to it.
You may continue.
Yeah, I don't like that.
Sarah. Sarah. Sarah, I can't breathe it. That's on you. Sarah, I can't
Oh,
breathe.
fuck.
It's on you. Sarah. Real ransom. Now you want to give it for it extra. Because I got it. Sarah. Real
Oh, that laugh.
Sarah, I can't breathe it. Oh. That's what I feel like when you drink on me. Sarah. Fuck you. Sarah. Yeah. You should probably shut the fuck up.
Yeah.
I'm glad she's going to have a long time to think about that.
I know. That was the perfect time for him to use that video as a springboard. So the jury now hears probably the most damning evidence against Sarah Boone in that moment, right then. And now, because the defense is going to focus on that exact moment. And the defense is going to say, this is when this overt act and the past abuse all came back up. So what does Cacciatore do? I think the best damn thing, which is to bring out the best evidence the defense has and just fucking shred it right in front of them. I mean, this was effective. Didn't you think this use here with the blown up photos?
Oh, they go to war with the defense position. And the one thing I didn't kind of like is that they were able to bring a new theory in at the last possible second where there's just no way for the defense to respond to it. And where I am, that would get a jury instruction to exclude it and quite possibly a mistrial. Because they're supposed to present those theories to the accused.
Mm-hmm.
It would quite likely get a mistrial. That said, I was like, I'm glad it finally got argued, but they should have brought it in when Sarah was on the stand.
Which one?
The theory of you don't have to believe her story.
Oh, you mean attacking her credibility?
Well, attacking, basically saying it's entirely possible her story is completely bullshit, right?
Oh, because you take into account who's been in the courtroom and who's heard all the stuff that's going on today, and
and just the fact that when I heard the story, I was like, it seems far more likely that in fact she hit him with the bat and ordered him into the suitcase, not this this hide and seek thing is
that was
a little stupid.
Brought up later, yeah.
And he's like, you don't have to believe her hide and seek story, and I'm like, you should really have told her that.
But that one I didn't hear. Wasn't that in rebuttal close like that? I didn't hear that one yet. See, I
it's
didn't
in
hear
rebuttal
that one yet.
close. Okay.
Was the door open on that by Owens?
No, like it was never mentioned up until like the last possible minute of the last possible time. And like Owens doesn't even get to respond to it because it's rebuttal close, right? It's the last thing. I was like, here where I am, that'd be a mistrial, right? Because that'd just be like, sorry, you don't get to bring in a new theory. Sorry, I'm doing a little bit of organizing at the same time.
It's fine. The suggestion was there, though. I'll say the suggestion was there because there was the argument being made about the bat and the suitcase. And even when the evidence was coming in at the first glance, I'm sitting here going, the way the evidence is being presented by Jay at the time, there's no way that the injuries to his face occurred through that suitcase.
Yeah, I don't know. It felt a little like that should have been presented a little more like to her to give her a chance. Here, the rule is called the rule in Brown and Dunn. You have to present your theory to the person and you have to spell it out. Like you have to be like this. And sometimes that means you have to go, I suggest to you that you hit him in the face before he got in the thing. I suggest to you that.
I don't think you have to do that. I think that once,
I
think
it's
that,
a
I think
different,
that Jay,
it's a very different
standard.
Like it's a different standard. We do things differently. I'm noting that that's the case here in Canada. And so when I saw that, I was like, what the hell? And I looked it up and I'm like, no, that's fine for where they are. So
see, for me, he did that when he presented the suitcase and the injuries and the baseball bat. Like when he presented the baseball bat, I was going, why are we talking about the bat? And when the ME testified to the physical injuries, I was going, why are there injuries to the face?
And they'd actually have to, like here, they'd actually have to confront her with the different theory and not just sort of tiptoe around it. They'd have to actually present that theory to her to let her respond to it. So it's, again, it's a different thing. But when I was watching it, I was like, is that okay? Are they allowed to do that? And then I was like, oh, turns out they are. So that I was just like, I still would have liked to hear her response to that. Like to hear what she would have said, you know, if they say, hey, these injuries clearly don't match. Would she have said like, or would she have said, like, would she have had a good answer for that? I don't know. And we just don't get to know because we don't get to hear her answer. So, yeah.
Dude, Cacciatore's strongest bit then towards the end because he ends with a bang. He does well.
I mean, he begins with a bang, he ends with a bang. It's all banging.
It was
phrasing.
Choose your words, friend. Choose your words.
I made my choice and I stand by it, even if it was the wrong choice.
There.
Scintilla of doubt about the depravity of the defendant's actions.
You gotta love the prosecutor point, man. Every trial, the prosecutor point, it's always so spot on. You think they practice it in the mirror? Like the angry stare and the point?
I mean, he just did really well on this one. He had a good close. The opening for the prosecution wasn't that fantastic. But the close was good. I didn't have any complaints about his close, and I was glad that they were finally able to just say, like, I was waiting all trial for them to be like, her story is bullshit.
Bullshit. Yep.
Like, because what I believe after watching that whole trial was, you know, you see that video where he's like in the fetal position and you know, she's yelling at him.
Yes. And
I believe something like that went down and that she's holding the bat, that she's hitting him with the bat, and that she tells him, get in the suitcase. Get in the fucking suitcase. And then he gets in the suitcase and she zips him up and then he's begging to get out. And I think it's after she tells him to get in the suitcase that she starts video recording. And that's, you know, that's my, like, if you asked me to say what happened here, that's what I'd say happened here.
Yep.
So, you know, not this hide and seek bullshit story. That hide and seek story to me makes no fucking sense whatsoever. So, like, you know, do I believe it? No. It just, but I mean, I do think she would have walked if she hadn't videotaped everything and talked to the cops.
Wouldn't have been an easy conviction.
I think it would. I think it would have been an easy defense. I think it would have been an easy case to defend if it wasn't for that.
Yeah, it was the conversation. It was the talk of the cops. That's what the entire thing was. Talk of the cops.
And video recording all of this shit, right?
And video recording all this shit. The video that was the game changer for me was I'll find it. I'll play it. But let me listen to Cacciatore's. Let's get through his first.
Fair.
We know from the evidence that this was not the first time she had considered killing George Torres. We know from the evidence that on January 13th, 2020,
It's the first time it's done this. What the hell? Come on. No, it's probably because I have 3 videos.
approximately 1 month
It's probably me.
prior to George Torres's murder, the defendant had a text message conversation. Please do something with yourself, Sarah. God bless you.
All right, this is a weak argument. This was a dumb one. This I didn't buy this. This one was like, I'll be rid of you, Torres, blah blah blah. That she was planning his murder at that point in time. I think that was a stretch. That was a stretch. Like you have the case locked tight.
Don't make weak arguments. That's the other thing I tell young lawyers is if you've got good arguments, and he does, stick to the good arguments. Don't make the weak ones. So, yeah.
And all
next part.
The law actually specifically tells us that the intent to cause death is not necessary. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. We turn this as well.
Come on, give me your props.
Commit any crime as
Oh, that was smart too. The
admissions to drinking, to her voice.
Here we go.
This great bodily harm to herself. Sarah Boone had no duty to retreat. Ladies and gentlemen, in a few moments, Mr. Owens will rise.
This is how you attack the other side's argument. You don't do it the way Will J did in his opening statement. You don't go in this convoluted, like, maybe you're going to hear this. You might hear this evidence. You might not hear this evidence, but maybe you shouldn't listen to it until you possibly hear it. You don't do that. When you attack the other side's argument, you do it like this. You say, in a few minutes, you're going to hear them get up, and they're going to say this.
You know what else? That's objectionable here.
Really? No. Yeah?
Yep. I'd stand up and say, I'm entitled to make my argument.
Oh, see, but I think that this was a very effective use. This was such a
I mean, it's super effective. That's why you're not allowed to do it.
He was. But I think you can attack I mean, I like it because you can attack the defense's argument. You have the chance.
You can do it in certain ways. You can say something like, you may hear or you may be thinking that, you may be thinking that X. Well, I will tell you that, not X, right? That is sort of how you get around that. But what you can't say is you can't say, my friend is going to stand up and argue. And it's like, objection. I get to make
that's
my
bad.
argument.
I love doing that. It's my favorite move. My friend
Yeah,
on the other
it's.
side.
I'm just like, nope. You got to let me make my argument. Sorry.
Well, this was annihilation. This was destruction.
I mean,
this was what I did in court this week to a poor person. Like
he stands. I mean, the other side stands up and just doesn't know what to do. Right.
Where's this? Unknown. I'm a domestic relations litigation attorney. So basically, I'm a divorce lawyer, not just divorce, but domestic abuse situations, all of the above. And I'm a trial attorney. I've been doing this for 14 years.
So, related field of law and not at, and you've been at this for like a hot minute.
Yeah, just a bit.
To answer the implied questions there.
To answer the question, yeah, I had trial this week, the week before, the week before that, the week before that. Like, yeah, I do this a lot.
Yeah, Rob ain't sitting here faking it. How about that?
With very sensitive topics.
Yeah.
He's going to show you this.
I love how dismissive he is too. He doesn't give the photos even a second glance. He just holds it up. He's going to show you this, show you this.
And this.
Oh, it is.
Is he using the defense's exhibits or?
Yeah, the exhibits they had at trial.
Nice.
And he's going to talk in this as well about the list of grievances that Sarah Boone had for George Torres. He's going to talk to you about curtain rods.
So dismissive.
He's going to talk to you about black eyes.
Just drops them.
He's like, but she killed him.
About what an awful, awful boyfriend George Torres was. And ladies and gentlemen, at the end of all of that, it still will not change the fact
This part.
that the defendant is not entitled to the justifiable use of deadly force. Because as we continue to read this instruction, it tells us in deciding whether Sarah Boone was justified in using the use of deadly force, you must consider the circumstances at the time the force or the threat of force was used. Danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed that deadly force was necessary. Moreover, to justify the use of deadly force, and this is important, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Ladies and gentlemen, no.
Side note, did they teach this to you in law school? Because they taught it to us. They taught it to us in law school. It's the lazy man's ability to keep your hands out of your pockets.
Oh, the steepling the fingers?
The steepling of the fingers or the
Yep.
crossing of the hands. The lazy
Yep.
man's.
Also, the grabbing of the podium.
Yep.
Grabbing
Keep
the
your hands out of your
podium is a solid one.
Yep. And you just develop as a go-to. It's a go-to. Every lawyer has their own tick, whether it's the way they hold the pen or the way that they steeple their hands or the way they cross their
I know one lawyer whose work suits all have the pockets sewn shut.
So he can't put his so he can't put them in there.
Yep.
Solid move.
He did that on purpose because he's just like, I tried all the tricks and my hands always found their way into my pockets. So he just, when he gets a suit, he's like, I need these sewn shut. And they're like, why? And yeah, because he's like, you know, and guys, if you're wondering why you can't put your hands in your pocket while you're doing this, it's because it looks like you're playing with yourself.
It's also just lazy, disrespectful.
Yeah, but the big thing is you don't want to look like you're handling the jewels while you're delivering your clothes. And I told one young lawyer who like was sitting there, he was doing a bail hearing. He was an articling student doing a bail hearing. You're entitled to do bail hearings. He was sitting there playing with coins in his pocket. And he's like, how'd I do? And I was like, you did great, other than the fact that it looked like you were jerking yourself that entire time. And he's like, what? And I'm like, your arguments, fantastic. Hands out the fucking pockets. You know, because he's got one hand who's gesturing, and the other hand is like working up and down as he's playing with these coins. And I'm just like, and he's like, do you think the judge saw it? I'm like, the judge couldn't look at anything else. The judge, I saw the judge looking, and then looking at the rest of the lawyers like, do you see this shit? And he's like, but I won. I'm like, yeah, I'm going to tell you that there's some other judges that would have called you out on it and would have interrupted you. Learn the lesson now. And he's like, and I'm like, this is like, consider this your freebie. So, yeah, it's not a thing you want to do ever for any reason. So, yeah.
So we learned a thing. I just think it's appropriate.
Keep your hands out your pockets.
Keep your hands out the pockets. So we started with something that was like, hey, did they teach you how to do this in law school? And then we ended up with, because you might look like you're jerking off.
And the thing is it really can.
Well,
and you know, you've been practicing this for however long. This might be the career, like this might be the case that makes your career, especially if you're
want to do. Yeah, exactly.
Can you imagine you're in like a big case like this and you end up like on TikTok with all the people focusing on the exact moment you're jingling your hands around in your pockets?
Absolutely not. No.
Like,
I would just deceased. No way.
Young lawyers, if you have this habit, you need to break yourself of this habit through any means, including like if you have to chop your arms off at the elbow, because like
I like the sewing the pocket shut though. That's pretty solid.
I feel like that one is a little less in depth than the chop off the arms at the elbow, but whatever you got to do, right?
You know, we started making the point, but then we drove it home. It got driven home, Ian. Son of a bitch. All right, let Mr. Cacciatore finish.
A reasonably prudent and cautious person would believe that a man who could barely fit into this box, who was incapable of movement, who was begging for his life, who was slowly asphyxiating, suffocating with each breath, would have needed to use deadly force against him. The justifiable use of deadly force utterly fails, utterly crashes like a house of cards.
Yeah,
There's
baby.
more.
But wait, there's more.
However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke threatened use of force against herself. Let's stop there before we consider the next two paragraphs. Some of the most critical testimony in this trial is her testimony on the stand. It was a great day. We were doing puzzles and artwork, dancing with the dogs, listening to music. Tag, you're it, hide and go seek time. George gets into the suitcase. She comes and zips him up. But we're still laughing about it. We're still laughing after he's zipped up in the suitcase. And then that's when George had the temerity to ask, George Torres had the temerity to ask to be unzipped from the suitcase. And that's when Sarah Boone decided he needed to stop her. She was the initial aggressor, ladies and gentlemen. She provoked the use of force in this case. In her own words, we were laughing and playing right before he wanted to be let out because he couldn't breathe. Paragraph 1. The threat of force
The jury's like, stop, we're already convicted.
asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of language
She's yelling.
that it requires a in this box,
This one.
slowly being killed.
Rewind that a little bit because this is where he starts. He's making his final point here.
Now,
No, not his final point. He gets to some other points
the
later.
life is draining from George Torres, and it's evident in that video. And that, ladies and gentlemen, is evidence that there was no threat in the magic 9 minutes that was not recorded.
The
There
magic
was
9
only
minutes.
George Torres in this box, slowly being killed.
I'm just gonna say I wouldn't want to go up against this prosecutor. He's showing his
He was better at this one. I mean, I love this one. It was good.
yeah, no,
Magic
this one
9 minutes. My favorite line, imaginary doubt.
Next,
yeah.
we
Oh,
come
that was good.
to weighing the evidence.
Yeah, this part.
This instruction tells us it is up to you to decide what evidence is
Hi,
reliable.
Melly.
You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider. Did the witness have an opportunity to see and know the things about which the witness testified? In focusing on the
I hate
defendant,
that one because it's always
Absolutely.
the defendant. That one just
Yeah, it's
that one's
always
basically just the accused is less believable than any other witness inherently
Always.
because they've been charged. Like,
and it's not
in-
really fair. But I will say
in
he
Canada-
doesn't use it. He doesn't use it in an unfair manner, though.
in
Not
Canada,
here.
a recent court case has said that that is an improper credibility assessment.
Really?
Yep.
I don't
Because
think he
they've-
uses it in an improper purpose for improper way here. Because what he does is he doesn't actually go to. He doesn't go to how her changing her story here. He goes to the prior inconsistent statement she's already made. He goes
The
to
thing
all
is,
the different statements.
He does connect it to her.
Yeah.
And in Canada, they basically said this is a use of your protected rights against you because you have a right to see the file. And so therefore it's improper because it's basically just saying the accused is less worthy of belief because of that. The other one that they've said is a problem or can't be used is self-serving statement, because the accused saying I didn't do it is always inherently self-serving in that the accused doesn't want to go to jail. And it's like the fact that the accused is denying the crime can't be used as a reason to find them less believable.
Yeah.
And so, yeah.
two people walk through the front door on the evening of February 23rd, 2020 at 4748 France Court. George Torres and Sarah Boone. But only Sarah Boone ever walked out of that front door alive. Did the witness seem to have an accurate memory? This is an emphatic no. And the litany of her intoxication in versions of events is evidence of that. Was the witness honest and straightforward in answering the attorney's questions? I would submit to you she wasn't. Or did the witness have some interest in how the case should be decided? Clearly. Does the witness's testimony agree?
Yeah, I mean, that one always goes against the, you know.
I would say largely no. Because on the issue of whether or not George Torres could have threatened her the way she says that he did, the answer is clearly no, and we know that from the forensic data. We know that from the items itself. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? In regards to the defendant.
Gee, counselor, it seems like your voice inflection changed a bit. Would you like us to focus on that part a little bit more than your other parts?
Yeah, well, on the one part, he just sort of addresses with, I submit to you, yes. And then he moves on. It's like, okay, you're just skimming right over that then. Skim.
This
like,
one, he's like, did the witness have like, oh, huh, you would like me to pay
this one he's
attention
like,
now.
Yeah, sit up, everyone. Now is the time for me to, like, I'm about to do some dunking, and I would like you to observe the dunking. Please observe the dunking, because there will be such dunking as you have never seen before. So,
Also,
yeah.
what is this? Does this dude just lift cattle in his spare time? Look at the arms on this guy.
He
just...
You know, most lawyers like drag around their exhibits and so forth in a, in a little wheelie box that they load into his car.
What, he drags around the other lawyers?
He does the same thing. It's just he then, after he puts the wheelie box in his car, he lifts up the car and takes it to the courthouse. He's like, I save so much money on gas this way.
Like, sir, I get it. Like, we all see the muscles.
It's almost more appropriate to ask about the time she did make a consistent statement. You listen to her version of events.
I'm just going to say, this guy could have gotten himself out of that suitcase. He would have just flexed and the suitcase would have burst open.
Let me put it this way.
You hear her.
This dude's arm wouldn't fit in the suitcase.
I would have, like, if they put him in the suitcase, he would have just flexed and it would have just been like suitcase rips open like you know, like the Hulk shirt. Yeah, I don't see him like that's not going to be his cause of death of like suitcase.
Just watching the seams on the suit jacket barely held down. Especially when he does the flexing and the pointing.
Yeah, I feel like the seams on his jacket are having as much trouble holding together as the defense's case.
Or Sarah Boone's stories.
So, yeah.
And for next interview the next day with Detective Cacciatore and Detective Lowen, and more details come out. Things change. First, she was never intoxicated. Then she was intoxicated. Then there's just the whole fact of she omits the fact of, oh yeah, he was actually trying to attack me. Oh yeah, I was in fear for my life. When she said at every turn, no, it was just a great day. We were having fun. Oh my God, I can't believe this. We were doing good. The only stress we had was about jobs. And now, 4.5 years after the fact, it's time to come up with a new story. But ladies and gentlemen, I submit to you that the truth does not change.
I didn't like the I submit to you because
The
you don't have
facts
to
do not
submit
change.
to the...
No, that's his crutch. That's his crime. That is his what if anything. Like, I submit to you.
And the thing is we end up using it in Canada a lot because, you make submissions and whatever, but you never put it in a jury anything. Like, no. Because the jury doesn't hear that as like, I am making a legal submission. They hear that as like a BDSM thing. And probably most of them are not.
You know what? Some of the jurors might want to hear that from him. I don't know. I don't know if anyone was thirsty in the courtroom. I don't know. But yeah, it just is so.
It's
what
weird
human talks that way.
Yeah. And you're right. If a juror was thirsty enough, they might call him later and be like, "So,
you were promising, sir. Promises, Mr. Prosecutor."
Yeah, was that an offer? Because, yes, please.
Is it wrong to want to hug this judge? No, I imagine that
No, this
several
judge
of the
is like-
jurors. This judge is awesome.
This judge is one of my favorite judges of all time. I put Judge A slightly higher, and that's only slightly.
Wait, hang on. Emily, we're talking about the prosecutor with the strong arms that carries vehicles saying that he submits to the jury.
I submit to you.
You should choose a different turn of phrase. Just, a thought.
The videos do not change. And on any version of events that the defendant has given, they all add up to the fact that there is absolutely no doubt that she is guilty of murder.
Where's the reasonable doubt? I want to hear the reasonable doubt. That was my favorite part.
I ask you, ladies and gentlemen, do you have any doubt about the defendant's guilt? When she described using that baseball bat
nice
to hit
Also,
George
congrats on
Torres's
100K, Emily.
fingers back in the suitcase when he attempted to save his life. Do you have any doubt when she is given
Congrats on the
how many
800K.
versions
Yeah.
of events in this case? Do you have any doubt after hearing the testimony of her neighbors about the loud crash and arguing that night? Do you have any doubt after hearing the testimony of Dr. Sarah Zadovich? Do you have any doubt after watching the videos of George Torres being murdered and her laughing about it and talking
He's
about
like,
the fact that he
if y'all
cheated
have
on
doubts,
her?
you're dumb.
This was so good. This was so good. And this it's pointing to it's taking and this is what good prosecutors do. They take that burden, the burden of beyond a reasonable doubt, and they take it on, and they don't just shy away from it. They say, I'm not only telling you don't have a reasonable doubt, I'm telling you have no doubt.
Oh, I mean, the prosecutors will come in and they'll be like, I've seen prosecutors do ladies and gentlemen of the jury, I have a tough burden today. I have to prove this case to you beyond a reasonable doubt. And I submit to you, I have, and, if we're going to use that language, and I have today, and here's how, let's go through it. And I've also seen prosecutors say, if at the end of seeing all of that evidence, you don't believe that this person is guilty beyond a reasonable doubt, you need to acquit.
No,
but
this
you should
dude doesn't
absolutely
just
be there.
do it, though.
Oh,
But
he
this
leans
dude,
into it hard.
He doesn't just he goes straight at it, and he just says, he goes, look, if you're gonna have a doubt, fine, you acquit, but you don't have. He said, how many times does he say doubt? He's got to be 40 times
and
during his
he
closing argument.
Starts talking about imaginary doubt and mythical doubt and Fraggle
Forced
Rock
doubt.
doubt and forced doubt.
This one was kind of the prosecutor. This is the prosecutor looking at the jury saying, I dare you to acquit. I dare you on these facts to acquit. You can't.
Yeah.
Do you have any doubt after reading the text messages from her phone, after seeing the videos of how she controlled and manipulated George Torres? And if you say, Mr.
This
Cacciatore,
part.
I still
Yes.
have a doubt.
Yes, right here.
Well, then the law asks you, is that doubt to an element? And is that doubt a mere possible doubt, a speculative, an imaginary, or a forced doubt? I submit to you, the idea that she had to do this because she was a battered spouse is an imaginary doubt. It's a doubt born from the imagination of Sarah Boone. It is not.
My God, that was you want a punchline, you want a one-liner. Yeah, baby. Way to go.
I mean, I feel like he can get away with it in this case because this case is kind of, he just needs to walk the ball over the plate and then just be like, see, ball is over the plate. But I kind of felt like this one could come off as like, ladies and gentlemen of the jury, if you still have doubt, y'all dumb. And that might not win people over if they were in doubt mode. But I don't think
the way he does it, like even the delivery, like
I
yes,
just
the
think
prosecutors love the pointing, but this was good.
I just think he's walking into a situation where there's literally nothing he could say wrong. Like he could get in there and just be like, I said Fraggle Rock earlier. He could get in there and just like sing the Fraggle Rock theme song and then be like, oh yeah, and you should also convict Sarah Boone. Like,
Mini Mischief 2 is terrified of Fraggle Rock, like terrified, like has night terrors over Fraggle Rock. Like I can't bring him near Fraggles.
Okay, I will move on because let's go with the Ghostbusters theme then.
That one, so much better. Yeah, that.
Like just come in and be like, who you gonna call? Ghostbusters. Also convict Sarah Boone. And he'd still have won this case. Like
he probably would have.
It's rare that you have a case that is just that like clear. So I mean, he's kind of spiking the football a little wee bit, but yeah,
it's worthwhile. I mean, spiking the football gets you an 1.5-hour verdict.
You know what that verdict? Why it was an 1.5 hours?
Because they had to go back and they didn't want to waste their dinner.
Yeah, they're sitting there at the back going, if we come out right now, are they going to let us come in or come back here and finish dinner? And it's like, I don't know. Okay, we better finish dinner, and then we can just talk about like how dumb. They're going to want to talk about how dumb the case was for a little while. And then they'll be like, okay, let's go home. Our families miss us. So
I thought this was the great way to end the close. Great way to end the close. And you know what? Could you imagine if Owens wasn't smart enough to ask for a break right here and Owens had to get up and follow this?
I mean, Owens has not been a paragon of intelligence, but he does make the right move here.
Yeah. Which is like, no, I want them to go quickly so that I can get a break. We need a break between.
Yeah.
He
needed
the idea that she had to do
Here's the imaginary doubt, and then we're going to watch
this because she was a battered spouse is an imaginary doubt. It's a doubt born from the imagination of Sarah Boone. It is not a reasonable doubt. But if you find yourself back in that deliberation room and you are just trying to think of some way in which,
and if you were asking, this is not my beautiful spouse.
Searching
this is not
for that way. That also is not a reasonable doubt, ladies and gentlemen. That is a forced doubt. Ladies and gentlemen, I'm confident that when you read the entirety of those jury instructions and apply the law to the facts that came out in this case, that you are going to come back with the only lawful verdict, which is guilty as charged, second-degree murder. Thank you.
So I just got to ask, do you think he bet his colleagues back at the office as to how long the verdict would take?
I don't know, because if he did, I mean, he's putting some money on it, and he came in swinging, so he wanted to win that bet.
I mean, my over/under on that one was an hour, so I guess we hit the over. But
I was pretty confident we'd have a verdict before I started, So I was a little bit, but again, it went to the jury later than I thought it would. It didn't get to the jury till like 6:30.
Yeah, I was like,
7.
Yeah.
All right, I'm not going to listen to Owens bitch about this. I am going to listen to the beginning of Owens' opening because
Oh, we
my
should listen to
God.
Owen complain about the thing because that
Really?
Yes, absolutely. We should dunk on Owens for being an idiot there.
Okay.
It's like, Judge, this is my last chance to piss you off. So I'm not going to miss that opportunity.
Oh, he doesn't. He steps in it like hard.
And, you know, I'm on national television. Now is the real good time to make a frivolous application because it is frivolous. Like if he just said, I would ask the jury be told not to consider the outburst and, you know, if the gallery could be warned and, you know, so forth. I wouldn't have an issue with it. But he's like, I just want to tell the world that this is the choice I made because everybody watching and everybody has opinions now. And
yeah, you pissed Jay off. You being pissed. You want to get a spicy prosecutor, you pull something like this.
I mean, if it was done tactically to piss the prosecutor off, okay, cool. But it doesn't work for him. Like if it was a tactical decision, it was a bad tactical move.
Yes, bad move. That's bad move.
Like, yeah, okay. You tell me it's, you know, maybe if you're saying it's a tactical move, it's like, okay, you have just decided to invade Russia at the peak of winter, and you are not outfitting your soldiers with a single jacket. Everybody's going in like shorts and a t-shirt, or just like unisex bikinis, and you're just going to invade Russia in winter. And
or you broke into a house in Appalachia and expected not to get shot. Yeah, that. Like it was, you made a decision. It just wasn't the right one. So
yeah, I saw somebody in the chat says, my decision was calculated, but I am very bad at math.
We are back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
Dave Kesher on behalf of the state. Jay for Florida, State Florida. James Owens for Sarah Boone.
We have Sarah Boone.
Tony Henderson, Sarah Boone. Ms. Boone is still seated at counsel's table wearing the same clothing from this morning. Are we ready to bring in our jury for the defense closing at this time? State.
Yes,
Defense.
Judge, I would like you to give the audience an instruction, and then if
oh no, we missed
would
it.
instruct the state attorney to instruct whatever family members or friends, George Torres, may not be in.
This one. This was the request for instruction. So what Owens did the second go round was the right thing to do. That should have been the first go round.
It should have been the only go round.
Yeah. As in, Judge, I'd like you to instruct the members of the gallery. I understand there's things going on. Like, do this. Owens.
Yeah. Like, hey, Judge, we had a little outburst before. I understand why it happened. I just really don't want it to happen again in front of the jury. Can we give a little instruction poo and, you know, move right along? So, yeah. Mardo, that was definitely a bot.
Yeah.
That was Nightbot. Nightbot. Yeah. That was definitely
my
a bot.
Nightbot is nice. Emily's Nightbot is not nice. Ian's Nightbot is called Fightbot.
Yes, my Fightbot has opinions. The default programming on Nightbot comes in salty. And I was like, hell with that. I'm just leaning into this. I'm just going to call it Fightbot. Because, yeah.
This was a decision.
I put a Mr. Torg quote into my Nightbot.
Okay, may proceed.
Sarah Boone's entitled to a fair trial. I think that right's been compromised here today. I don't know who scheduled who scheduled on the front row with the Torres family, the family of the victim. But they had to have known to tell them that the suitcase video, which has been around for 4.5 years, was going to be played during opening statement.
Yeah, and you know what?
Office or the sheriff's department had to advise them, or the victim's advocate had to advise them.
And it might still make you cry.
in front of a jury that's trying to decide the case, they needed to get out of the courtroom.
And, oh, can we
Now,
pause?
what happened here today?
Yes, you may scream.
You know, you can be absolutely confident that you're gonna be okay in the moment. And then it might just turn out that when you see the dying moments of your son, that your confidence about how stoic you can be turns out to be misplaced. Because as it turns out, that's a hard thing to watch. And buddy, there is a way to make this argument that doesn't make you, blah, I just ate a whole bunch of hair, that doesn't make you look like you are a total jackhole. And you chose to make it the other way. And it was a choice. And I resent your choices because they are the choices of a total jackhole, which I believe I just said. So, like, why would you choose to say, like, how dare they be overcome? Because you see that he's sort of subtly blaming them about, like, they had to know that if they couldn't keep that. I'm like, oh, sir, you need to, like, you're at an 11. We need you at like a 3 on this one. This is the kind of thing you come at. Like, this is not where you come out swinging dong, sir. This is where you come in saying a thing happened and we understand why it happened. We're just really asking that it not happen again because it is bad. And the court understands that it's bad and everyone understands that it's bad. And, you know, and the thing is if he'd done that, he would have gotten a, you know, a very polite jury instruction saying, you may have seen a thing, please disregard the thing, right? It's not, and that's all he was ever going to get. Like, he was never going to get, you know, a pony and a rocket ship and a Red Ryder BB gun, which is what he comes in asking for. So just, you know, don't ask for stupid things because you're not going to get them. And do it in a way that doesn't make you come off like Sir Douchington of what the fuck ya. Like, it pissed me right off and I wanted to rant. And I appreciate that you allow me to rant.
Feel better? Does it feel better?
No, because it isn't accompanied with violence. And this one really feels like it should be accompanied by violence. And I'm not allowed to violence, at least not, you know, not since the incident. So, yeah.
This is spicy. You guys, why are you know, this is spicy because, well, never mind. I'll let the conversations go because
this is the kind of thing that should be taught in trial advocacy, and I feel like it is, which is you've got to have some compassion and some discretion. Like, there's a time and a place for arguments, and sometimes you've got to be careful. And like the other thing is, like, let's say you're going to cross-examine a child witness. You know, you can't come in like, hey, isn't it the case that you are a lying sack of poop? You have to, you know, you have to be a little more delicate about it than that. And this is, like, this shouldn't be hard. This shouldn't be difficult. This should just be like, oh, yeah, we don't do the stupid thing.
You should recognize the tone that you're entering the discussion in. Yep. And maybe.
And if there's another family member there, you know, if I was like, you know, the brother or something and I'm sitting in the courtroom, after he says that, I'm feeling like going out and, like, you know, having a little talk with Mr. Owens's tires with, you know, something sharp. And don't do that, people. That is actually a serious offense. But I'd certainly be thinking it if I was in his shoes. I wouldn't be doing it. But, like, you know, don't be the guy that the jury is like, and the jury's going to be like contemplating keying his car. So,
well, the jury's not here for this, but he does. You say he brings up his clothes. If we get there, Ian, we got to get there.
I mean, the jury's probably going to hear about this later.
I know. Well, we have to get through the close.
Fair.
should not ever happen. There should be safeguards in place. There's no room for this after 2 weeks of murder trial for something like that to happen. One of the Torres members of the family audibly, during the 2-minute suitcase video, expressed some kind of emotional reaction.
Oh my God.
He or she were bent over in agony, physical pain.
Oh,
Physical
gee.
pain followed the audible announcement.
Why
You can't
could she
unring
be
that
in
bell.
physical pain over the death of her
That's
fucking
their
child?
responsibility to ensure.
It is not their responsibility. This is where I got pissed. It's not their responsibility. The victim's family has a fucking right to be there, an absolute entitlement to be in that fucking courtroom. And yes, they're admonished. They're told to keep their reactions to themselves. But fuck, like, are you kidding me? Like, it just and it's this. It is the accusation that's thrown directly at the victim's family, right? Like the victim family somehow intentionally did this. And then it's thrown directly at the prosecution, saying the prosecutors somehow knew this was going to happen
and like orchestrated this, like their master plan is to have, sorry, I'm like, the jury already knows that the nice woman is sad because her kid died, right? The jury understands this. And
So that kind of thing doesn't happen, especially when they know they're going to show a video and the family of the victim is on the front row. I've never heard of such. I asked for a mistrial.
Response.
I've never heard of such a request.
Yes, I fucking love Jay for this, by the way. This was the right response. He was waiting. How quickly he and this is a good trial lawyer who just immediately.
Oh, I mean, he picked up on the language they used.
Oh,
and he
great.
was like, once he heard that, he was like, he gets up and he uses the same language they use, to say, I've never heard of such a request. It is beautiful. It is brilliant. It is quick thinking. It is all the things you want to be as a trial lawyer. And
you know what he didn't do? He didn't go in there at a level 10. He came in at a nice clean 5. And he was like, I've never heard of such. And I'm like, yeah. And everyone else in the room is going, Jay, I could appreciate a 9 about now. Like, you can come in at a 9 and still have me, no problem. But I do appreciate the 5.
The thing is he's being gentler than he has to, which is exactly what you want to be here. Judges often decide issues based on who they think is being a jackass, right? Who's wearing the white hat? Who's wearing the black hat?
Mm-hmm.
And you want to be the person wearing the metaphorical white hat, so like Jay is like, Jay comes in and he's like, I've never heard of such. He could have just said like, this is, he could have done like the Seinfeld lawyer of like, this is unreasonable. This is, whatever. This is, unconscionable. This is, and instead he's like, this is some garbage.
You know what else sucks about this is what we know about. Well, Ian and I, a couple weeks back before this trial began, when Mr. Owens was originally retained, heard Mr. Owens give a press conference after he had been brought on board. And we heard Mr. Owens.
He makes a lot of choices.
What he was going to do as far as a defense. And Mr. Owens did not have kind words to say about any of the Torres family. None. So there is a whole lot that I don't know where it came from.
And I think it's a huge mistake. The tone you want here is, this is a tragic circumstance. We have tremendous empathy for the Torres family. We understand why they're upset. We understand why they have the views they do. We just ask that you wait and listen to all the evidence, but it is certainly understandable and expected that they would be, upset, and that they would have, have views about Ms. Boone. They're not likely to ever be friends. But this is a tragic circumstance. Please wait and listen to the evidence. You don't need to dunk on the family or mock the family or harass the family. You can just say,
yep.
Like, we understand why they're upset because they're family, right? Any family member would obviously come to conclusions and have opinions, but you never lose by being the better person, right? It's at the end of the day, all it costs you is just do a good thing, be okay. So yeah.
Any of the victim is on the front row. I've never heard of such. I asked for a mistrial.
Response.
I've never heard of such a request. The victim's family has the right to be here. They were advised as to what would be used during closing arguments. I cannot make a decision for the victim's family and the homicide survivors as to whether or not they believe they can handle it. She clearly, or he, I don't know, couldn't, and I believe the appropriate thing was done. They left the court. But again, to say this is intentional sabotage and all the accusations that continues to get made are unsubstantiated. It does not warrant a mistrial. People get warned, and sometimes they misjudge their own emotions. I don't understand what test we are expected to run on homicide survivors. So the motion should be denied.
Motion is denied.
God,
The
I love this judge.
Jury's going to be back in about 13 minutes, counsel. So we'll reconvene at that point in time.
I also love the way the judge just is
Can we
like,
clean the
motion is
well from the
denied.
state's materials, please? Thank you.
There's no he's like, I don't feel any need to explain myself here. It's just we're not doing that.
Yeah, it was great. The judge was like, no, it's denied. See you later. Bye.
Yeah, that is some bullshit. We're not doing it.
Yeah, we're done. We're done here. You're not getting into that. Now,
yeah.
Here's the
7
thing.
minutes.
Will J, the prosecutor, has already seen a whole lot of Owens' antics. And this is kind of what fueled me, because there was an objection that came way early. And I was going, holy shit. One, rule of thumb, very, 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 very rarely will anyone ever actually get a objection in an opening or a closing.
Where I am, it's risky in the sense that if you're objecting to the other side's open, like to their closing, if you don't, like if you get repeated, and he gets repeated objections denied, it can be grounds for a mistrial.
Yeah.
It can be a situation where it's like, oh, you objected so many times that it's like you objected repeatedly and they were all bad objections. Mistrial, prosecutor. Sorry, you prevented the defense from mounting an effective closing argument.
Very rarely do you see a defense attorney. So most defense attorneys are really well trained in doing closing. They know how to give a damn good close, and they know what the line is, and they know that they can walk right next to it. They know they can put a toe over it. They know they can leave 1 foot over it and keep walking.
You just can't have 2 feet. You can't have 2 feet over the line, basically.
And what Owens is doing is Owens is playing fucking hopscotch, or just there's a jump rope and he's just putting 2 feet in one side of the line. It's just like, can't be here a whole lot.
Well, some of the objections at the start, I was like, yeah, those are weak ass objections.
They were.
And then later they get
that way.
No, they get better over time because Owens gets worse over time.
But I think that Jay knew.
I don't know if he knew, because that's sort of a little too much predicting the future. I think he caused it partially because Owens gets super frazzled, and I think that he might not have gotten as frazzled if he was able to start off and do his thing. So I'm not sure. I'm not super sure.
If I'm Jay, if you were running this trial as a prosecutor and you had seen how Owens had been questioning witnesses, skirting the line on some of these arguments, trying to bring in stuff that was,
I'd still have waited. Especially here where I
First
am.
one. Well, especially the first one. The first one, the introductory stuff, I thought was like, bro, that's way
Yeah.
early.
He's like objection relevance, and it's like, dude, he's just setting a theme. Like, knock it off.
Yeah. We have some celebration to do.
Oh,
Dr.
nice.
Goldbutter. My last chemo 14 years ago, 1022. Survivor.
I love that number.
That's awesome. Phenomenal. Grim faded at my law school. They teach us not to thank the jury. Interesting. Tess Heard, my first FNF in months. Missed y'all. Thank you, Tess.
I assume they don't teach you to like tell the jury, hey, go F yourself.
No, probably not. Olga, thanks for becoming a member and for gifting memberships. It's very nice of you. Thank you very much. Buffy Lynn at 14. Can whoever moved away choose not to visit? There's no requirement that children have to visit. Not when their parents are in jail. Lauren, I love the way you kept glaring at her. This was the
Unless they get a court order.
Story.
Sometimes families do get court orders that say visitation.
Usually
even
it's
from
not when they're
jail.
actively incarcerated.
Sometimes though. I've seen it. I've seen it.
It depends on the age of the child, very much. 14-year-old, I'm not seeing it.
At a certain
unless
age,
the 14-year-old
at a certain age, they get old enough. Yeah.
Desire. If they express a desire, then yeah.
Yeah, and the other you're right that I've seen it more often with like very young kids, especially with shorter jail sentences where it's like so and so is going to be in jail for the next like year.
Yeah.
And you know, their 2-year-old should be brought over like every couple of weeks just so they know who dad is, you know, so that then later when dad is going through and getting more visitation, it's not like, oh, who's this random weirdo?
That's a good point.
So, I mean, she's going to be in jail. Like, I mean, you know, the 14-year-old's going to be like 45 before she's looking at release, maybe. So, yeah.
XCDA, thank you for gifting memberships. Much appreciated. Dandy Daisy 1. Will we see some future Sarah letters? I can't imagine we're not going to. 2, you think the jury looked at a 108-page text message? No, I thought they would. I thought they would read the damn texts. That's what my thought was. But they were done.
Here's the thing. She's probably going to make more, like write more letters from custody. And I know I'd get super chats and so forth covering them. I don't plan to cover anything else she does in jail if it's not a court filing. Because if she writes a letter to the media or whatever else, it's because she wants to be on the news. She wants us talking about her. And what she deserves at this point is to be locked away and forgotten, that nobody knows her name, nobody is a fan of hers, nobody like anything. And the more attention she gets, the more she might get people doing things like donating money into her canteen and, you know, keeping this going. I want to see her vanish entirely from existence, just gone. And, you know, George can't write any letters that we'll be reading on stream. So I just want to see her go away. And that's what I think she deserves. And I think that's what we deserve too. We've been through a lot, folks. We've had to watch some really awful stuff. I can tell you those those videos were real hard for lots of people, myself included.
Yeah, they're not fun.
You know, she deserves to be just gone, like just goodbye. So that's my take, and I'm just gonna say as well, I ain't judging anybody who chooses differently, right? If somebody else is like, I want to cover this stuff, then cool beans, right? They got other people can have different takes on this. Other people can have different stuff they want to cover and different methods to cover it. But I'm okay if she's just gone, daddy gone. Like, you know.
It would be nice. The video that did it for me, the one where I was done, Was
The one where he's
she,
in the fetal position?
No, it was the one where she called him when the protective order was in place
Mm.
and had him come over, then call the cops.
Yeah,
And
that's
she's-
very.
And she's jumping in and out of the room, and almost giddy. And that one was that just fucked with me. That I see too much of. I see too many people that get protective orders that don't
that behavior is
deserve them.
sufficiently common that I warn clients about it.
Yeah.
And I say, if she starts calling you and she starts sending you text messages, and some of those messages might be real friendly, be aware that the result of going over is you end up in jail, not her. You end up in jail. And when I say real friendly, the number of guys who've received nudes from women who have a protection order against them is lots. And, saying, hey, come over. This is what's waiting for you. And,
and this part. So this part is the misconception that this entire thing is premised on. No, protective orders go one direction in one way.
They're mutual.
Unless they're
Sometimes
mutual, unless
those
there's,
exist.
in which case those are cross protective orders. They're both. But protective orders enjoin the conduct of one person.
Also,
the person
the
that is ordered to
only-
stay away.
And the only person who has the power to modify it is a court.
A judge.
Yep. And, you go into court and you say, well, she called me over. They're going to be like, oh, is her name Judge? Because if she's not a judge, then she don't get to do that. And in fact, she don't get to do that even if she is a judge.
Right. Consult an attorney in your jurisdiction. But what I'm telling you is in Virginia, they are unidirectional. Means I don't give a shit what they say to you, how many times they call you. I don't care if they're sending you photos of things. I don't care what they're doing. That order prohibits you from engaging in conduct, not them.
The only time I've seen an
absolutely
acquittal,
weaponize it.
the only time I've seen an acquittal based on guy went over, was woman was sending him pictures of her abusing their kid.
Yeah.
And he went over, pulled the kid out, and was initially charged with breach of the order and kidnapping. And if you're wondering why it's called kidnapping, it's because it's actually really common that it's parents taking their children, and always has been. But he gets charged with a whole bunch of things, and later they were like, oh, yeah, no, you had good reason to get your kid out of there. That was a total, that was a necessity kind of moment in the defense of others. So we're cutting you a break.
So yeah, that one was what did it for me.
And the thing is even in that case, you should call the cops as well. Don't go yourself. Call the dudes with guns and send.
And they'll
them.
go. They will
They'll
go.
go.
Absolutely.
Yep. I mean, especially if you send the pictures of your kid being abused, they'll roll out, and they'll probably be angrier than you would. Because
sorry, this is tyranny. I guess tyranny. I love it.
Yep.
Bet this guy bench presses the bench.
Love it.
Story. Morgan, Appalachian, born and raised, 100%. Rob, we bring the find out in the FO. Yeah, yeah. You don't break it there. No way. El Bauman, thanks for becoming a member. Alan Muller, already flexing discussion. See every Doc Savage book cover. Okay. Ryan Man YYC. Hey, Runkle, I thought it was agreed that it would be referred to as the unfortunate incident. Starkey, Owens certainly suited Sarah as her attorney. Wendy Wilkinson, one membership. Thank you very much. Go ahead.
I mean, for the most part in this trial, Owens was just doing the stuff that every defense lawyer has to do, which is you make the arguments. And sometimes you get a shit case and you got to make the shitty arguments. It was this one moment when I was like, Oh, you got gross. You got gross.
Yep. You make the arguments. You don't become the client.
Yeah. And
Olga,
that
thank you
I
very
was
much,
like,
Olga. Thank you, Olga. Thanks you, Rob, for letting Runkle rant. It's hilarious. Love your Friday streams. Oh, and hi, Runkle. Thank you for the funny
Hello.
rants.
I every once in a while I got a rant, and
I just let you go. I give you the space. El Bauman, thank you for gifting memberships. Laura M, thank you. Spent my 28th birthday with EDB chat, and now y'all. Thank you, Laura. Happy birthday. Happy birthday. 28 years. Make the next one a great one. Billy's Momzilla, well said, Ian.
Thank you.
Kim Chi, Runkle, is this the client you couldn't defend?
No,
he
the
could
client I
defend her.
couldn't defend was I mean, I could defend Sarah Boone. I could tell you Sarah Boone would be easy to defend if she hadn't made all the videos. If her phone had been lost, this case would have been a sleepwalk to victory case. And I'm really glad she felt the need to tape record everything. And the thing is I think she thought, like, she turned over her phone without much headache. I think she thought that, like, all of this would look good on her. I think she thought that, I think she walked out of yesterday with those really ugly videos going, oh, man, that was a good day. Because the jury saw all those videos of George saying I'm an angel. I'm like, you what now? So yeah. Rob, I gotta ask your opinion on something.
Shoot.
So I got two designs to possibly put on this this journal I'm working on. Design number 1.
Okay. Love it.
Design number 2.
Hang on.
So
2.
that's number 2.
I like 2.
And 1. You like 2? All right,
I like
we can
2.
do 2.
It's got good personality.
It's kind of Cthulhu. Yeah. Chat has differing opinions too.
I can put up a poll.
Yeah, let's put up a poll.
What are we going to call the first one?
First one is floral. Second one is Cthulhu.
Okay. Which Ian print pattern? Chat, stop voting in the chat. Hang on. Which print pattern for the journal, right?
Yes, that works.
Floral. Can I just say it's a octopus?
Sure. Because you can't spell Cthulhu, can you?
No. You're such a dick. What an asshole.
Morgan says, can we see again? That's Cthulhu.
Hang on.
And...
Wait. Let me make it bigger. No, I don't like, no, move my head. There, that one.
So that's
okay.
Cthulhu. And that's floral. Cthulhu. Floral. Yeah. So those are the options. I'm going to say when I tool it, it's not going to look as good as the... This is an image that Midjourney spit out. And Midjourney has some creative interpretations about what you can do with leather. So
I believe it.
Midjourney thinks you can make leather do things you can't. So yeah.
Sounds weird the way you say it. Lynn Britton just got home from football. Got to catch up on Saturday. Enjoy. Love the replay crew. Oh, that's a reminder. Please hit the like button. Core TV, you have to hit the like button too. I saw you in the chat. You have to hit the like button on this stream, please.
Oh, did I tell you
like,
Core TV? Core TV is donating something for the charity auction.
Really?
So
that's cool.
Yep.
We got to talk about how we're doing the auction, by the way. So
yes, I got to figure that out. Also, Rindaru saying, and then EDB buys it for Octo. I will let you in on a secret that Octo told me. Octo is drowning in octopus themed stuff. And
Kind of like the unicorns that I have.
I told Octo, I was like, hey, I could make you like an octopus something. And he's like, please don't. I have so many octopus things. I don't know what to do with them all. So I was like, fair. So I don't think that's gonna happen. Claude Simeon's is Hot Ones gonna be part of the charity stream. In that I am going to do a Hot Ones challenge. Yes.
Yeah.
And I totally screwed up Rob's super chat system.
No, that's fine.
Sorry.
I'll be glad to. Kathy at Oz, she abused the 911 system. She did indeed, and that's not a good way of using it. Baby steps. Thank you for gifting memberships. Very much appreciated. Cindy Collins, I'm pulling the guidelines right now. From my first glance, the last revision I'm looking at was 16 and a half years was the minimum, but I don't know if there's enhancement or not.
Good night, Court TV, and thank you once again. I really appreciate it. I'm going to get back.
Yeah.
I got to respond to your email later tonight. So,
yep. Thanks, Court TV. Glad to see you here. Thank you. And thanks for hanging out in our chat. But you had to hit the like button before you leave. It's required. I got to look at the guidelines again. But from what I was looking at, first degree felony is up to life. But I don't see anything other than the 16 and a half as the min. I'll have to look it up. The judge say 22 and a half. I take the judge then. If the judge said 22 and a half min.
I think life is really on the table.
On the table. It's also because there's no recognition. The big thing with her is they're looking at consciousness of guilt. Consciousness of guilt is a factor that is considered when you're determining whether the person can be rehabilitated, whether the incarceration system has a remedial effect on the individual. And I don't know that Sarah Boone is going to score a whole lot of points there.
Let me just put it this way. If I was the judge right now, I would have life written down on my, on my sheet. It would be written in pencil, but it'd be written down. So it's like I could be talked out of life, but you'll have to do some talking. It's basically how that goes. And so let's see what she has to say. But Billy's momzilla.
Sorry, the depraved mind was an enhancement.
Billy's momzilla. She's got a deal. She had a deal offered for 14 years, but it would have had her out in 8. I think that deal is going to start looking. I think her time is going to start tasting real bad after 8 years. And I bet she's just talking to her lawyer going, we can get that 14 years now, right? We can get that back. You know how often clients do that where they're like, oh, we can get that, time. And it's like, no, I made you sign the thing saying that you understood that you couldn't. So no, that ship gone. Not only did that ship sail, but it caught fire and then it sunk. And it's at the bottom of the ocean now. And the fish near it are flipping you the bird. So it's over.
Kudos to defense attorneys. People think domestic relations litigation sucks. I hate these stupid charts.
Oh, we don't
They're
have
the
the charts in
worst.
Canada.
They're such a pain in the ass. I hate the scoring sheets. They're terrible. All right, I give up on this right now.
I don't disagree with you. They are awful.
So if the judge said 22 and a half, I think that's what it is, Cindy Collins. I'll take a look at it, but we're going to know more about that as we get towards the sentencing.
Yeah.
Yeah. All right. Let me get back to this because unfortunately I do have to watch.
And somebody was saying, when is the live stream? It is November 2nd.
Yes.
All day we're doing the live stream. And I'm going to be starting at midnight my time and gonna go until midnight my time. So it's going to be a long day.
You mean midnight like if I am running FNF and I end FNF and I kick it over, you'll be starting.
Yes,
Didn't we do that last year? Same thing.
I think so.
Because what I did last year was FNF. I think I used it to start kind of pre-boost the donations. Okay. Same model. Love it.
Yep. It worked, so why not? That'll be like 2 a.m. your time. I can adjust if it would work better. Like if you're thinking ending midnight your time, I could set it to a couple hours earlier.
I can make it. I can
okay,
make it.
good stuff. Somebody
I can
said
make
where to donate ahead of the live stream. You can donate. I can pull up the link here. Extra Life.
I can pin it. Where is it? I forget what the short link was.
The short link I'll just find here. I gotta. Where's the? How do I get to the short link again here? There's a feature for the short link, and I'm like,
Drake says you put it in the chat.
Okay. Yeah, for some reason it doesn't. Settings.
Here, I'll just pin. So it's I just pinned Lady Drake's comment, so it's there.
Okay, awesome. So yeah, you can donate there early, and if you're wanting to send things, you can send them. I've got my PO box in the.
Wait. All right, Lady Drake. This is not a comment on you. It's just Sandy has just the link, which is going to make it easier for people to not have to scroll through. Give me 1 second. See, Sandy's got just the link one. There you go. Okay, just the link. That's the pinned chat. That's the donation for Ian's Extra Life. Thank you, ladies, for finding that. That's awesome.
Much appreciated.
And for pinning that. Much appreciated. Okay, mods are awesome. So thank you to the mods for doing everything that they do to keep this and my brain like focused somewhat. So. Patty Hoffman, can we bid on a future Rob pen? I think I should be able to get a couple of pens ready to bid or ready to ship off. I should be able to. My goal is my shop's ready to go. I just need to get a little working room for the lathe, but I should have something to be able to donate. All right.
Yeah, you're still getting moved in.
Yes and no.
Nell says, where's the mailing address? It's on my YouTube page. It's a P.O. box. Let me find it.
While you're finding that, I'm going to go ahead and start this.
Excellent.
I think you will find, from considering the evidence in this case, that there is no doubt that Sarah Boone.
Wait, hang on.
Oh, I got to put it in the private chat because I can't comment easily. There we go.
Why did I get so far ahead? What happened?
Closing last time, if you could please, closing argument. You may proceed, sir. Yes, sir. Thank you.
Ladies and gentlemen, good afternoon.
Lindsay, there's a brick.
I'm James Owens, along with Tony Henderson and the girls. We're all from Milton. I think y'all figured that out.
What the fuck is he doing?
Northwest Florida, close to Pensacola.
Mm-hmm.
And my buddy
can we pause?
Mexico.
Yeah.
Don't introduce everyone on your team. This is not the time for shout outs. This is not the Oscars where you're like, and I want to thank my mom. But the thing that really made me just want to step through the screen and slap him was the girls.
The girls.
It's just
you remember the names. You remembered some names, but then it was the girls.
And the thing is lots of lawyers do this where they have an entirely female assistant staff and they call them the girls. But I just want to step through the screen, grab his tie, and nail it to the ceiling and leave him up there until he figures things out. It's a little bit of a Sarah Boone maneuver, but
I mean, it's a choice. It's a choice.
I don't know the jury breakdown, but there's got to be women on the jury.
Ian,
And
the people that deliberated and delivered the verdict, 5 females, 1 male.
son, you fucked yourself. Yeah.
5 females, 1 male.
Oh man, that yeah, that was a choice there, sir.
So that was how I started the stream. I goes that was a bad fucking call with this case.
Yeah. I have a thought, and the thought is mostly just rage.
Yeah, and when they pulled the jury, I mean, they pulled the jury and they were like, juror in seat number 3 is in. He's like, that's mine. He was just like, yes. He was like, I did it. I said, get the fuck out of here. You're guilty.
He's like, I got opinions, and the opinion is guilty.
Yeah, there was not a hesitant voice in any of those jurors at all. But yeah, this was people missed it. So we're gonna go back to the.
It's like, I got a fever, and the only cure is guilty.
It's just this was, and the problem is part of me just completely acknowledges that what he is doing is entirely unconscious. He has no recognition for how demeaning or belittling that can be.
I mean,
even
I think
just the
this
reference
guy
to
was
the
like-
girls part, it's like it's the names. You are naming individuals and then you're just identifying them categorically as the girls.
I feel like this guy stepped out of a time machine from like the 50s, and I'm not sure it's the 1950s.
You know what? I need this for this.
Like, it's some 50s, but I'm not sure which 50s. So
I need this. All right, Owens, pissed me off.
Rob, is that an emotional support unicorn?
James Owens, along with Tony Henderson and the girls. We're all from Milton. I think y'all figured that out, that we were from out of town. Santa Rosa County, it's northwest Florida, close to Pensacola. And my buddy Kevin Beck, he's a longtime friend, he's from New Mexico. The defense team is here.
Jesus Christ. It is so much worse when you slow it down and play it again.
I just want to
And the jazz hands at the end, like the defense team.
yeah. Like, I just want to hit him. Like, I know I'm not allowed to hit him, but he just, like, sir, you need to stop. And, like, you need to find whoever taught you this and seek a refund, because, like, this, you should not have learned this from a human. And anybody who taught you this was not your friend. Like, they are so not your friend.
This was so bad. It was so bad.
Yeah.
I want to see because someone in the chat saying to take a look at the 2 law students that are sitting behind the judge.
Oh, we got to watch this again and see the.
I want to see
their
law students
take,
because it was also one of the things where he goes, "This is the name of this individuals, the girls," and then a good buddy over here from New Mexico gives the full name. We're the defense team. Jazz
And the
hands.
thing is they've got those students who they're learning trial advocacy. I bet they're going to go
They're
back
learning
and be
not
like,
how to
so,
do trial advocacy.
do we have some thoughts about that particular bit of trial advocacy? Because I got some thoughts about that particular bit. All right, are we gonna have to watch that again?
Yeah.
Okay, I
And
just
my buddy
gotta
Kevin
swallow the
Beck,
bile.
he's a longtime friend, he's from New Mexico. The defense team is here, and we're here to represent Miss Sarah Beth.
The students
And
are like,
feel
we have
confident
opinions.
That we're going to be able to show you why she's not guilty. Okay. I'm gonna
Yeah,
take
that's
my
getting a
time.
little close to
I've got some notes. I'm not supposed to organize things
expressing a
anymore.
personal opinion.
And bro, don't. You don't lead when you're explaining to the jury. Look, there are jokes that lawyers get away with. One, we're bad at math. Like, just categorically. Those jokes can play. They can do well.
Also, you got to be really careful about the jokes on certain kinds of trials. You can be pretty jokey if your client is charged with like impaired driving. You can be pretty jokey if your client's been charged with like, theft under 5,000, two-wit package of condoms. You can like those are times when you can maybe crack some jokes, right? But you can't really crack the jokes when you're dealing with a murder or like an essay or anything where a child was hurt. At that point, you should just forget you have a sense of humor and you need to be, you need to be interesting and invested, but you can't be interesting in the I am a funny guy kind of way. So yeah.
So making a comment about you not being organized at the end of a murder trial when you're defending the person that's accused of murder, generally speaking, is not the right play. I will make comments about me being disorganized or all over the place all the time, but it's never when I'm trying to convince a judge to side with me on something.
Yeah, it's really a look because it's like I have this client here and I couldn't give two shits about whether she lives or dies. Like that's how that comes off to me. So I'm like, maybe you should give two shits about whether your client gets convicted or not, because that seems to me to be a thing that should matter to you today, sir, and maybe you should have done some prep for.
Yeah,
like.
I've got some exhibits that we're going to show you.
It's like, sir, this is not a Wendy's. This is a courtroom.
Okay.
You have to plan for this.
We'll try our best to help you make the right decision. Okay.
See, it's the right decision part.
Milton's a small town.
Objection.
Overruled. Why didn't you object to the right decision part?
See how small it is. 7 miles away is another small town called Pace. In between that is a Walmart.
Objection. Who gives a fuck? I mean, the thing is the judge is letting him get away with it because
Judge, I'm allowed to.
I'll give you a little bit more for intro, but then we need to get into it.
I'm going to get into it. But I wanted to say, it's a small town, good people. We've been down here 3 weeks. We didn't know what to expect. We've been surprised.
Objection.
that actually was
Mr. Owens' approach.
Yeah, it's what the fuck are you doing? What are you doing? What are you doing? You are trying to you're pandering to the jury.
Safe to say, I think James Owens is not too happy with the objection there from the prosecution. Multiple objections into the beginning of his closing arguments there.
Shut up, Fox. You're not smart.
We appreciate that. Now, I'm going to do some reading, and then I'm going to do some talking. But ultimately, this is about justifiable use of force. That is a legal defense in Florida. We as citizens, the law is designed to protect us from defending ourselves.
No, protect us when you defend yourselves, not protect you.
I know
from
he
defense.
does this a lot. This was really. I'm gonna read to you a little bit. I'm gonna chew some gum and I'm gonna walk at the same time too.
And then he's gonna fail at both of those things.
The law is intended to protect us against protecting us, which isn't a thing. So what the fuck is happening? We're going to 1.5. I can't with him. He's too.
I feel like there isn't enough alcohol to explain what he's doing or to put up with it.
No, there is. Just Sarah Boone drank it.
Oh.
You were the only ones, in this case, because Sarah Boone was arrested, that's going to be able to look at it critically and objectively. Objectively. Not like the state attorney.
Objection.
Wow. Whoa.
And the law in Florida gives y'all the power and authority to do that. The state attorney can't make the decision. They can't make the decision. They can try to influence you. And we're going to talk about some of the things they did here in this trial and some of the things they said.
You can't. You fucking kidding me?
More objections there from the prosecution as James Owens continues
Shut
his
up.
Closing statement here.
Shut
Fox
up.
News is just awful.
Another objection there. I don't know what the objection was. What are we? You can't characterize the other side as trying to mislead you. Are you fucking kidding me?
They have a big dumb.
You cannot, in closing arguments, say, Your Honor, the other side, or, ladies and gentlemen of the jury, the other side, they're trying to lie to you.
Yeah. They're here to deceive you. They're here to bamboozle you. They're here to, yeah.
And they put smoke and mirrors. The other attorneys just tried to hide evidence from you. You fucking kidding me?
And the thing is I find it's way more effective to be respectful. Like he made submissions on this and he's entitled to make, he's entitled to argue his side, but he's only really going to focus on one side of the story. He's not, I need you to look at both sides of this story and come to a decision having heard all the evidence and considered all the evidence, so.
I mean, hell, you can make the comment like the evidence that you just heard recited by the prosecutor. Yeah, that evidence, which was handpicked.
Yeah.
One piece here, one piece here, one piece here. Yes, that evidence that was hand selected might have painted a picture that would have not looked good for my client, but that wasn't everything. Of course, they're going to handpick the evidence that looks best for their case.
Yep.
That's a proper argument.
Yep. I mean, I saw a very skilled defense lawyer say, wow, after the, the opening from the other side, that was a really compelling, description. And I'd be ready to convict if that was all I'd heard today.
Yeah.
But that's not the whole case. You need to consider all the other evidence that they didn't focus on in their close.
Let me tell you what they left out. Yep, exactly.
Yeah, they started off with, that was a great close from the other side, including the description, like the word wow. And I was like, where are they going with that? And then
you can even say, not just that, you can say, I found it interesting that they saw this piece of evidence and they interpreted it in this fashion. I would say that interpretation or that argument is completely off the rails and inconsistent with what the reality was. You can do that. You just can't.
Yeah,
do what he just did.
They got their side, their position, we've got our side. So we're going to talk about that. But
that's
fair.
fair.
We're going to talk about justifiable use of deadly force and non-deadly force. Either way, however you rule, it still justifies her behavior. And the result is not. Now, I don't believe there's anybody.
Overruled. Yes.
I don't believe. Did he just pray? Did Owens just hang on? I gotta slow this down. I see this the first time because I was just listening to it. Hang on. Look at Owens. Did you see this?
Overruled. Yes.
Yes.
Lord help me. The Lord's
that is the Lord help me look.
And the good Lord is like, you pick the other side on this one. You should be looking
What
down
is it?
for.
Here's the church and here's the steeple. Open the doors and there's the people. Fucking great. Hang on, I gotta see this again. That was worth the price of admission.
Overruled. Yes.
Oh my God.
Objection. The argument I'm thinking about.
That
Objection. Fox News is full of dumb
I
people.
think you will find from considering the evidence in this case that there is no doubt that Sarah Boone is a victim. That Sarah Boone has been traumatized. That Sarah Boone is still traumatized. And the reason for the trauma is George Torres. The reason for the trauma is George Torres. From the positive things about the man that we've seen on video to the positive things Sarah Boone has testified about, to the violent monster he becomes. And I mean monster, because it was repeatedly.
Is he a Frankenstein? Because if so, then you've misunderstood the book.
And what happens the next day?
Frankenstein is the doctor. Also, for all the people in the chat who are about to say, but he's also the monster, I will go off on a rant.
That's the gaslighting. That this young woman, vulnerable woman, with nobody, just starving for love, starving for attention, and seeing the good in the man.
Dude, I don't know what ladies you think you are talking to.
No, Frankenstein, Dr. Frankenstein is not also the monster. Read the fucking book. Oh.
I don't know what group of females he thinks he's speaking to. He's in a different era. He's like this woman who starved for affection.
Like
This
I
woman
said,
who
he's in the
loved.
50s, and
This
I'm not
poor innocent
sure
woman.
it's the 1950s. It might be a different 50s.
Jesus,
yeah.
no fucking wonder it was an hour and a half. This is
Oh,
ridiculous.
I mean, that's including the time to eat. Emily says, but Ian, who actually did the monstrous acts in the books? The monster did. In the book, the monster did. Like, he commits several murders. Dr. Frankenstein doesn't murder anybody in the book. In fact, his crime is he creates a life, which he creates a life, and then when he creates it, he's like, oh shit, this is super ugly, and he recoils in horror, and then he spends the rest of his time trying to find the actual thing, like trying to find the creature to apologize and explain, and the creature is not interested because the creature just keeps getting angrier and angrier and angrier over like basically being ugly and unloved. And yeah, Dr. Frankenstein is not the monster in the book. The creation commits multiple murders and out of vengeance and anger.
Right now, Owens is creating a possible multiple murderer in me right now. Like, I switched over to Top Mark Media. I switched over to Top Mark.
The doctor was a monster for trying to play God. We're all trying to play God. Like, you know, when
guys,
your
why are we
doctor
talking
cures
about?
your
Can we not
cancer,
talk?
he's
Stop. We're not talking about Dr. Frankenstein. We're talking about
Sorry,
Owens
it's a
and his
random
closing
one.
argument. That's it. Stop. We're not doing no Frankenstein. K-Rab, Recovery Addict makes his commentary-free stream on the trial available on Top Mark Media. That's what we're watching now. We just switched over. So no
Okay,
more
good.
commentary, just trial. And my word.
I'll save this rant for Monday.
And the reason for the trauma is George Torres. The reason for the trauma
Boost it.
is George Torres.
Yeah, except she doesn't come off traumatized.
The
She comes off
positive things
sadistic.
about the man.
I gotta hear it again. I gotta hear this tape. Fuck. Oh.
On video to the positive things Sarah Boone has testified about, to the violent monster he becomes. And I mean monster, because it was repeatedly.
Like a Dracula?
And what
Like
happens
what
if
kind of
he gets
monster?
I don't remember. I was drunk. I don't remember. That's the gaslighting.
Is he Swamp Thing?
That this young woman, vulnerable woman, with nobody,
I must know.
just starving for love, starving for attention, and seeing the good
Starving
in it.
for murder.
And it was good. But every day was on the balance. She measured every day, depending on how it started and then how it ended. And that's the way she had to live her life, day in and day out.
Committing murders.
Missing the fucking mark, man. Talk about missing the mark. I
Thing
mean,
is, he's
like,
speaking to
there's
the hypothetical juror who's buying his bullshit.
he's missed. What the fuck are you doing?
He basically
There's a way to
thinks
make that argument. Like, there's a way to make that argument.
he thinks the jury thinks that Boone is totally sympathetic. And what he needs to be doing is coming in and being, this is the awful but lawful argument, right?
Yeah. My client is a piece of shit. You hate her. But
Yep.
the behavior they engaged in was lawful self-defense.
Sarah Boone is a deeply flawed person. Her and George Torres had a, tumultuous at best relationship in which both sides were abusive to the other.
Mm-hmm.
But,
there's a world in which both of them have battered spouse.
Yeah.
And both of them can use it in a moment.
Can I take control of the video for a second?
Yeah. Oh, that's cool. Turning out good.
It's just begun. There's plenty of time to screw it up. So,
Turning out good. Yeah. Rocco got to rant twice. Yes, he did. He did tonight. Didn't she have a deal for 5 years? She had a deal where she'd be out in jail in 8. Now she's looking at a lot longer than that.
It was such a good deal. I could tell you with those videos that were on her cell phone, if I'm her defense lawyer, I'm like, take the fucking deal. Take the deal. This deal is an absolute gift. And the reason why it's happening is because the prosecutor doesn't want to put up with your shit. So take it.
Yep. Elle Flagon's defense doesn't have to be distasteful. I agree. Crazy Cat Queen. I would give him the benefit of the doubt if he didn't do it the way he did. Not an excuse, but Owens may have said the girls because it's his and Henderson's daughters, so he may have not have wanted to identify his daughters by name.
Then don't refer to them at all.
Then don't refer to them. You
or
don't have
you can
to.
refer to them as like our legal assistants. Or just, our daughters came out to watch the trial. They're helping out too. Like if you say the daughters as opposed to the girl, like our daughters as opposed to the girls, that's humanizing, right? That is so much better than what he does.
Comes out of his mouth. Yeah.
Yeah.
Yeah. So mouth hole is going to keep moving. I'm going to keep trying to.
Day in and day out. Dr. Harper and Dr. Brandon talked about trauma. Dr. Harper spoke of the veterans that she had treated for post-traumatic stress disorder. I don't know if you remember her testimony.
Oh, don't do it.
But she spoke about some of the veterans that had been.
Don't do it.
And
people in war, a lot of times get post-traumatic stress. It used to be called shell shock and other things. But people in wartime, or police officers will get post-traumatic stress. And a lot of them
Don't do it.
Males come in with this bravado, oh, I'm all right. I'm all right. And so, that's why Dr. Harper was talking about the veterans, that's what they'll do. But you got to spend time with them. You just can't be one session. And you've got to run post-traumatic stress testing, which tells whether they really have post-traumatic stress.
This is borderline an appropriate argument.
And the thing is you
because the state
really
only
don't
has
wanna-
one opportunity. The state has one session. That's all they get. They get one evaluation.
The thing is you also want to be really careful that you're not comparing her with like soldiers and police, because you're always going to lose that one. Soldiers and police are viewed as heroic, and she is not. Like, you're not going to spin her as heroic. Like,
she does. She certainly.
Oh, I mean, she thinks she's, she thinks she's heroic, but she's wrong.
I'm now understanding the hour and a half. I get it.
We all probably have experienced some trauma. All of us have lost some.
Oh Christ! I wouldn't even have.
It's awful.
I wouldn't have even finished my dinner. I would have just been like, "Can we get takeout bags?"
Sleep for days. And eventually, you have to go back to work. You take a week off. Life has to go on. Life has to go on. You go back to work. Kids are in school. You get a little time, right? Time heals, right? These veterans that come back from a deployment, they get back. They get some semblance of normalcy. They may or may not get some treatment, but time helps. Time heals. Everybody, it helps. Just time. Overcoming a divorce. Overcoming.
Where the
death,
hell are
whatever
you going with this?
Sarah Boone had no break. No break.
Because if it's
Learn
Switzerland, I think that they're done taking in,
Can't get out of the situation. They broke up. She go about 2 days. Vaccines calling. Just learned helplessness. And it's, in the manual. That spouse syndrome
Wait, no. What happened?
is not. But what did you hear Dr. Harper say? She suffers from post-traumatic stress. That is a mental disorder. You are actually undergoing the psychological effects of post-traumatic stress. You're not in your right mind. And it's repeating itself. It's repeating itself again and again, day in and day out. And when you look at this law, that's what you have to apply.
You know what the worst part is?
Someone in Sarah Boone's.
Every time it turns to a spinny wheel, it's
You
making
want
a
it to stay
better
that way?
argument than Owens.
I was gonna say, I want it to stay that way.
The
I don't
spinny
know if
wheel
I
is
could.
doing a better job.
I don't know if I can handle it. This is so bad. Why are we? Why? This was the best you fucking had.
I think he
You know
was
what
just like,
you do? You know what you do if you're Owens? I swear to God, you know what you do if you're Owens? You pick up where Cacciatore left off, and you pick those fucking pictures up, and you hold them up, and you said the prosecutor just dismissed the hell out of these things, but let's take them one at a time.
yeah, like the prosecutor wants you to ignore these pictures. They said they spoke
That's where you
dismissively
start.
of this. This is a stab wound. And they spoke dismissive. They just dismissively tossed this in the corner.
Yeah, you watch Mr. Cacciatore drop this photo in the well as if it was to be dismissed as something that was inconsequential. Look at the injury.
Yeah, this is a stab
Fucking
wound.
Go.
We both have the same erg.
Choose when you're deciding whether her conduct was reasonable. Got a bunch of notes. Not bad, it was
Something I wanted to read.
Oh my god. Oh my god. This is it. Hold the fuck on. Were those stickies on full page of sticky notes?
Something I wanted to read.
It wasn't that one.
Yes, it was a full page of sticky notes. Wow. The thing is when you get up to do a close, you should have just your notes for the close. He's got his entire case file up there. Like, you shouldn't have a book for your close, sir.
Not in the murder trial. You know what? In my little 1-day trials.
Yeah, sure.
Yeah, I've got my notepad and I'll reach back over for a note that I've missed, or I'll grab something that the other side referenced in their closing arguments. But
and it's a murder trial. You should have given this speech several times before in front of the mirror, right? Like, this is something you should be. This shouldn't be the first time you're figuring it out. And it looks to me like it's the first time he's figuring it out. And I got all the opinions about that. And like half of them are just swear words. So.
Her capacity to assess risk, especially in moments of heightened stress. The cyclical nature of this violence, the tension building, the battering, the contrition phases, caused Sarah to be trapped psychologically in that relationship. Due to this clear abuse, Sarah Boone had a reasonable belief of imminent harm under her state of mind. George Torres had a history of violence against Sarah, and as a result, Sarah Boone's actions were the result of fear conditioned by abuse she endured over time. The cumulative effects of long-term abuse, as we saw her behavior on the 2-minute suitcase video, is a trauma response.
I feel like I'm being abused here.
Of preservation. While tragic, it was not driven by malice, but a mind ravaged by abuse. And I'm going to ask you to try to understand. Try to understand. Sarah Boone being emotionally and psychologically broken. These actions may have been misguided attempts at survival, but not murder. Imminent danger, her response reacted to that belief. It's somebody suffering from the long-term psychological effects of domestic violence. Who spent a lot of time? Dr. Bain, you remember him. He was the first expert on trauma. Took some notes. Kevin Beck, you remember, did the direct examination of Dr. Brandon. He was from.
Y'all ever go to one of those science museums and they have the big cone? Like it's in its own room, right? And you put a quarter in the
and it goes round and round and round.
And the quarter
and
goes
still
round,
gets to the point. Still gets to the point a little faster than he does.
Yeah, and you'll sit there and you'll watch that quarter. And you'll be sitting there just fucking amazed at this thing. And it'll be a solid 2.5 minutes. And you're watching this quarter. You're going, is it really going to get down there? And eventually it does. I just don't know that Owens ever will.
Wow.
Down in Miami, I think. He talked about the trauma that you cannot escape from the abuse, so you develop coping skills to protect yourself, knowing that the bad things will happen to me. It changes your behavior, not only your behavior, but your thinking, your subjective thinking about
what changed your thinking, Owens?
What to do. And if you remember, Dr. Brandon said it's all about that person's perception.
Maybe he's got battered spouse. Maybe that's explaining his thinking.
A lot of times they suffer from anxiety. Basically, he said the trauma ends up being terror because you do not know what to expect. You do not know what is going to happen that night. It may be a great night. You may drink, and both of you have a great time. He falls asleep, passes out, he falls asleep, but it may turn, by depending on his mood. I don't know if you can tell, she would try to placate him.
Dr. Brandon said, when you're trying to evaluate somebody, it takes time to get them to trust you. And the ultimate goal, he said, is to be a behavioral detective. If you're a forensic psychologist, is to be a behavioral detective. And the ultimate goal is to put yourself in an abused person's eyes so you can better understand their world. But ultimately, it's their perception of danger. Their perception of danger is what you have to look at. What a reasonable person would do under their perception of danger. Now,
All right, I've
Let's
gotten
be
a lot
honest,
of people commenting about the audio.
For a lot of experts, it's about getting paid.
All right, I'm switching the audio. This Owens, kind of a prick for this, my friend.
He's a prick for lots of reasons.
This is a fucking dumpster fire of a close.
Mm-hmm.
Like, what the hell are we doing? Is there a point that we're going to get to?
There's a point, but it's at the top of Owens' head.
I don't know if it's there. I don't know if I don't know. I'm so mad. It's fine. I found another one. I'm going to boost the volume on this because I know that Top Mark doesn't have any of the junk of the other commentary, but it's quiet. And I'll talk to Scott about it. I'm sure he knows. I'm honestly really glad that Scott is making the effort to do this stuff. The man's going into these trials and creating media.
Yeah.
So he's not a court TV, but he's doing his best at it. He's doing a fucking good job. But I'll talk to him about the audio, and I'm sure he already knows it. So I'm gonna lose my shit. I'm not gonna make it to the. Why is it so quiet? It's boosted 600%.
Maximum overboost.
This ain't the 1900s. This is 2024.
Are you fucking kidding me? Are you kidding, Owens? Did you just say that shit out loud?
Meanwhile, the jury is like, you'd know, sir, because you came from the 1900s.
Wait. Are you kidding me? You started your opening state. You started your closing argument with calling them the girls, and then she's just starved for affection. Little old her, my God, this poor little old lady, this cute, lovely, innocent woman. Because women can't defend themselves. That's how you started, and then
it gets worse.
Then you went with this isn't 1900s. This is 2024.
It gets worse.
How?
Saddle up.
What the fuck was that?
I'm turning myself down a little bit here. Jody says most of us are from the 1900s. Most of us are from the 19-something. He's from the 19-0-something.
Just fuck.
What's all these text messages? Why is that relevant? What are they trying to claim?
What do you mean?
She provoked his violence? She provoked his violence.
Or you could respond to the argument they actually made and not making one up.
Let me get back on this. Abraham Marino. I don't know if you remember him. Abraham Marino changed his statement. They took a statement from Abraham Marino in which Sarah stated, I don't know if you remember, but it was when the police were all there. I think they got the tape out and some neighbors were coming around and there were 2 or 3 neighbors sitting around. He said Sarah came out and stated it was an accident. Okay. Well, then
I feel like this guy's met Abraham Lincoln.
Abraham Marino knew George Torres from Philly. Okay. They were friends. They would talk either at the complex or if Marino went to Holiday's Hardware or Ace Hardware, where it's called. State attorney. No files.
I'm going to object to reading you rooms that not in evidence.
Approach.
Yeah, what the fuck are you doing? What is on your phone? Why did you randomly grab your phone? Was it a text message? What just happened? Why did he just do that? Wait, so he had notes. He had a binder, then he had a notepad, then he had notes that had sticky notes. Now he has his phone?
It's got shades of Bowles checking the law on bail on his phone.
It really feels that way, right? Like where Bowles is like, yes, this case law that completely controls how my client is either detained or not. I'm going to read from my phone.
Oh.
Do not get this man a remarkable. I do not. No, we don't need.
If you're going to get
this
anyone
man a
remarkable,
retirement.
get me a remarkable.
Get this man a retirement.
Actually, I don't know if I'd use a remarkable.
Oh, I used it for I used the full trial this week. It was
Really?
awesome. First time I ran the full trial on it, and my laptop.
Yeah, honestly, I use a laptop.
I gotta tell you, when we finish Owens's bullshit, I'm gonna say a really fun story that's really funny because I had my best cross-examination of my entire career this week, like the best.
Okay, that we have to hear. That'll be a good palate cleanser.
And then this photograph, which we introduced, which shows the bottom of the stairs. As you can see, there's Lucas's bookshelf. Right? This is where Sarah Boone stored Lucas's stuff. And you can see it's not disturbed at all.
Why the fuck do I care?
Wait. Your argument is that the shit's not off the wall, so a suitcase couldn't have gone down the stairs?
Yeah,
Got it.
I'm not seeing his argument here.
Got it. Understood.
I don't understand.
Anyway, I want to get back to Sarah. I want to talk a little bit about that, but let me talk a little bit about the law unjustifiable.
I just noticed this, by the way. I love the screen behind them is simply the instructions for how to connect your fucking computer to that monitor, and no one has connected their computer or taken the stupid screen down. Like, like it's got QR code.
I've actually thought about going back and just watching their wireless presentation training that you can see with the QR code. Because like you can see the QR code.
I think I can zoom in on that right now on my phone.
And then it's like, you know, I was like, I thought about, because the Boone trial kind of bores me in the sense of, I mean, it's gotten a little more interesting with this guy being a clown, but it's like a book you already know the ending to, because you know she's getting convicted. You know she's getting convicted because she's awful. But I kind of wanted to do a video just, what is it, like reviewing the Boone trial wireless presentation training. Just out of sarcasm.
It'd be more exciting. You could have it going simultaneously with his closing arguments. Lynn says Owen infers men can't be DV victims. Does he really?
Oh, it gets worse.
It
gets worse.
Shanta says, you know what's also called the girls' breasts. Owen. Well,
I didn't think of that.
I didn't think of that either. I just thought it was demeaning. But I can see how someone would take that. Absolutely. Talk about Dr. Frankenstein. We're not going to have that debate again. Fiona W. Really appreciate the distraction of today's FNF. My beautiful mom passed away at 1 a.m. on Friday. She was nearly 98 and had advanced dementia. Fiona, I'm very, very sorry for your loss. Hopefully this frustration here and the laughter at the frustration is maybe helping a little bit. I'm very sorry.
And also allow yourself space for mixed feelings, because that's often a thing in these cases. And it's okay to have mixed feelings. It's okay. You can, give yourself that space, because a lot of people feel guilty about mixed feelings in those cases, and you shouldn't, because it's very natural and very normal. And if you don't have mixed feelings, then don't hate me for saying it. But
I was going to say that you can have mixed feelings about a lot of things, but you can't have mixed feelings about this closing argument. That is the one thing you cannot have mixed feelings about.
I have mixed feelings about this closing.
Why? I'd like to
Because I
set
have
it on
both
fire.
anger and rage. Maybe some sadness.
I don't feel sadness. I just feel like I want to kick somebody in the balls. Like, what the
I
hell
feel
is going
sadness
on?
that like it's happening to us, that we're watching this.
I needed to see it though. I needed to see it.
Yeah.
Is legal and lawful if you reasonably believe, I think we all probably all already understand it by now. You reasonably believe it was necessary to prevent imminent threat to harm. The law is crucial, ensuring that individuals can safeguard themselves in potentially dangerous situations. By acknowledging you have a right to defend yourself when you have a reasonable belief that force is necessary to prevent an attack. Okay? What did Mr. Henderson say in jury selection? You don't have to.
Do you know what juror just perceived what he just said? None. Are you fucking kidding me? You just read that. Like
You read that, you didn't offer any explanation, and you hustled through it because you were like, I got more points to make, so I'm gonna go zoom, zoom, zoom. And the jury's like, what did you just say? Ignore him.
transpose this to Cacciatore, who literally had the thing, and this is why I said having it up on the screen, because they can sit there and look at it, and you can methodically work through the points and make the point, apply the evidence to the different factors, right? So you have the law up there, and you're not lying through it.
Yeah, he makes some choices.
To wait. You do not have to wait. If you're facing, in your mind, a reasonable imminent threat, you don't have to wait.
I'm gonna mute because I'm gonna make a lot of tap tapping.
And this unconventional form of physical restraint to block the attack of George Torres. What did she say?
Wait, hold the fuck up. Whoa, hold on. Wait, she used this non-conventional form of restraint? That's a turn of phrase. Wow. Whoa.
He does kind of make it sound like
It's a very interesting way of saying she zipped him in a fucking suitcase.
Yeah. It also makes it sound like this is some sort of other play gone wrong, which, it really isn't.
It's not. It's terrible. It's terrible. All right, Ian, you can mute because I can hear the tapping. I'm going to keep going. And the only reason I can laugh at this now is now that I know that she's convicted. What the fuck am I hearing?
Oh, I mean, I was laughing at it at the time because I knew she was going to get convicted. The only question was whether they were going to finish their dinner.
It's all there. Now, you got to think about that. You got to think about what was going on. You got to think about the trauma she was undergoing. You got to think about they've both been drinking. And you got to think about the fact that it was all fun and games for a while. And I think the biggest thing to know is that George Torres chose to get in the suitcase. He's a grown man. That was his choice. She didn't force him in at gunpoint to get into that suitcase. He voluntarily got into that suitcase because they were drunk and being silly and stupid and playing hide and seek. Which I guess when you get so drunk, that seemed like a good thing. Zipped him up, they're laughing, carrying on. And as you know, Sarah likes to videotape a lot. And I know you've seen some of these videos and you're wondering why. But I
The
think
hide and seek story is just so bullshit.
George is being videotaped, he's not going to do anything.
you think about that. When George is being videotaped, that's like her power. You know, Dr. Harper said that Sarah's words are her power. Sarah's words are her power. Physically.
Also, murder. Murder is her power.
But that's her power. Sometimes. When she gets a chance, to have some control. That's what she does. And she videotapes, because she knows when she's videotaping, she can tell it like it is. I can tell him what I want to tell him. A couple of these videos you've seen, she's telling him like it is. But she's got that video camera on, and George knows. He's being videoed. We've got one we're going to show you a little bit, where he loses it. Just a little bit. Right there. And of course, we've got the TV. But they're kidding around, playing around. Then, Sarah realizes, okay, this is my chance to say something to him. So she sits down, she turns on the phone, and you've seen the tape. You've seen the tape.
No, you're not.
Yeah, that tape was not good, sir.
Are the first words out of Sarah's mouth when the video begins.
That's not helpful, sir. That sounds like retribution. That does not sound like defense. Why are you doing this?
I have a
That's great
theory
idea when
for
you're a
why
defense
he's
attorney,
doing it.
repeating the prosecution's best evidence. That's the best idea. That's a wonderful idea.
I have a theory for why he's doing it. Are you ready for this?
Please.
The theory is he's not very good at his job.
I somehow knew that was part of the theory. I just thought for a second there might be a different part. What the fuck is happening?
There's a lot packed into those words. Think about that. For everything you've done to me.
Yeah, it's premised on retribution, not defense. It has a retaliatory connotation. Everything about that fucking sentence is not something you should be repeating. What are you doing? That sentence alone.
Yeah, that he is making a choice, and
he's choosing to refute self-defense.
Yep, it's really awful.
This is how it feels when you choke me. Now that's in direct response as a result of the abuse that she has suffered at the hands of George Floyd. She wants him, for that moment, to feel how she feels. She wants, for that moment, for him to feel how she feels.
Oh, it does get worse.
I can tell you, it doesn't go in the better direction at any point.
So he repeats the phrase that very clearly has a retaliatory connotation, and then he emphasizes that she wants him to feel retaliated against as retribution.
Yep.
Thereby
yes, sir.
completely eliminating any argument of self-defense.
Yep.
Uncomfortable. Lack of control that she feels when George is violent with her. Just for a moment, she won't give it to you. If you can imagine.
Oh my God.
Approach.
Oh my God. He then says, just for a moment, she wants him to feel. Are you fucking kidding? What? Why
I'm pretty sure the prosecution's objection here is objection. I think defense counsel's forgotten what side he's on. And
why are you putting it? What are you saying right now? What
the prosecutor's like,
are
objection.
You saying?
I didn't know I hired this guy. Like, he's on the wrong team.
So let me get this straight. He repeats the one sentence of the video that is probably the worst sentence because it has the retaliatory connotation. The premise of the sentence is retribution, right? Not defense. There's nothing in there that denotes fear, nothing in there that suggests an imminence of harm, right? He repeats that phrase. And then he doubles down and says that she wants him to feel like she did. Fuck. I gotta hear this again. This isn't real.
If you can imagine.
Oh, it's very real. It's just also very sad.
Uncomfortable. Lack of control that she feels when George is violent with her. Just for a moment, she won't be able to do it. And if you can imagine.
Just for a moment, she wanted him to feel that way. So, there goes the self-defense. Why did we have a trial for this long? What the fuck did we just hear? Oh, and by the way, the objection was drawn by the if you can only imagine. Can't do that. Yeah. Yeah, that.
And then it's turned off. And there's a 9-minute gap, 11-minute gap, whatever it is.
Oh, no.
Crazy. And I don't know if, of course, it's a syndrome, but she felt like she couldn't do without it. And let's say she videotapes it, and then it's turned off. And there's a 9-minute gap, 11-minute gap, whatever it is. I said 11, they're saying 9. I think if you count 2 of the other minutes. But there's 9 minutes that we don't have video. But what is Sarah?
Sir, we're lawyers. We can't do math. I'm sorry. And you're proving the point. So,
Now, if you remember when you listen on that video, George is talking in a normal voice. He's not stressed. Of course, if you're talking, you can breathe. She had said she had some air. And of course, she doesn't realize the situation.
did you just say if you're talking, you can breathe?
Yeah, I was saying pause, but I realized I was muted. He's
Did
like,
you just say if you're talking, you can breathe, and you're talking in a normal voice, you're not stressed? Did you hear the same fucking video we did?
I mean,
Are you?
he was clearly stressed because he's like, Sarah, please let me out. Like, Sarah, I'm dying in here. And the other thing is the whole, if you're talking, you can breathe, is exactly what police officers have said in every case of positional asphyxia or like crushing to death. Like, and the jury may well be thinking about about those past instances. So you've just basically pulled George Floyd and so forth into the, like, maybe don't invoke that kind of thing in your clothes. Like, I was just like,
just started horribly and it just keeps on going. Does it get worse? How can it get worse from here?
Well, you might have thought that it's as bad as it possibly could get.
It's not possible.
But you
There's no
probably
fucking
thought-
way. There is
you
no
probably-
way.
You probably thought that 10 minutes ago too, right?
I did. I thought it 10 minutes ago, but now I'm here. Now I'm here and I'm stressed out. And I don't like where I am right now because I feel uncomfortable. And it's like every decision is wrong. They can't make that many. There's not enough decisions to make between now and the end of his closing argument that could be that wrong. You're smiling though, and I don't like the smile.
The thing is, he could have decided to literally set fire to his tie, and it would be a better decision than most of the decisions he makes in this close. So
she has no appreciation of that. It's a canvas. All she knows is an old canvas suitcase. And she's got some, the 2 zippers removed or spread out a little bit. So she thinks he's not being serious. But eventually he gets angry. She gets angry, he gets angry. He says words to her, and then his hand starts to come out of the suitcase.
Oh, this is the time that's not taped.
She also said his tone changed. And I know everybody's got a cadence with their spouse or boyfriend, girlfriend, but you know what I'm talking about. We've got a way of talking to people. We've got a way, your wife, your husband. You know each
Sir, I don't want to know. I don't want to know how you talk to your wife or anybody in your family. I don't want to know. I've heard enough of how you talk to everybody else in this courtroom. We maybe don't go in this. We've all got a way of talking to each other. I call them the girls, and I say that she's a cute little innocent girl who can't possibly do anything.
I feel like his wife is communicating to him through
Just try a
like,
couple of things the way
you know,
just said it, right? Well, especially somebody as hypervigilant as Sarah and as hypervigilant as a battered spouse woman would realize that he can flip the switch at any time. When I get out of here, I'm going to end you. And he realizes he's getting out. He got his hand out.
Okay.
At that moment in time, in Sarah's mind, that's an imminent threat. So she's got a justifiable right to use force. What did she do? She went over there and grabbed it. She lifted it up. She tried to get his hand back in. Remember? She tried to get his hand to go back in. Wouldn't go back in. So her son's back was.
Wait, that wasn't the testimony. That wasn't the testimony. Wasn't the testimony that she grabbed the bat? I thought you grabbed the bat.
She grabs the bat to try to get his hand to go back in.
Yeah, but why is he doing this? Why is he doing that whole thing? That wasn't what she said.
I don't know. I mean, he's a whole thing. Like he's
But
a
the thing
whole.
is, he's made a somewhat decent point. The point that he's making right now is here is this act that she has testified to. Here's the foundational fact that I have that basically establishes that what I'm about to do by keeping him in the suitcase is a justifiable act of self-defense. We actually have somewhat of a foundation here. Now, is he going to finish the argument properly?
No.
3 feet away. Where the police found it the next morning. Same spot. No attempts to hide it. No attempts to delete phone. No attempts to tamper with evidence. Nothing. In the same spot.
No. Why would you put that in their mind? Why would you put that in their mind?
Oh.
Why would you say the word tamper with evidence? Why would you do that? Why? Why would you suggest that there might have been videos on George's phone that we didn't see that maybe she tampered with? What the Owens?
Yep.
Oh my God, I'm gonna die. Make it.
She picks up the bat. She pokes him hard, trying to get him to stop trying to get out. And eventually he does. And you've seen the blunt force injuries. And you saw some of the circular injuries where you could tell there's a poking. I think it's right around here. And she poked him several times. You remember the pathologist said, I think, maybe 5, 6, or 7 times. She pokes him. And he's got some.
How? Wait. How? He's in the suitcase. How, sir?
He says that she pokes her hand up, and like she says he pokes his hand up, and then
But he just pointed at her. He just pointed at his ribs. He pointed at his ribs. How, sir?
Oh, well, wait for that, because he's opened a whole door that the prosecution is going to be like, oh, that is great. I'm going to drive a van through here, and that van is full of gasoline, and now your case is on fire and also, run over by a van.
Because these are things that are very different than her testimony was. The hand came out of the suitcase, the hand got hit with the bat, and she freaked out. And that was where is the whole poking him with the fucking bat in the ribs? How was that missed? Or was this just something that he's just going on, he's just living on a prayer right now?
Whoa, he's halfway there.
he's more than halfway there.
Scratches. I don't know if they'll let you look at it, but on the back of that suitcase, it's got some bars, some metal bars that are inside of the lining. There's some lining, and it's for support when you walk in. She testified. You heard what she said. That she testified. That's uncontroverted testimony.
Wait, what?
Now, let's talk about the jury.
Yeah, remind the jury that George isn't there to give his side.
I want to talk about reason without for a minute.
I've got one.
Is it the wrong jury instruction? Please tell me it's the wrong instruction. Please tell me it's the wrong instruction. Did you print the right one?
Oh, you've watched his opening then.
Yeah.
He had the wrong jury instruction in his open.
We're going to talk about these without a minute, but if you look at those bottom three short paragraphs, it is the evidence introduced in this trial and it alone that you're to look for the evidence or look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence itself, a conflict in the evidence, or lack of evidence. But here's the main thing. You know, obviously, I represent her, and I'm trying my best to show you honestly and fairly the doubt in this case. And 5 reasonable doubts, 17 reasonable doubts, 25 reasonable doubts. You have to have one reasonable doubt. I'm trying to show you throughout the evidence that each one of you can have a different reasonable doubt. Difference, but one reasonable doubt about the state's case, and your verdict is not guilty, according to them. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere
I
possible doubt.
don't like how he reminded them I represent Sarah here.
Such a doubt does not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. And this is a deeply held belief. You know, reasonable doubt is the highest standard we recognize in litigation. You know, car wreck or something like that is preponderance of the evidence standard, 51% your time. Abiding conviction, that's a deeply held belief that you must have if you're thinking about something. That's a firm belief. That's a level of certainty that you would have.
Okay.
That's what you gotta have as a juror. I've got to be certain of her guilt. If on the other hand, if after carefully considering, comparing, and weighing all the evidence, which we want you to do,
Jury's like,
there
check.
is not an abiding conviction of guilt. I'm not certain. I'm not certain of the guilt. Or if you have a conviction, I think there's some evidence of guilt, but it is one that is not stable, one which wavers and vacillates. One which wavers and vacillates. Then the charge is not proved beyond a reasonable doubt, and you should find the defendant not guilty because the doubt is reasonable. You understand that? You've got to be certain of guilt. That's the high standard we recognize. If you've got some evidence of guilt, so okay, there's some evidence for conviction, but it's not it's not stable. It wavers and vacillates. Then under our system, you've got a reasonable doubt.
Okay.
And you've got the power and authority and the obligation under the law, if that's the way you feel, to vote that way.
I have heard better.
What a
reasonable doubt
horrible way of saying that.
I'm not sure what I've heard a worse one, but
we were both saying that's a terrible way of relaying that for the defense.
Yep.
Like he's like, you know what? You don't have to find the reasonable doubt, but if you do, maybe you do, maybe you don't have to, sir. Fucking like send it, bro. Like just can you?
You need to throw some passion into this speech, right? You need to talk about, you know, the higher purpose behind litigation. You need to all of that stuff. I really don't think he did a great job there.
And you know what? This is where you throw the mountain of reasonable doubt. This is where you say this doubt reasonable, this doubt reasonable, this doubt reasonable. This is where you give them every fucking opportunity to consider a doubt in their mind and to grasp onto that and say this is reasonable.
The problem is
like
he had nothing to say. Like,
just like if you feel like you want to like not convict her, that'd be great. That's what that was.
It'd really help my bottom line, folks.
No, you know what he probably said? You know, girls.
Oh,
you jury, you girls, if you girls have ever been, because those men are mean and scary, right? And you guys just want love and you're alone. Girls, you've been here before. What the fuck is happening? Oh my God, this is so bad.
Later in the instruction.
Yeah, this guy makes me want to violence.
You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You may rely on your own conclusion about the credibility of a witness. That is totally the province of the jury to decide.
Oh no.
The jury may believe or disbelieve any or all the part of the evidence of the testimony of any witness.
Oh no. Why are you focusing on that? Why'd you focus on
See-
that? Why did you draw attention to that?
Yeah, because the only witness whose credibility is really at issue here is Boone.
Yeah. Why would you draw attention to that? That's the only person. Why are you?
Suffers from battered self-symbol. Battered women's experiences affect her perception of imminent danger.
Okay.
Past experiences with George Torres. Those past experiences with George Torres, and there's a bunch, affect their perception. Remember, Michael Brandon talked about perception of imminent danger. Victims of repeat violence may fear death in situations others would not. The reason Sarah experiences all this, the reason she was feeling the way she was feeling, that imminent threat of danger from George was because of George Torres.
All right. I'm buying.
George Torres is responsible for her mental state because of the
I'm
way
buying what
he
you're selling.
violently treated her.
You're back on the train.
She reacted to his
I'm
attempts
still
to
like,
get out
check, please.
because of the way he treated her and the way she knows what is he going to do if he gets out of the suitcase?
When I'm saying I'm back on the train, it means he's back on like actually like making a somewhat cogent argument. Like he's back on the like I am making a legal argument, and it's like this is rational and
That's fair.
how you argue the facts. So I'm like I'm back on the train, sir. I'm like okay, here we go.
Yeah, there is an argument to be made here. Yeah, no, that's fair.
Yep. You've got me. We're going linear. Now where are we going to go from here? Because I'm really afraid that what's going to happen is
She knows. The second video is played. She's flipped it back upside right. You hear him, it's 22 seconds. He says, Sarah, she's not going to open that suitcase. She's not going to open that suitcase. He's already threatened her. She used the bat to get him to stop trying to get out of it.
Okay.
Why would she do that? Why would she do that?
Because she's murdering.
I know what he's going to do to me. I know him like I know him more than he knows himself. I know what he's going to do to me.
But that's not what you said at the beginning of your closing. You said that she wanted him to feel how she feels. You said that she wanted retribution. And now,
ladies and gentlemen of the jury, I invoke takesies backsies on the things I said at the beginning of my close.
that would be a very effective legal argument if we could make it. Like,
you don't have to wait. That was justifiable.
Correct.
Now, you got to understand this. She intentionally used the bat
oh no,
to defend herself.
oh no.
She intentionally didn't unzip it to defend herself. Both of those are lawful under our law. She went upstairs. The dogs were upstairs. At some point, she called her husband, her ex-husband, Brian Boone. We know that many times she testified, or somebody reports it, she would often flee to her ex-husband's house. So I believe that testimony came out.
You know what's really cool? When you are giving a closing argument.
I believe that testimony came out. You should know this, sir.
That part. That's, you know, what's really cool. The fact that you are constrained in closing argument to arguing the evidence that was adduced at trial. And you're like, I'm pretty sure this was said at some point in time. If it wasn't, you know, my B. Wow. So.
It's so bad. So bad. You're like, how can it get worse? It's like he's like, I meant to tell you guys this. I don't know what happened, dude.
Oh no, I was just thinking it. I was just thinking it. It's my bad.
Or somebody. Sometimes she would flee, or sometimes she would flee to upstairs. One of those two. But the dogs were up there. She made a phone call. At some point, she fell asleep, passed out, fell asleep. We don't know. They had 2 big bottles of wine, right? That was unintentional.
Oh my God. Yes. Please point to the bottles of wine and then say the word unintentional after the prosecutor, Cacciatore, just held the big fucking instruction up in the air that literally said voluntary intoxication is not a defense. Oh my God. Oh my God, oh my God, oh my God, what is happening? It is making you so happy watching me watch this for the first time, isn't it?
Uh-huh.
Oh my God.
This is just
That was unintentional. His death was unintentional. You remember when
You said the thing that was contrary to law. You literally said in the next sentence, you said the thing that was the exact opposite of what you just completely we are here.
Yeah, I mean, the charge is an unintentional murder.
you remember that? Now, I don't know if we did a good job of this, but it came out that she got arrested. You remember the one time when she got the black eye?
I don't know that we did a good job at this, but remember it came out the one time we got arrested with black eye.
Jury, we suck at our jobs. Like
Sir, I am wearing a unicorn hat and could have given a better closing than this with my knowledge of the facts. What the fuck is happening?
I feel like the unicorn could have given a better close than this.
It probably could have. You know what? Because you know what's more exciting than anything that Owens has said so far? These flashing lights.
This guy is great, though, for your imposter syndrome.
Oh, God.
Regulation. And you remember that? It was standing up over there by the dryer, and he was banging her back of her head on the floor that has very little carpet on it.
Uh-huh.
She ended up getting her arms out, and then she grabbed his neck. And she eventually got him off of her. And that's when he got up and stomped her in the eye. Remember? Well, the police came for that event, and they took statement, and Sarah was honest with the officers about what all, and they arrested her. You remember? Remember that? They arrested her.
Wait, what?
And she said, why? I was fighting back.
Wait, what?
You remember that? Why? I was fighting back.
Why are you
So from that point
saying
on,
that?
she didn't trust law enforcement. The video that they showed one of them.
No.
George.
No.
That was
No. Hang on. Hold the fuck on. What did you just say out loud?
Yep. This is all about choices.
Please tell me that he's about to use the trust of law enforcement into the whole I gave a statement, it wasn't voluntary. Is he going into this?
Nope.
about dropping the case, where she was defending herself and fighting back. I want to talk about this investigation by law enforcement. Now, she didn't know the law. She's not a lawyer. She gets up the next morning.
So what's your excuse?
I was gonna say this is gonna bring an objection. He's getting close. Ignorance of the law is not you cannot raise this. Is he about to get to like some ignorance of the law as a defense?
He kind of stares away from it.
Okay.
A little bit, but it's not
Sarah's
great.
got to pick up Lucas at 3. Brian's calling. Eventually she walks down. She's looking for George. Where's George? He's quiet down there. And she looks in the bathroom. She looks out. He's smoking a cigarette. He's on the computer. She sees the suitcase. And you can imagine.
Objection.
Sustained.
She sees him in the suitcase.
Yeah, can't imagine.
She panics. What does she do? What she do? She tries to get her fiance out of the suitcase. They're engaged to be married.
the rule that is being objected to right there is you cannot ask the jurors to put themselves in the position of any of the individuals in this case. You cannot ask them to imagine what it would be like for them. That is improper. You are not allowed to do that. That's objectionable. That's why that objection was made when he said you could imagine.
Trying to kill him. They're engaged to be married. She gets him out. She tries to do, he's purple. She tries her best to do CPR. She doesn't, you heard her, I didn't know what to do. I didn't call Brian. That's her safety valve. That's all she's got. Brian eventually says she's come over. She calls again in 2 minutes. I'm on the way. He gets there. You got to call 911. Man told her before. Call 911. She calls 911. She tries to do CPR again. Is she busy trying to hide evidence? She's busy trying to hide evidence.
I feel like Brian is the guy from the Matrix.
Trying to save his life.
What
dodging
the
all
fuck
the
are you
bullets.
doing?
I don't know what he's doing.
That is twice in 2 separate occasions that he has drawn attention to the non-existence of evidence and how his client might have led to it. And the CPR thing. I'm pretty sure it was clear that she wasn't giving CPR.
The thing is he can't say it was clear she wasn't trying to give CPR because she said she was, and that would be calling his client a liar, which would probably be accurate. But yeah.
If she can. So the police get there. She knows if she told them she fought back, she's going to be arrested. That's what happened before. What happened before? Like George said on the video, she'd never been arrested before. Before that time she was charged with that with George. She lies. She lies. She's scared.
Wait. You take a long pause, and you come back with that? Like, long pause. She lies. And the jury's
She
probably
lies like
"Mhm."
she breathes, which
Exactly.
is more
And
than
every
George.
juror for the first time during Owens' entire closing, during the first time for Owens' entire close, every juror is like this. Mhm.
Yeah.
Mhm.
He sees
She
all the
does.
nodding and he thinks he's doing well.
Yeah. He's like, I'm winning. It's like the Ralph Wiggum version of I'm winning. And you're like, oh my God.
She's scared. She doesn't know what to do. So she lies. She makes a decision to lie. Don't trust law enforcement. She doesn't know the law. She doesn't call a lawyer.
This is improper argument.
She talked to Officer Rodriguez, was the first black female the first one that arrived on the weekend. Talks to her. There's a report statement there where she doesn't tell the whole story. She lies. And then the detectives eventually get there and get her in the squad car. You hear the audio. I think it was played. She lies again. Then the next day, she goes down to the sheriff's department. Now, if they would have told her, hey, man, I'm going to arrest you. And she gets a lawyer to go down there and make a statement. And the lawyer would advise her.
Sustained.
Yeah. What the fuck are you doing, bro? Are you fucking kidding me? No. Why are you talking about some random hypothetical outside of the... What is wrong with you, sir? Also, take that tone of voice in your eyes right now and deflect it elsewhere.
Do you have time to get the list of what's wrong with him? Because I gotta
It's like
sleep
looking
sometime
back at the
tonight.
prosecutor like, you dirty prosecutor. I'm like, bro, wait a second here. One, you were talking about, thank God that recording, that interview was recorded because, I don't know, maybe that interview that was recorded might have caught your client making an inconsistent statement, which it fucking did. So I wouldn't be thanking anybody for that except your client for not shutting the fuck up. And 2, why are you talking about a hypothetical of what you would have advised her when you were a lawyer? You know what you should have been? Well, this is the Bulls' defense, but it's not the Bulls' defense.
I mean, the Bulls' defense is to go into the room and then take a nap.
And let your client say all the same things they were going to say?
Yeah.
Yeah. So, you know what? If she had a lawyer with him and the lawyer was Bowles, then she would have said the same shit. I just saw that. Have you noticed the Sharpie edit to the post? You mean the redacted name over here? Why is
Yeah.
it redacted?
I don't know. I think that might have been redacted because did they have a witness who didn't get to testify? I don't know. It's
I
weird.
don't know.
Stricken.
Now, if they
I
would
want
have
to
told
see
her,
this again.
hey, I'm going to arrest
Yeah.
you, and she gets a lawyer to go down there to make a statement.
Because he like looks at the thing is this is a every lawyer knows this. This is a completely improper statement. You can't fucking say this at all. You don't have to be.
And the lawyer would.
Like, I can't say this in a closing argument in front of a judge, not a jury. I can't say this.
And we're going to arrest you. And she gets a lawyer to go down there to make a statement. And the lawyer would advise her.
Objection. Facts not in evidence.
Sustained.
Move to strike.
Stricken. The jury will pay no mention or give any weight to that statement.
He's so frustrated.
And that brought an instruction too. That wasn't just an objection and move on. That was an instruction.
Yep. And he's just like so frustrated. And it's like, sir, this is your problem.
Like we all went to law school. We know that you're not allowed to do these things.
Non-lawyer. She didn't have a lawyer present when she made the statement. She didn't know the
Okay.
law. She didn't know she was justified in defending herself the way she did in this dysfunctional, toxic, abusive relationship.
That was cutting it close, but he did okay.
Yeah, he wasn't arguing the ignorance of the law is a defense.
Close.
He's saying she lied because she was ignorant of the fact that the law would have covered for her here.
It's really close.
Yep,
Hang
but
on,
he's
hang on.
okay.
This bears explanation. Ian, explain. This bears
So-
explanation.
Ignorance of the law is not a defense. If I don't know it's illegal to punch Rob in the face, it doesn't allow me to punch Rob in the face. And the reason why is because otherwise it becomes a superpower to be the dumbest person on the planet. Because if you are the dumbest motherfucker out there and you don't know shit about law, then you get to start murdering people and stealing stuff and all of this. And your superpower is being extra stupid. And so the law doesn't want to allow for this super stupid person to just have full power over everything. And so ultimately, we've said, no, you can't use ignorance as a defense. But here, the distinction is he's not saying that ignorance is a defense to the charges. Instead, what he's saying is she lied because she was ignorant and didn't know better. Right? So, as an example here, let's say I'm breaking into my own car because I left my keys in the car, so I'm sitting there jimmying open my own car. That was a bad hand gesture. Let's not do that again. So I'm sitting there jimmying open my car, and a cop pulls up, and I run away, and the cop is like, "Why'd you run?" And I'm like, "Well, because I know it looks real bad. I was making a bad hand gesture." It's similar to that, right? It's like, I don't have any reason to run away because I'm jimmying my own car. You know, similarly, they're saying she didn't have a reason to lie. She was actually in the right legally, but she lies because she doesn't know she's in the right, or she's worried that the officer is going to arrest her. So, yeah, that's kind of the distinction there. It's an important distinction, and that's the reason why the prosecutor doesn't stand up and be like, he's doing it again, judge. So,
Right.
yeah.
This is really it's the way it's phrased. I have to pull it up. I just saw it. Wait, one was catastrophe. No robs were harmed in making this hypothetical person that was closing. Two was Jeremy Morton. Good thing she took the plea deal. Wait a second. I'm being handed a note.
Oh, geez. Yeah.
And the scary thing is the chat was saying, Rob, there's more. I don't know if I can handle it.
And you were like, how could there be more? And the thing is, there's always more. There's just more and more and more and more and more. And then, yeah.
You know what? You have to admit the spinning wheel has not been a big problem tonight. It's like one or twice, but we're fine. I mess with it a little bit. So
She said, you know, not intentional.
And eventually, she wanted the detective, it was Detective Lowen, the male detective. And she said, I swear to you on my son's life, it was not intentional. What she was talking about was that George passed. Was that George died. That was not intentional.
Wait, what?
She thought he was fine in there. Would he sober up? We've learned from their history, when Sarah gets drunk, she calls for help. When George gets drunk, he beats Sarah. That's their pattern. How many times did we see Sarah call along?
Wait, what?
How many times did we see her beat George?
No, wait, what? Did he just say that he was just going to sober up in the suitcase?
Yeah.
No. No. No, no, no. No, no.
Was it George died? That was not intentional. She thought he was fine in there. Would he sober up? We've learned.
She thought he was fine in there. He would sober up.
Mm-hmm.
I can't breathe, babe. Sarah, I can't breathe.
Oh, Rob, you're fine. Breathing is for closers.
From their history, when Sarah gets drunk, she calls for help. When George gets drunk, he beats Sarah. That's their pattern. How many times did we see Sarah call along?
You know, he rehearsed that line and thought it was a good line.
That's their pattern.
He really did.
Sarah told me. I didn't know. I think she said, I didn't know something like this could happen. I've never done it before. And Detective Lowen said, well, what did you expect that was going to happen? I've got a daughter that she.
Nope. Nope.
18 or 19, she got,
Nope.
She got a
Objection.
down pickup truck. It was an older truck, but
Nope.
Objection. We don't need your personal story.
She didn't put any oil in it. Eventually, it burnt them up.
Nope. Where are you going?
You don't know what you don't know. I haven't done anything. I've explained it. Hey, you got to put oil in it too.
Wait.
Sarah Boone didn't know that he could die in there. It's an old beat up canvas suitcase that she left a gap in.
Hang on. What the fuck was that analogy? I need to go back and hear that real time. What did he just say? Were those words? Did that make sense at all?
It certainly
Did
wasn't a
anyone
Runkle
understand it?
analogy. Runkle analogies are spicy, but on point.
What the hell was this?
She was about 18 or 19, and she got a grandmother's hand-me-down pickup truck. It was an older truck, but she didn't have it long, and she was gassing it up, but she didn't put any oil in it. Eventually, it burnt them up. And you don't know what you don't know. I hadn't done a good job of explaining, hey, you got to put oil in it too. Sarah Boone didn't know.
So now he's telling the jury that he's a crappy father.
So let me get this fucking straight. You are hang on.
Jury, I did some bad parenting.
I need this for the analogy. This is the analogy right now. This is the analogy. Here's the analogy. The analogy is my daughter didn't know that she had to put oil in her truck in the engine.
Can I just say how
I'm getting there.
Like
my daughter inherited. My daughter was 18 or 19. So she was 18 or 19. So this is years after she learned how to drive, arguably 18 or 19. And she inherited this older truck, and she didn't know that we're back in the whole ladies not knowing stuff, but she didn't know that you had to put oil in the engine to keep it maintained, or the engine would burn up and it would seize. She didn't know that you had to put oil in it. And you know what? That's on me for not teaching her to put oil in the engine. Otherwise, the engine just wouldn't work.
Meanwhile, it's on George for not teaching Sarah that
that
you need air to
suitcases-
breathe.
that suitcases are not conducive to human life. So we have a car engine and oil, and then we have Sarah not knowing that an individual zipped in a suitcase that is 28 inches by 20 inches by 8.78 inches and 7/8 is somehow not conducive to breathing.
If only George had explained this to her.
So, sir, where did that fucking hypothetical, where did that come from? How did you get there? Why is my brain goes all over the place? Ian's brain goes all over the place. There is not a fucking world where we would have found that hypothetical to somehow make that point.
Well, because it's so bad. So bad.
It's the car engine. The car engine wasn't working. There wasn't oil in it, and therefore George wasn't working because there wasn't air in him.
You gotta change the air every so often.
No, that's the equivalent. The engine stopped working because you stopped putting oil in it. George stopped working because I stopped putting air in him.
And if you let her out, she'll probably put air in her next boyfriend. Via, like...
what the fuck?
It's an old beat up canvas suitcase that she left a gap in. And as naive as that sounds, she didn't appreciate the danger.
How about when he said, I can't fucking breathe? Several times from inside a fucking zipped suitcase.
But Rob, people say all sorts of crazy things when they're dying.
I mean, is that the way you want to kill somebody? Is that the way you're going to do it? She had
Oh my God.
Lewis to take care of it. Am I going to go to
Wait.
prison doing it like this? No attempt to hide the crime. I think the evidence is clear. That's how.
Oh, it is, but not in your favor, sir.
I don't want to belabor the point. I do want to show you.
Wait. I don't want to belabor the point. Sir, I don't think you know the meaning of that phrase. You used it inappropriately. You did not use that right.
If you don't want to belabor the point, you're going to need a time machine and a shotgun. And it's not going to end well for you.
Just quickly show you, Andy.
You know when the time to bring the photos in was? When I told you to do it at the very fucking beginning. Because you know what doing it now does? Nothing. Nothing. Zero. What?
He's so far in the hole that at this point they can't even see the pictures.
Mama Bets, I'm glad you're finding this enjoyable. I am just... I'm glad you're here and finding this enjoyable. This is ridiculous.
See, Rob, the secret is that I'm doing some crafting while we do this.
Yes, it's a good secret. You're enjoying my meltdown and loss of sanity while crafting. You know, I imagine there's some people in the chat that are doing the exact same fucking thing, doing their crafting and enjoying my meltdown and loss of sanity.
I mean, I recommend it.
See how Boone got stabbed?
Okay.
Stabbed with a steak knife in the leg.
Yes.
And she stayed with him.
Yeah.
She stayed with him. Poked between the eyes with a curtain rod.
I don't know if I'd have focused on the curtain rod.
I wouldn't have
'cause
done that
just-
photo.
That doesn't look so bad. It's
I
like
wouldn't have done that photo. This is what happens in my domestic cases a lot, where people are throwing like, this was terrible. I'm like, I get it. As you describe it, it's not great. It's horrible. But it's not.
Don't.
That part that doesn't look good.
yeah, stick to the two really good pictures, the stab and the, you know, there you
That's
go.
not good either. That's yeah.
Just the one where she's kind of like smirking and has a little tiny mark there.
Now we're going back to notes. Oh, we're going back to the desk. What do we forget? Nope.
The law empowers an individual to defend their life and safety when faced with a threat and
We
to
did this.
prevent an attack.
We already did
Sarah
this.
Boone did. That's what Sarah Boone did.
You said it like 8 times. You're not going to find it. If you haven't found it yet, you're not going to find it.
He's rambling. He doesn't know where he's going. He doesn't have any plans.
You've lost every point you had.
Yep.
Find your bullet list. Find your bullet. Every lawyer you're supposed to have the bullet list. You're ending. You got it. Where is it? Why is your binder undone? Why are you pulling shit out of your binder? What is going on? Wow. Nope. Side note, I've been here. I think every trial attorney has been here at some point in time in their career where you all of a sudden need something. And usually it's when you're far younger in your career, but you are making a closing argument, or you have a judge ask you a question and you're looking for that one case that you swear to God you saw like 5 seconds ago, or that one note that you knew you had, and you can't interrupt your own chain of thought to get back to like some logic, be like, I'm not going to find this right now. I need to dodge and get out of this and move on. He's in the weeds and he's lost and he can't find his shit. And right now I am feeling anxiety for him because I've been there. It's not fun. But this is what the experience brings. You have to be able to prep this thing and be able to go back to your list of things you have to hit.
Dude, he's got experience. He was Methuselah's lawyer. And that's
Probably
where he
did all
learned
the-
how
all
to
those-
treat women, was from
I was
Methuselah.
going to say, he probably did all those trials that adjudicated what rights women had back in the.
And he's still bitter about losing.
Problem is, once you're here, you
I think
have
it's
to go.
important to understand
Oh no.
Sarah had to be the parent a lot of times. It was her place. She had that $1,000 a month from the divorce settlement coming in. She had the car. She had the phone. She had the keys.
Where are we going with this?
She had to be the parent in a lot of ways.
Where are we going with this?
I note that she uses the past tense for the $1,000.
Multiple
her
times.
Her ex right now is like, my finances just got better.
Do you remember, Dr.
Well, what the fuck was that? What the hell was that? Much ado about nothing. She had to be a parent sometimes, and then we're going to talk about Dr. Harper. What was the point of that statement? And then
Harper is from Okaloosa County, which is up in the Panhandle, close to where we're from.
And she's the doctor that treated Sarah from early on. Remember, this happened in 2020. I think she first treated.
Is he falling asleep? Did he just forget like everything about the case? What?
He's like, I don't know how I got here. Will you buy
It's
me
like this
something?
thing. I think this happened in 2020, and you're doing a closing argument in a fucking murder trial.
Guys, this also applies if you're doing a closing argument in a regular murder trial.
You're such an asshole. I love you, but my God.
I first saw Sarah Boone shortly thereafter. And over the 4.5 years, saw her 9 times and did all the testing for post-traumatic.
Oh, we're gonna do the times for the times. We're gonna get an objection, aren't we?
She's testified that she's now just traveling around the state, testifying as a forensic psychologist. But
are we?
You know, she talked about how important it was to develop trust with the patient over a course of time. It's just going to take time when you have somebody suffering that kind of trauma and that kind of damaged psyche. It's going to take some time to get them where they can trust you and really tell you and talk to you and tell you what's going on with them.
You mean like George?
Talked about, you know, Sarah uses her words with power. I think the testimony. I think the evidence supports that her testimony was credible.
Objection.
Emily, Owens couldn't find the point if it stabbed him in the fucking chest. What is happening?
He is so lost in the weeds, and I don't even know why they, why the prosecution's bothering to object, because he's like just rambling
look at what it does to the
incoherently.
poor man. Look, he's a deer in headlights right now. He's angry. He's upset. He lost his notes. He had his notepad. He had a cogent thought 50 years ago. He equated changing the oil out in his engine to changing the air out in George.
He needs like a warm milk and a blanket and a nap.
The evidence supports that her testimony was
Objection
credible.
is sustained.
I can't get my person. The evidence.
No, you.
To be
also
fair,
can't
so do
tell the
I.
jury- No, but you also can't tell the jury why the objection was sustained. You're not. He literally, listen, this. I'm surprised Judge K didn't ream him a new fucking asshole for this.
He's doing it himself, though.
I know, but listen to what he does.
I know.
For the chat, just to give you an FYI, when a judge, when someone objects and a judge sustains the objection, you can't look at the witness and say, the judge sustained the objection because I asked you a leading question, or the judge sustained the objection because what you were going to say was going to try and, oh my God. He literally here. This man is not on the same planet as everybody else.
He's a walking remedial law school exam question.
I think the evidence.
He gives. I think he's giving his own impression.
I think her testimony. I don't think, but I think the evidence supports that her testimony was credible.
Objection.
The evidence supports that her testimony was
Objection
credible.
is sustained.
I can't give my person. Okay.
It's that part.
Yeah. Yeah.
And the thing is, he actually corrects the statement. Instead of him saying, I think, He then comes right back and corrects the statement. He says the evidence supports.
And
It's
then
like,
he goes
great,
and
Owens, you're doing great. And then immediately he goes, I can't tell you what I think about the evidence. Even the court reporter right now is looking at him going, Mr. Owens. Mr. Owens. You guys, and for anyone in the chat that's saying I'm being mean to him, I did not know what this was going to be. I am not. I think he had a closing argument that he could have made. There was an argument to make here.
I'm being mean to him, but because he deserves it.
The girls thing was pretty shitty. Not just pretty shitty. It was like really bad. And it wasn't just that. That was what set the tone. And the tone hasn't changed.
The evidence supports that her testimony was credible because of the time that she spent, because of the number of tests that she did, that she diagnosed with post-traumatic stress disorder, alcohol use disorder, I think that anxiety disorder, and battered spouse syndrome. Dr. Warner confirmed that. And, Dr. Michael Brannon, the first witness, he was brought in as a subject matter expert. So he hadn't treated Sarah. He was just testifying about the condition. He's been doing it a long time. He's an expert at it. And that's to advise you to try to understand what's going on.
What was that?
That's him explaining the limits of like why he wasn't
As
allowed to
crazy
ask
as
the
it
expert
sounds,
for.
in this syndrome,
Yeah,
they
he's.
try to protect the abuser. They're in love with them. They try to protect them. I don't know if you remember that there was a time where Sarah Boone had a conversation with one of the neighbors, and they were talking about something. And she said, "Did you hear anything yet last night?" Remember, she said, "Shh, it's okay."
No. Why are you saying this?
Both George and Sarah lied to the police. They lied
Wait,
to
what?
medical people.
Wait, what?
I don't know if it's shame. This comes with the syndrome.
Wait, what?
He quotes the shh.
I think another big, if you'll think about this, when Sarah gets beaten by George, she calls the police.
You said this.
When Sarah gets beaten by George, she calls the police. And a lot of
You
times,
said
she just wants him out. Just get him out. Get him to leave. She doesn't want him to get in trouble.
Okay.
She just wants him out. There never was a report of George calling the police on Sarah.
Okay, now you're a piece of shit.
Mm-hmm.
Are you fucking kidding me?
Gloria is saying, give us examples. How would you argue this better? He could have done a better job by walking in there and laying down to have a nap. I mean, I could do a better closing. Like, I could try to improvise a closing, but a closing takes some time and prep.
I fucking hate this argument. I despise this argument. I shred this argument every fucking time. I hate this argument with the passions of a fucking thousand suns. It is the worst, most disgusting argument you can see in domestic relations litigation. It is horrible. Well, how many times did you call the police? Well, you didn't call them at all, did you?
And often that is consistent with victim behavior.
Correct. This is despicable. Every lawyer that pulls this shit, I absolutely try to fucking shred every single time. It is disgusting. It is horrible. Tell me you don't know a single fucking thing about domestic violence without telling me you don't know a single fucking thing about domestic
I
violence.
mean, the thing is, I think he knows. I think he's just willing to mislead and deceive here. The other thing is, I don't think you can shred this guy because he's self-shredding.
He has already shredded. He's done. He's roasted. But are you kidding me? This? And now the reaction by the chat is now suggesting that I think I know where he's going right now.
Oh,
And
Rob,
he's about to
you
get
sweet
into a
summer
place
child.
that is going to. Is this how he's going to try and end his closing argument in front of a jury of 5 women and 1 male? Are you out of your fucking mind, sir? Are you crazy?
I'm just putting the leatherwork down for a moment just so I can really.
Is he really going to try this?
I'll keep watching.
She wasn't physically abusing it. The state is trying to present evidence. Is she emotionally abusing?
Sustained. Stricken. Members of the jury will pay no attention to that comment. Give it no weight whatsoever.
I believe the evidence that's been presented by the state.
Sir, correct your fucking self. Don't respond back to the judge who just sustained the objection and gave an admonishment. Turn the fuck back around and talk to the jury. Yes, I'm saying this angry because of what you just said. I'm sorry. I apologize. I will listen further.
Is an attempt to show that Sarah mentally or emotionally abused George Torres. Again, she's not charged with that. She's not perfect. Some of that was her trauma. In Sarah's situation, you do become numb and hardened, I think, over time. That's a coping mechanism. It's a day-to-day thing, some good days, some, you know. But the homicide detectives, I know if you saw that 2-hour video, at some point during the 2-hour video, they started talking about some of the violence. And they go, we know. They had already checked with neighbors or whoever. They knew. The neighbors knew. Police officers knew who responded. Torres' family knew. They all knew about the abuse. Dr. Harper testified that abused women act differently when they perceive a threat. I think Sarah Boone was loyal to a fault to George, even through all the abuse. Judge, I want to make a comment about a couple of things that were said by the prosecutor in opening statement.
No. What the fuck are you doing? What are you
He's
doing?
asking for permission.
No.
When he was talking about.
Wait, what the fuck were you doing? What were you doing? Why are you doing that?
He's asking for permission.
George Torres passing away and started talking about Sarah Boone. And his quote was going to write it down. George, in Sarah Boone's mind, George Torres deserved it. George Torres deserved it.
Tell me you're ending this fucking closing argument with retribution. Tell me you're ending this with retribution.
Oh,
You really just you went there right at the beginning. You were like, this was retribution. I'm like, well, there goes self-defense. And you're ending it with reminder, this is retribution. Well, there goes self-defense. See you later. So you're gonna begin strong for the prosecution and close strong for the prosecution. So begin strong by saying wanted him to
that's why I was
experience what
saying
she
that
experienced.
the prosecutors seem to be objecting that, objection. My colleague seems to have forgotten what side he's on. Like objection own goal? Is that a thing?
That's the position to take. He deserved to die. She loved the man. She went to try to kill him. He also commented about.
Yes.
Wait, did he just characterize their argument as that? That he deserved killing?
Mm-hmm. That's exactly what he did.
He just why? It's so disjointed that it doesn't. Oh, this is the judge ripping him a new asshole. This is a long sidebar. Wow.
Mhm.
This is
I
the
think he's
judge
like, are you going
tearing
somewhere?
into him.
Violent nonsense.
Oh, I want this sidebar. I want that sidebar.
Prosecutor said in Oakland about. Prosecutor said in Oakland about the violence, the violent episode.
That's a proper argument. The prosecutor said this.
Mm-hmm. When you're correct.
It's a bunch of violent nonsense. Was his statement to you in opening statement. All this here, photographs, is a bunch of violent nonsense.
No, that's not what he said. That's not what he said.
There were a couple of exhibits that I introduced late, and they were no contact provisions, where there had been a court order from a judge, not only a verbal order, but it was reduced to writing. So there was a court order for George Torres not to have any contact with Sarah. Okay? Court system got involved. We would have no contact with George Torres. Now, I need to talk a little bit about that. And they talked about coercion, coercive control, power and control. Power and control. We know about his abuse. We know he destroyed the home, the TV.
You guys, I know that you like watching me melt my brain right now and my brain disintegrating. I have to pull up some of these chats that are non-question chats because we've been streaming for 5 hours and 12 minutes. I didn't think I was going to be going this long. It's 1:47 a.m. my time. I've got to start pulling these chats up. I'm going to get through his closing. I have to at this point in time. I'm committed. But I have to pull up some of these chats. Thank you for everything you guys do to the channel. It's amazing. I love it. And thank you guys for supporting each other. All of it. It's wonderful. I love seeing you guys here every Friday, and thank you for all you do. If there's a question, I'm going to save it. I am trying to get through this and do so with my sanity intact, but I don't know I'm going to get there because this has been about as wild as I didn't think it was going to get this bad. So, I'm just giving you the warning because I'm going to start pulling stuff up as we go through because I'm realizing that it's almost 2 a.m. my time.
We know about his jealousy. You know, some of the things he said to her. We know about how he treated her dogs. Nicely when he was sober, but at times he abused the dogs or threatened to do so. If you think about power and control, when you're controlling a person, and I think she testified that he kind of smothered her, always around her.
Timmy Lynn's a
Part
master.
of his fear was her realizing that she had enough and to leave him for good. That she would get the strength over time if she had enough time away from him where she wasn't in control of it and he wasn't in control of it. Enough time away, she would come to her senses and realize she could do better.
Judge has been giving court orders all week. I didn't stop George Torres. George Torres knew he was going to lose control.
That's not a
She
bad
had bunch of
argument.
Time away from him. She might move on. He was willing to violate a court order to maintain.
That's not bad. That's not a bad argument. That's a pretty good argument. The judge, you've heard the judge give orders all week. This is a person who violated court. That's not bad. This is actually some common sense. I'm scared of where he's going to go from here because every time he started down a common sense argument, he's lost it real quick.
Take control. That's your choice. I want to show a couple of videos. I want to say something to you. Shelby Andrews is going to help me. If we get dim the light. Yes.
Oh no. Oh no. What are we doing?
Do you understand? As of this moment, and until I can get you out, get the fuck out of here. You're a rookie. I dare you.
Did you see
Yeah, look at it. Wait, get away from me. Get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder.
Did you see him flip the switch? In that instance? Where he lost it, even though the video was going. Show the next one.
Now, right after this, he gets real tired and has to take a nap, but they cut that out. The other thing that's interesting is how he turns the TV towards the camera.
Yeah.
And that made me think, like, if you're doing this out of rage, you don't turn the TV towards the camera.
I don't know.
Given
I don't know.
everything we've
I'm not-
seen,
I'm not- I have no
wonder
context.
I wonder if she told him to smash his TV as a punishment. I don't know, but I wonder it.
I have no context. Do you know how many of these fucking videos I've seen where you catch a snippet of the video and you make an assessment based on what you see in a snippet? And then if you had watched the full 2 hours leading up to it, you would have a completely different understanding of what transpired. I hate these, especially in interpartner relationships. I hate these. And when people try to play them out of context or play snippets of them, when the prosecution did it, I hated it. When the defense does, I hate it. I hate it because you can't view these incidents in a vacuum. And I hate the availability of this video. People say the video and the photos are necessary, but here's the fucking problem is it doesn't, you never get the full story ever. So I'm looking at something and I don't know what I'm seeing. I don't know if this is a joke. I don't know if this is violence. I don't know what it is I'm seeing. That last one, I don't know what I'm seeing. I don't know if I'm seeing someone grab a phone after being hit. I don't know what I'm seeing. I don't know anything. You're giving me a snapshot of something that looks horrible. And I agree with you. It's fucking horrible. These two were horrible to each other. They were fucking, I mean, they brought the worst out in one another. The alcohol, you watched them in these videos. It didn't matter if you saw a snippet or the full thing. Tell me that they were not the worst version of themselves when they were around each other at all.
No, I mean, it's I've seen way too many of these relationships, so
And that's what I'm trying to say. You've seen them too. I hate it. I hate seeing these videos without context too.
Thank you. Thank you, Judge. You turn it off. Can you turn it? Ladies and gentlemen, I'm gonna finish up right here. And Sarah Boone, I've gotten to know.
Objection. Proper argument.
Sustained.
Yeah, why are you can't give your impressions?
Equal justice under the law. She's to be treated like any other citizen. Fairly and impartially. Based on the circumstances she was facing at the time of this tragedy. Based on the battered spouse instruction, which is a special instruction that's given when women have a heightened sense of fear and trauma that you're utilizing in applying her subjective standard with a reasonable standard of what a reasonable person would do under her circumstances and using the force that she used to defend herself. I hope I hadn't missed anything. I tried my best.
No, sir, you got it all. Just
Don't-
know that all of it was.
Don't tell the jury you tried your best. Nobody cares if you try.
We ask that you
I got to
do
give the
justice
rock
to this case.
speech here. You know, losers talk about trying their best. Yeah, I'm not going to finish that one because, yeah, but like, don't tell the jury, oh, I tried my best. It's so pathetic. Yeah.
You know what? You know what the end of this closing argument makes you feel? It makes you feel sad, but it makes you feel sad that you have to reach the conclusion that you have to reach, which is Sarah Boone did this.
Well,
Like,
he's fishing for sympathy, but it's entirely
It's not.
inappropriate.
It's leading me to a somber conclusion, and I hate the conclusion. I don't like it, but the conclusion is that this was an act of retribution. This was one more act in an act. You know, if you view this interpartner violence as being boom, 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 right? Which is, a lot of it is back and forth. Sometimes mutual, sometimes one or the other. Then what Sarah Boone did was arguably just escalate the next incident of interpartner violence.
I mean, I don't hate the conclusion that she's got to go away for.
I know, no, it's the right conclusion. It's the right result. But everything about this closing argument just took the whole idea of self-defense and threw it out the fucking window. There is no way any reasonable jury could come back with self-defense after hearing that closing argument. Usually I say the closing doesn't do a whole lot, but my God, what was that?
Oh, I mean, he's doing a whole lot in the close. It's just some of those things he should be doing not to be helpful.
If you thought Cacciatore was the reason for the hour and a half, shit, it was Owens.
I think Emily was like, "How long has this close been going on? It's been 85 years."
This is heartbreaking.
And find her not guilty because the doubt is reasonable. I've tried to show you where the doubt was. I trust your judgment. We spent a long time picking the jury, 4 days. We trust you. We appreciate your service and your obligation to do your duty. You have the
I
power and
trust you
authority to
too.
right
You
this
did.
wrong. That's what we're asking you to do. And give Sarah Boone some hope for a better life.
Oh my God. It is a better life. It's behind bars where she's sober and without access to anything that she can do. Oh, this is gonna be funny, isn't it? This is gonna be funny. Yeah. So I'm gonna take a break here, and what I'm gonna do is I'm gonna give the story about my week in trial. My trial. So I had a trial this week. I'm gonna swoop to this one because we're gonna watch Mr. Jay give that little pep in his step again, but I'm gonna give you guys a little preview to that. So swoop to that. All right, I had trial this week, and best cross examination I've ever had in my life. So I represented an individual who was the responding party who had a motion filed against him. So previously married, and the individual I represent, the former spouse, the ex-wife, was receiving a certain amount of support that was being paid. And the ex-husband was the one that said, I can no longer afford to pay the support. I can't afford to pay it. I can't do it. It's not possible. Now, the support was supposed to be paid for a period of 4 years. It was supposed to be 48 months. And I went through the financials and went and saw the transactions, his lifestyle, what was going on, what he was spending his money on. Why couldn't he afford to do this? And holy shit, I saw why he couldn't afford to do it, because it was a whole lot of money he was spending somewhere else, all kinds of places. So opposing counsel and I have a very good working relationship, and we're very organized, and they bring in, they're going to present their entire trial via laptop. I never have the courage to do this. I'm always nervous about it because I always want to have that paper in front of me. So they're presenting their entire trial by laptop. So they have a hookup to the big monitor. So they're scrolling through and presenting exhibits, and the judge has it in front of them. And here I am watching and tracking, and I have a thumb drive with the exact same exhibits on my computer, and it's working pretty well. Well, the counsel starts asking them questions about the different expenses. So I start in one of the files, I can look at it and I'm like, this looks like it's not a scanned document. It looks like this is an actual converted image into PDF. Like it looks like it was just downloaded from a bank statement. So I'm going, I wonder if this is searchable. I wonder if the exhibit that I have in front of me is a searchable image or a searchable PDF of the entire financial transaction history of this individual. So I hit Control F. Lo and behold, up pops the box, and I start typing in the different things that I have previously highlighted in my binder of financial transactions that seem to be a little bit irresponsible. So I Control F. Lo and behold, there it is right there. And all I have to do is hit Tab, and it goes to the next transaction of the exact same name. Well, this becomes very interesting to me. And they finish their direct examination. And Ian, you'll appreciate this one. When's the first time you ever try out a technique, like a new technique, live trial? Pretty scary,
I mean,
right?
it's where you got to try it, because there's not really a practice arena for this stuff.
Yeah, but it's scary, right? Like when you're trying it like for the first time. Yeah, not
Oh,
fun.
100%.
So I'm now nervous as shit because I have a laptop in front of me and I'm not used to this device in front of me while I'm arguing a case or cross-examining a witness, because I have my notes and I have my notepad, but I also happen to know the different transaction names, what occurred. So this person who says they can't afford anything, I start asking questions about what they pay money for. And they start saying, well, here and there, we live very reasonably. We don't spend a whole lot of money. We don't travel lavishly. We've only traveled twice in the last 22 months. Really? Twice? Where? Florida to visit our parents. Huh. Are you sure? Yeah, it was only twice. So I give it a shot. Control F. I type in United because I know that I've seen United transactions. And lo and behold, in that little search bar that pops up at the top of Adobe,
Or hotel.
I see in the search bar at the top of Adobe, I see the number 1 of 23. I was like, oh, well, let's see. Tab, 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 tab. And I was like, this was a trip you took that month, and then the next month, and then next month, and all of a sudden, I was going, this is pretty interesting. I wonder what else this little Control F function can do. So I then ask, what about subscriptions, right? You had a Butcher Box subscription. Like, that's pretty pricey, $185 a month. That was a long time ago. How long ago? Control F, Butcher Box. tab. Well, you only canceled that, what, 6 months ago? Okay. Any other subscriptions? And now I'm about to get to my the moment I've kind of been waiting for this thing. Any other subscriptions? Not that I can think of. About coffee. You have coffee, right? That comes to your, of course I know this. Lawyers don't ask questions they don't know the answer to. Well, yeah, I do. How much is that? $25 a month. That's not that bad.
You don't know the answer to, or that can't possibly hurt you. That's my rule, is that sometimes there's questions that just doesn't matter what they answer.
You ready for the next question, Ian?
I
What
cannot
about
wait.
OnlyFans?
Oh my
this
God. How much
person
is he
has
spending
now-
on bathwater?
He has now remarried. And his new spouse is 8.5 months pregnant. And I was like basically saying, I love the fact that this person is bringing a new child in this world. It's phenomenal, but it's not supposed to come at the expense of an obligation you already had. So I said, what about OnlyFans? No, absolutely not. Oh, baby. So
Maybe
I
it's
start
her
leaning towards
OnlyFans subscription.
I start leaning towards my computer and opposing counsel. You know, you get the feeling when they're getting close to the edge of their seat, about to pop up and like jump on you.
Yeah.
So I start walking over to my laptop and I hit Control F, and I can like just see her out of the corner of my eye moving closer to the edge of her seat. And I start typing. And you can see him getting nervous. And I type in OnlyFans, and lo and behold, it hits. And she is out of her fucking chair as fast as you can imagine. Objection, blah, blah, blah. I was like, Judge, they brought these expenses at issue. This is them opening that door. And the judge goes, counsel, you did have him testify extensively to this. And I was like, oh yeah. And I was like, there's my green light. And then I happen to know this person liked suits. So I found the clothier, which was a custom suit and shirt maker. And what's interesting about it is they had a very specific name that shows up in the accounts under a very specific spelling. I knew the spelling. So, sir, it's a very lovely suit you have on. Where did you make it? Or where'd you get it? It's a custom suit. Huh. So what is this company here? Oh, they make clothes. Okay. What kind of clothes? Dress shirts, ties, pants. How many times do you say you used them in the last 22 months? Handful? Well, let's see. Control F. At this point in time, I'm not saying he was a trained dog.
Rob, did you ever get to say survey says?
Wait, no, not yet. No, I didn't. But Control F. And I type it in and 23 hits. That's very interesting. So I start tab 785, tab 564, tab 1,257, tab 354. Boom, 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 boom. And I asked the guy who's sitting there, and he made the very bold decision of wearing a very lovely suit to court. Very lovely suit to court on a motion that he was filing to stop paying support.
Yeah, that's the day you wear a trash bag.
Well, I asked him about the suit and who made it. He said, I can't remember the name of the company. I said, well, was it this company? At this point in time, his spidey senses have now been alerted because, well, I've trained him. And he says, yeah, that's the company. And I said, $2,235. And you spent it on this day, right? Yeah. It's interesting. Said, well, it's a custom-made suit. Custom-made suits is what they make.
How much was he spending on the OnlyFans, by the way?
Wait. The OnlyFans was nothing. The OnlyFans was for shock value. The OnlyFans was to train him.
But how much?
I'm not going to divulge that. But this suits. So the $2,200 and something, right? So I said, so that's that transaction. And then 2 months later, you have another one of $2,350. Said, so you had to get more suits. And he goes, no, the first one was the down payment. The second one was the final payment. And I was looking at him and said, $5,000? Yeah. Well, sir, how many suits did you buy? One. Does that happen to be the suit you're wearing right now? Yes. Cross-examination continued in that vein for another 25 minutes. And I was wearing my new hardware on I like cufflinks. That's my favorite thing. I like the personal cufflinks. So I was wearing my new dinosaur cufflinks. So my client made a very astute observation because the prior day when I was prepping her, I was wearing my frog, not frog. Yeah, it was the frog, my frog cufflinks. And I walked into court and her best friend was there, and her best friend saw it and was like, "Are those dinosaurs?" And the client pops up and says, "He was wearing frogs yesterday." And the friend pipes up and says, "So do you wear predators on court days?" And I was like, "Huh, never thought of it that way, but I think I'm going to start." Like, so I now have to teach a lesson to the rest of our paralegals of when you are populating your exhibits and sending them out to opposing counsel, maybe just let's start encrypting them. Like, make them do a little bit of extra work to find the information.
I was gonna say, if I get a non-searchable PDF,
I'm
first
OCR.
thing I do
yeah.
is I OCR it, and if I have to, I will print it. And the other thing is, if I get one that's got like encryption and limitations, the first thing I'm doing is filing for. They need to send this without all that bullshit. OCR, somebody's asking, it's optical character recognition.
Yeah.
So, like, when I download a PDF from court, sometimes you'll get like Carrie Morrissey's, things which are just like she printed it out and then scanned it. Well, you can OCR it, and then the computer will find the letters, and then it can then it becomes searchable. So, yeah.
So I gave you this part of the day. Towards the end of the day, the judge is giving his remarks towards the end and says, "Look, there can be a material change in circumstances in two regards that would justify a modification of support," right? So material change in someone's ability to pay. And it says, after the extensive cross-examination by Mr. Morton, let me just tell you before you begin your closing arguments that I am not inclined to hear any argument on that issue. I was like, okay. And then he starts saying, and on the other topic, and this is after closing, on the other topic, material change of circumstance in the need for the support. And he makes the comment and says, I'm finding there has not been a material change. And I hear the opposing party's mother, who was a witness that testified in the back of the courtroom, opposing party's mother goes, "Are you kidding me?" I hear her from the back of the courtroom, which means the judge heard her too. And the judge, after making that ruling, the judge goes, "Mr. Morton, I assume you want to be heard on fees." Pop my ass up out of that chair. "Why, yes, Judge, I absolutely would." Go through the argument on attorney's fees. And the dad of my client had been paying the attorney's fees. And, because of that, based on rules in Virginia, you're not getting those fees that have been kind of gifted by a third party. You're not getting back because you haven't been out of pocket. You haven't been injured. The court doesn't find that an injury. But the court said, but you haven't been paid for the fees of being there today. So the court said, I am going to make a partial award for the fees that have not yet been paid by your client's father. Not been paid by your client's father. So, Mr. Morton, I'm going to award $5,000 in attorney's fees. And I hear out of the back of the courtroom, what? Payable within 90 days. And then I hear the opposing party's new wife say, fuck. So the court renders their ruling. Everything's done, and opposing party snaps up out of the chair, leaves the courtroom really pissed off. And the first person, my client's looking like sitting in shock. which makes you, it fills you up, like it fills your chest. It just makes you feel warm that you did this thing to protect them. And the first person at the bar, like the behind me, behind council table, is the father who's paid all of these fees and who has heard that they're not going to, get them back. And he sticks out this hand that's a bare mid of a hand and gives me probably the strongest gripped handshake I've had in a long time and says, "That was amazing. Thank you."
That is
And
nice.
and the best friend who was there as the emotional support human, the best friend said, "That was totally worth me taking the day off." Because she was allowed to sit in. She wasn't a witness. She was exempt from the rule on witnesses. She was allowed to sit there and watch the roasting. She goes, "Did the second you said OnlyFans and got him on that?" Because I will remember that face for the rest of my life. I was like, yeah.
Oh man.
So there are these moments. The reason I make this comment here is a high stress poker. And when it goes well, it goes well. And that whole popping out of your chair. Mr. Mort, would you like to be heard on fees? Why, yes,
You bet
Judge, I would. Your ass fires out of that chair because you are riding this high. Same thing as the control F. And you just basically say, well, let's check about that. And there's a pep in your step that's so natural. You can't hide it. You can't fake it. So you're flying on this high and adrenaline where
So I gotta ask.
Quicker. Yeah.
Did new wife know about the OnlyFans, or was that a surprise?
And she was out of the courtroom because she was yet to testify.
Oh, damn.
I'm not gonna, it wasn't my intention. I'm not about that. When she took the stand for a very limited purpose, and I blocked a lot of her testimony, but she was, of course, she was wearing
asked her.
I know. I didn't have.
Did you know everything? Did you know he's wearing a $5,000 suit today?
She was 8.5 months pregnant, my friend. And the thing is, she knew because she was wearing this really. And the thing is, she was 8.5 months pregnant, happy with the upcoming birth of their new child, and it was. But the problem was she was wearing this beautiful black dress that was very form-fitting to show the belly intentionally. And that also allowed me to roast the husband, which was saying, so here's the thing. You say these expenses are there. Do you shop at Sephora? What about
Rob?
Lululemon?
I'm also being told I'm required to show you some things.
Oh, the bots?
This is the first one. And, they're in, I was like, I don't want to take them out of their bags if they're sealed, but no, they're bags that open. So,
what?
Little devil bot with
Kristen, you have outdone yourself. That is so good.
With a tail and wings. So that is awesome. But there's more. There's way more.
This is like the fun. This is the good part of there's more. This isn't the Rob part of there's more.
This is not the I'm being cross-examined and there's more, because cross-examination is the worst time for there's more. All right. So we got this one. We're going to remove from bag here. So this is a, it's got a brain worm. It's got a solo cup.
That's
and
solid.
It comes with a second brain worm.
Awesome.
Kristen was like, you can't put these online until, like, Rob's got to see these live. So we're doing that. All of these, by the way, are up for auction on the, are on that. Oh, and there's a butt dial cell phone. Somebody said amazing work, Ian. This is not my work. This is Kristen M96.
Yep. Kristen makes all the bots. I've got the bots. Ian's got the bots. So you can own a bot.
There is Nightbot.
Oh, that's clever.
Yep.
That's really clever. Nightbot. I like that. That's very clever.
So that I was like, oh, that. At first I was like, what is this? And then I'm like, oh, it's Nightbot. And we've got Vampire Bot, I'm guessing.
Oh, that's
It's
cool.
got
I like the
one
tooth.
fang.
The tooth's really cute.
It's got horns. It's got wings. So
I like the
another,
tooth.
and we got one last one, which I got to dig out here and show you. All of these are going to be up for auction. All of these are going to be there. Oh, I'm being told it's a dragon bot. With hot sauce.
You put the gray hair on him. It's terrible. It's so funny, though. Totally, that's. Because that one's gonna get the most out of all of them because of the fucking hair.
So it's
Oh,
a
God.
Rucklebot 3.0.
That's so good.
Oh, and people are saying the other one is toothless. Okay, I got it. I got you. So yeah, this is the Rucklebot. You can see it's got hot sauce and food that can fight back.
Okay, so we're gonna watch the first 3 or 4 minutes of this part of the closing argument because
you're gonna
pull up
watch
rest
the
of
first
chats.
3 or 4 minutes, and then you're going to be like, I have to watch the rest of it.
No, I have to pull up the chats because I can't keep my mods here that long. I've been
fair
streaming
enough.
for 5 hours and 46 minutes. That's the problem.
You're gonna be astounded when you see him, or when you see it. 'Cause-
He's already. I can tell by the pep in the step. It's pretty
Oh,
good.
he comes in ready to fight. So
Well, that's what I'm saying. So we're gonna rewind this. So that whole like lawyers having a pep in their step, man, we are built. It's not that we're built to fight. It's
Oh, I mean, sometimes you've been prepping something and you just know it's like, and you just get that feeling of like, I get to walk up. I had one where it was a cross-examination and this person had basically said nothing that was useful to me right up until just the end. And just at the end, he dropped something that was like demonstrably false. And I was like, oh, good. And now I get to get up and just like, so you testified to this. And he's like, yep. And I'm like, isn't that not true? And he's like, no, it's totally true. I'm like, you sure? And he's like, I'm totally sure it's true. And I'm like, here you go. It's false. And then you just get to beat up on the guy. Because at that point, you're like, isn't it?
Part of it's just waiting for them to open that door. And when they do, you're ready to just jump on through. Ms. Rob's Dan, yeah, I was confused too. You can't really say it's unintentional when you said it was intentional. So, all right, here we go. Let's back up for a second because there's a courtesy that Jay does. This isn't a real courtesy. This is you're about to get fucking roasted courtesy where he gently gives the thing back to Mr. Owens. This is a watch the fuck out because I'm about to kill you.
Any rebuttal?
Yes, sir.
You may proceed.
Are you able to hear me?
Yeah.
Okay.
Mr. Owens, here you go. You take this. Don't worry. I won't need it. You're roasted. She can make money on a book, I think. Oh shit. Coming in hot.
Yeah, he's just like,
ladies and gentlemen,
thump.
George Torres is dead because the defendant believed he deserved to be zipped shut in a suitcase so that she could make him feel how she felt when he cheated on her, when he choked her, and to hold him there as a captive audience, according to her testimony. Now he has to listen to me. Well, right out of the gate, there are credibility issues. Cheating to me means human pornography. Well, we saw cheating really means women. And the heated conversation on June 14th about these women in Facebook. And that is what leads to the arrest on June 15th. He's out whoring, Candy Crush, all
Sorry,
these other
Jeremy.
things that you see in her phone. He uses the legal system as a weapon at times. There's no denying that they are engaging in violent behavior. And it is over nonsense. It is smashing TVs. They call the police and then they're standing there looking bewildered about what to do and who to say and laughing and joking. Ladies and gentlemen, the courtroom is a place for justice, not a suitcase. The reason we have a jury system originally started with the idea that the king, the crown in England, shouldn't be able to go and incarcerate citizens on his whim. So it developed into a system where citizens would have to say, yes, you can take our fellow citizen. But the opposite is also true. A citizen cannot take another citizen's life because he or she feels.
All right. I love this. This is great. Phenomenal beginning. Love it.
Oh, I mean, he I feel like he saved a lot of his best clothes for the rebuttal.
This is really good.
Oh, it's amazing.
This is a good start.
Yeah.
Likewise requires a jury to decide that it was objectively reasonable for a person of ordinary prudence
Congrats,
and
Book
caution.
Dragon.
Like Mr. Cacciatore argued earlier, battered spouse syndrome is not a license to kill. Past grievances, even being stabbed in the leg, so on and so forth, do not give her the license to kill. There are still
Yeah, we
laws in
played
place
that earlier.
about
Thank
when
you.
and how this can be done in
Yeah.
a justifiable manner. I want to talk about the most important jury instruction in this case that has not been discussed very well or thoroughly. Excuse me. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself. And we'll stop at that comment. The facts of the case that came from her own mouth, if she is to be believed, and we will explore thoroughly why you should disregard every bit of her testimony, from court to the detectives, to the 911 operator, to the doctors. Her testimony, if it is to be believed, the most favorable light that she has presented of herself, is that at the end of a Sunday fun day, where we are drinking, we're outside by the dartboard, we're doing puzzles, we're doing arts and crafts, and there finally comes a point in time where we're gonna play hide and seek. And he says, tag, you're it. Even though she's it, she goes upstairs, hides in the shower, eventually gets tired of being there, it's cold, so on and so forth, and she comes back downstairs. And as she comes back downstairs,
I
she
prefer
can see
Monday fun day.
Torres fiddling to place
Come
himself
join me
inside
on
the
Mondays,
suitcase to try and
folks.
hide for this game.
Yep.
The lid is not closed, it's flapping. And out of jest, out of levity, undisputed according to her testimony, she comes over there and zips it shut. Whether it's 100% or enough for 2 fingers to get out, that is something that you decide as the jury.
Roasted. She's fucked. This is so good. It is just cutting through the bullshit and getting straight to these moments. This is so good.
Yep.
Where was
he's
this?
just-
Where was this Will J? Where was he?
I mean, he's coming in with fire.
So much better.
But there came a point in time where the fun and games was over. And Mr. Torres told her that. Babe, I can't breathe. Sarah, babe, let me out. This is all on video. We don't have to imagine this. This is all on video. 1062. At that point in time, she is using force against him that is not justified. She is the initial provocateur. She is the aggressor under the law. And what level of force is it? I can't breathe. Not let go of my hand, not get your hands off me. I can't breathe. This is no different than 2 people, maybe they're buddies at the bar, similar to an example given by Mr. Owens, who are wrestling, and one has another one in a headlock. And there comes a point in time where the person on the receiving end of the headlock says, that's enough, I'm tapping. George Torres was tapping, and she ignored it. And she was kind enough to tell you why. Out of anger, which translates to hatred,
Not to tell you.
ill will, spite, just like that in jury instruction for second-degree murder. She told you exactly why. She got angry. Him saying, I can't breathe, babe, was what triggered her. Not a fear of imminent harm. Those are her own words. That is the law. These are the two paragraphs that solve this equation without getting up on a big whiteboard in college that's 30 feet long, 15 feet high, and a ladder, and somebody's scribbling Latin words and Greek letters for months and months to solve this huge, complicated equation. The equation is solved in two paragraphs. She is the initial aggressor. He is saying, I can't breathe. It is no different than a naked chokehold that she does not let go of. And she told you it's because I want him to listen to me. This is my bully pulpit. This is how he made me feel in the past. She doesn't describe it as teaching him a lesson, but that's exactly what she says. I want him to feel like I
Krista, November 2nd is the auction. November 2nd is the auction.
felt in the past. I want to tell him things. Ladies and gentlemen, we can play semantical games, but that is teaching him a lesson. Therefore,
Oh, thank you, Crazy Cat Queen, for the information. No, she can't profit.
because right now, plain as day, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threat and use the force against herself. And what force are we talking about? Well, the threat of force that she tells you she was facing was him fighting for survival, him sticking his fingers out of the suitcase, him sticking his hand out. That is the threat of force coupled with, I'm going to end you. Well, ladies and gentlemen, she is the initial provocateur. She is the one using deadly force against him. If I have somebody in a rear naked chokehold, they are entitled to use deadly force against me to break that chokehold.
Sir, I'm going to need you to
until we're
stop
separated.
saying naked.
He had every right to say what he said. He had every right to exist and stick his hand out and try and survive to breathe another day. However, the use of force is not justified if you find that Sarah Boone used the force to initially provoke the threatened use of force against herself, unless she does one of two things. And she did neither. Not even close. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. All right, let's give her absolutely every benefit of the doubt, which you should. This is a criminal prosecution. The state of Florida has alleged she committed murder. You need to do everything you can to look for reasonable doubt.
Wow.
Put a reasonable doubt,
Yeah,
an imaginary
he's
doubt,
confident.
forced doubt, speculative.
Wow.
He is super confident here. He's like, you should totally give her the benefit of the doubt and still convict the hell out of her.
Jeez. I love this close. This is so much different. Pep and Step, like, just give her every benefit of the doubt. Give her every single benefit you can. Shit, disagree with everything I tell you, but you still have to reach this conclusion.
Oh, this is like the second murder that we've seen in this trial.
Gosh, this is amazing.
Doubt.
But this goes longer, right?
So accepting that all their past history, accepting the doctor's testimony and the limitations on what they reviewed compared to what we reviewed. We did a much more thorough review of the relationship than any of the doctors did in this case. So let's give her that first clause. Because of their past relationship, with George now fighting for his right to exist and saying that he will end her if he gets out, we'll give her that. But just like Mr. Cacciatore mentioned earlier, lawyers' words mean things to us, and they mean things to everybody, but really to us. Or an and. There's an and. Had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. She did not use every reasonable means to escape the danger that now, after provoking him, that he was presented to her, according to her. She didn't pick up her cell phone and start walking, call 911. She didn't do anything other than, if you believe that is why she called Brian Boone, made a phone call to Brian Boone, and unfortunately, because of past history, he just ignored her phone call. She did not exhaust every reasonable means to escape this danger that she created. She started it. She created this, other than using the deadly force on George Torres. Now, this is a weird situation. This is not a rear naked chokehold. This is a suitcase, or as Mr. Cacciatore said, a box, or actually more aptly described it as a coffin. And when you secure somebody into a box or a coffin, you can still exert that deadly force on them from a distance. I'll give you a quick example from a couple of movies that I love. In 1977 in May, a movie came out called Star Wars. They eventually called it Episode 4. In the first scene, there is this large imposing figure that wears black armor. He is a government agent, and he is looking for some stolen classified documents. He picks a man up who he believes is responsible for this treachery, and breaks his neck and chokes him to death when he doesn't tell him where the plans are. We all understand that. That is direct force we all understand. But what we understand is the force she's exerting from the couch.
This guy
And
is.
then when she
I
goes
love
up
this guy
to
because
bed,
he's
she is
obviously a
still
total
using that
nerd.
force on him. She set
This is what?
This guy's he's talked about house rules. He's now like referencing Star Wars. This guy's a nerd.
And the Force, and he's all about it. Now I understand why he didn't want to give the fucking press conference. He doesn't like the press conference.
these implementations into motion and did not stop. So later in this movie that came out in 1977, another co-employee of this dark, imposing figure, Vader, insults his religion. He does not go to HR. He takes matters into his own hands and chokes this person from a distance. Ironically, while we're talking about force, it's the force. And then in the subsequent movie, he's like doing it from his office. He's killing his incompetent employees on different ships. Force, deadly force, can be exerted from a distance in this situation. So whether she's on the couch or whether she turns in for bed, she is still using that deadly force on him.
He is HR.
Every reasonable means to escape this danger. Do something. You started this. You put him in the position where he cannot breathe. She's required by law to do something about it. Not something, everything. There was no efforts in this case. None. Or, in good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed the threatened use of force. That did not happen. She never withdrew from physical contact. She is still, like Vader, choking him from the couch, choking him from bed. She never withdrew that force. Physical contact includes any restraint on George Torres' movements. She never indicated that she wanted to withdraw. Sarah, babe, I can't breathe. All right, if I let you out, are you going to come out peacefully? Since I started this, I'm the one that made you not be able to breathe. That didn't happen. So, ladies and gentlemen, this entire analysis about deadly force starts and ends there. She was the provocateur. These are her obligations when she starts it. She put him in fear of death. He is literally telling her, I cannot breathe. A couple other things about the law. Second-degree murder does not require a proof of intent to kill. Argument was made repeatedly that she didn't intend to kill him. That has never been the state's suggestion. Because
I hate that I have to do this. I really hate I have to do this.
What do you got to do?
It's 2:37. How long does he go?
I don't think that far.
All right, I can go for like 5 more minutes. I'm told I have to see the bat. Where's the bat? Does he really pull the bat out?
I don't have stream ending powers, so otherwise I'd be like, Rob, go to bed, and I'll.
No, yeah, Ian can't end my stream. I have to be the one that ends the stream. And I've been going for 6 hours at this point. I think this makes the longest FNF in quite some time because we've watched the full ass and not full ass. I can't say that anymore around you.
I mean, you can, but there'll be consequences.
I know. There's a problem. Consequences.
won't belabor this since it was discussed earlier, but did the witness have an opportunity to see and know the things about which the witness testified? Even at trial, she admitted that she was intoxicated for the first time. She went back and forth with the police about whether or not she was intoxicated and her standard of drunkenness and whatnot, but she was so intoxicated that she still felt the effects of it at 1 PM the following day. The medical examiner told you that alcohol dissipates in the average person. Everybody's different, tolerance, all sorts of things come into play, but on average, 0.015 grams per deciliter will dissipate every hour. So you can do the math. 0.015 times 14 puts her at 2.5 times the legal limit. For those reasons alone, you should not believe anything she told you. You should not believe anything she told the police. You should not believe anything she told the doctors. She was at 2.5 times the legal limit. She has a gap in her memory that's unexplained when I brought up the photograph at 11:03. You can't have it both ways. I don't remember 11:03 to 11:12, but I was upstairs in the shower hiding. Does the witness seem to have an accurate memory? Well, this ties into what we're talking about. But again, there's a glitch in the matrix, 11:03 to 11:12. Her memory is not accurate. By her own admission, I don't remember.
You had Star Wars and Matrix. Okay, sorry.
She tells the police, when they show her the video. I don't remember that happening.
He is a total nerd.
Was the witness
I love
honest and
it.
straightforward in answering the attorney's questions? I submit when we got off script, and by we, I mean with both attorneys, she wasn't as honest and straightforward as when it was a very directed and smooth examination. I came out of the gate with something that was off script. Tell me about Pamela Erickson. Tell me about Christine. Tell me about Crystal. Because she's the one that said cheating to her meant pornography. Well, ladies and gentlemen, you know, she knew exactly who those people were and that she believed that he was cheating on them with her. And apparently she is too with some guy named Ben. When I describe this as a violent, nonsensical relationship, that's exactly what it is. It's not to downplay the violence. She got stabbed. She had minor surgery. It got infected. Those injuries are real. But they just don't apply in this case. They just don't apply when you use that self-defense instruction when she's the aggressor, if it's to be believed.
Oh, no, that was the appropriate use of that. That was so good. That was the appropriate use of an argument. Why is that objectionable? No, sorry, you're fucked. That was perfect.
It's the liar objection. On what grounds? Because this is absolutely destroying my case.
He literally says, like, no, all these things happened. Everything that they said happened. All of it happened. It just doesn't fucking matter. That's what he says. Because this all happened. It just doesn't matter. Because it didn't matter here. She has to know. Right here. She has to know at the end of these closing arguments.
Let me say it loud and clear. Bad spouse syndrome does not have any effect on this case. It has no relationship to this case because she is the aggressor. She zipped him shut in the suitcase. After he said, I couldn't breathe, she wouldn't let him out. Therefore, all of the instructions above that paragraph of however do not apply. They do not apply. Now, turning back to what I was saying.
Look at
Did the witness have some interest in how
he's
the
up
case
there
was decided?
smiling.
Well, of course. 3 out of 4.
Oh, he's like, this is awesome.
Indicated to the judge, fear of punishment was more important than the fear of public speaking. It speaks for itself. She has an interest in the outcome of the case. Now let's talk about, does her testimony agree with the other evidence in the case? You do not have to accept this story. Let's pretend, as you should, because all 6 of these things, we haven't gotten to the inconsistent statements. Let's pretend her testimony doesn't exist, and you just have to look at the circumstances. The testimony from the defendant.
Oh, baby.
George Torres' head is here. You can stand if you need. You can sit a long time too. His head is here. His butt is kind of down here. His feet are here.
Wait, he's holding to stand up. Okay, so they're standing up. Hang on. 1.25.
And his hands and his knees are up here. He's in the fetal position, if we remember right. The hematoma on his head is on the left side. The bruises, the deep bruises on his back are on his left side.
Holy shit.
You hear that? That's solid. You don't have to.
He just fucking kicked it over. He did what she said she did. Holy shit. No, he didn't.
Hands and his knees are up here. He's in the fetal position, if we remember right. The hematoma on his head is on the left side. The bruises, the deep bruises on his back are on his left side. You hear that? That's solid. You don't have to accept that she put those marks on him when he was in there. The evidence doesn't support it.
Yep.
You can conclude she used his bat when he was outside the suitcase.
Oh.
You don't have to believe her. When she said they were playing hide and seek. You don't have to believe her because she doesn't know the rules. She came downstairs, saw what she had done, and had all the opportunity in the world to clean up whatever mess may have been at the bottom of the stairs. But ladies and gentlemen, physics doesn't lie.
I told you have to watch
Can't
this.
expect you to believe her testimony about the loud boom being the day before compared to her 2 neighbors who weren't drinking, who have no interest in the outcome of the case, who suffer from none of the infirmities of her testimony. She suffers from all 6 infirmities. When her neighbors say there was a loud boom that night, there was a loud boom that night. Did it shake the wall they shared in common? It shook the wall that they shared in common. Did she have any injuries consistent with being dragged up and down the stairs the night before? No. You saw the pictures the CSI took. You don't have to accept her story about hide and seek.
He couldn't have gotten to any of this as if Owens didn't kick the fucking door open. None of it.
Thing is, he
Owens.
planned all of this. This is
this was planned, but it was planned with Owens kicking the door open.
Oh, I mean, he basically just yeah. He
Owens
just waited.
came in and we talked about it. Not once, but twice Owens came in and talked about Sarah didn't falsify evidence. Sarah didn't hide evidence. Sarah didn't change evidence. Sarah didn't do these things. Owens came in and made that comment twice.
Yep.
And we paused. I paused. Both times he did it.
Thing is, I think he planned to do this from the outset.
I don't care. The way he just did it right there was fucking beautiful because it takes away the objection. You're right. If there was not any of what if there's not any of what Owens had said, that would have drawn an objection. And I did. I was watching the judge, the people in the chat. I was watching the judge. Judge was perked up and he was ready to rule on something. He was waiting for an objection there. I don't know why he didn't get it because holy crap, you cannot let that come out of the prosecutor's mouth unchallenged. Hell, I would have objected to him hitting the suitcase with the bat. This isn't a time for demonstratives. You can't do that shit.
I think he can.
I don't know.
Pictures
what the fuck happened?
But ladies and gentlemen, physics doesn't lie. She can't expect you to believe her testimony about the loud boom being the day before compared to her two neighbors who weren't drinking, who have no interest in the outcome of the case, who suffer from none of the infirmities of her testimony. She suffers from all 6 infirmities. When her neighbors say there was a loud boom that night, there was a loud boom that night. Did it shake the wall they shared in common? It shook the wall that they shared in common. Did she have any injuries consistent with being dragged up and down the stairs the night before? No. You saw the pictures the CSI took. You don't have to accept her story about hide and seek. Something made that loud boom. It takes energy to make a loud boom. Energy that could very well be in the form of somebody going down some of the stairs, all the stairs, in the suitcase, out of the suitcase. But that's what the
This is fair game. He's arguing the evidence. This is fair game.
evidence supports is there was a loud boom that shook the walls and interrupted a FaceTime conversation that was so loud that the girlfriend on the other end heard it. Something loud happened. And then there was silence, according to the witnesses. And they can argue that Juan Torres' testimony was great for them. It's great for the state. She was screaming at him already at 7:30 p.m. She was already on her bully pulpit. And we know she doesn't need to put him into the coffin to get on her bully pulpit. There's video after video of her on her bully pulpit telling him how it's going to be, how you're going to live your life. Go take a walk. Do this. Do that. You don't have to accept anything she said. It's inconsistent that he received the hematoma to his head, his bloody mouth. How is his mouth getting bloodied inside the suitcase? That's protected from her and her bat. But that suitcase, a 100-pound drunk woman is not beating through the wood of that suitcase or whatever it is that's making that noise when it's thumped.
It's not wood.
Ladies and gentlemen, those injuries happen outside
Cardboard.
the suitcase. Ladies and gentlemen, somebody or something went down those stairs. She has no injuries consistent with going down the stairs. He does. He has blunt force trauma all over him. You don't have to buy her story, and you shouldn't. The inconsistencies, I'm not going to belabor it. Your dinner is waiting in back. Let's just briefly talk about the experts.
How'd you like that?
I'm sorry. I'm sorry for pausing. I'm not going to belabor it. Your dinner's waiting back there. Holy fuck. You're right. This is what he wanted to do the whole time. This was everything he wanted to do.
Oh, I
Holy
mean,
shit.
his initial thing, I think, is just there, and I think it's also partially to bait the other side into making mistakes.
This is ball game. I mean, this is it.
Yep, this is the whole thing.
Dr. Brandon was absolutely fantastic. He explained everything that you all needed to know about battered spouse syndrome. And this isn't about whether one of them or both of them had battered spouse, because at the end of the day, she's the initial aggressor and she had the duty to do the things that the law requires. But it does call into question the credibility of the past power dynamics of their relationship. Those videos speak for themselves. The officer in the last video asks him, dude, you're a guy. Why don't you do something about this woman, your wifey, who you don't want to rat on for beating you? He said, man, I'm not a beefcake. I'm not going to rat her out. There's countless examples, if you apply Dr. Brandon's testimony to Juan Torres, that really shows you the power dynamics of the relationship. He was her violent pet. Dr. Harper, I don't find much quarrel with what she says about battered spouse syndrome, and nobody should. I mean, she's the expert. But she's not Ms. Boone's treating physician. She's not her treating psychologist. The way it was described in argument, and I believe from Dr. Brandon's testimony, was she's supposed to be a forensic detective. Get to the bottom of this. She's going to come in here at trial and tell you her opinion you should rely upon. With 9 visits, she never asked the defendant what it is the victim said that put you in imminent fear of death or great bodily harm. That's the crux of the matter, Doc. You're never going to ask her what it is
You're a bad detective.
This grand jury instruction about threat of force or use of force. It's remarkable. And, you know, she didn't review everything that was presented to you. At the end of the day, it's your opinion that matters about this relationship. And again, we agree with Dr. Werner. It doesn't matter. She had the duty to retreat. She had the duty to take the chokehold off. And if it was too dangerous for her to directly take the chokehold off, she had the duty to do something else, everything in her power to stop him from dying, because she started it. She set it in motion. She used the force grip on him from a distance, the couch and from bed. It was her obligation to stop. She didn't. But Dr. Werner, she was called by the state of Florida after having evaluated and listened to the defendant give a similar story and concluded battered spouse doesn't apply. So she was never asked to delve any deeper into it. Given the information that she did have, the limited information, she agrees, yes, Ms. Boone has battered spouse syndrome, but it doesn't apply to the case because she was the aggressor and she did not fulfill her obligations. And really just your gut common sense. Go back to jury selection. In jury selection, there was examples about bullies day after day doing something to somebody. And somebody raised their hand and said, don't they have to do something that day? Don't they have to do something that day? And he didn't. After he was put in fear of death and told her he can't breathe, the imminent threat of great bodily harm and death she is describing to you is him fighting for his life to escape. She did not fulfill her obligations.
Wow.
There's details that matter. Again, not to belabor it. I mean, the evidence in the body-worn camera and the 911 calls, it's not offered to prove the truth of the matter of as who stated what. Who knows what happened between these two? You see them with the police. Can't believe anything they're saying. It's not offered to prove that she's a bad person. It's not offered to prove that Mr. Torres is a bad person. It's simply offered to call in question the reliability and credibility of what she said about the past. That's all that it's there for. But there are some nuggets and some Easter eggs. There was an argument made during closings that Mr. Torres knows not to do anything when being videotaped. Bizarrely, shortly thereafter, they showed a very edited clip of him attacking her and slapping the phone out of her hand. He knows he was being videotaped, and there was another video like it too. So to make the argument that he doesn't do anything, he's a good boy when he's being videotaped, it's belied by their own argument. They showed one of the videos. Learned helplessness. She seemed to control everything. I mean, his birth certificate, it gets torn up when he doesn't comply with her wishes.
Yep.
You'll see the rest of the text messages if you choose to delve into them. But I would suggest you don't have to, given the jury instruction about aggressor.
I get it. They didn't even have to read them.
Ladies and gentlemen,
he told them they didn't have to read them.
It has been a long 2 weeks, and you are making a very, very important decision for Ms. Boone, and a very, very important decision for Mr. Torres and the state of Florida and his family. He's dead. She killed him. She's admitting she killed him to have this affirmative defense if I was justified. It was not justified under our law. She does not get to decide that she has a license to kill because of her past grievances. The law requires her to stop using the force that she started applying to him. And she didn't. She didn't withdraw. She didn't tell him he was withdrawing. She didn't use every means available to try and stop this from happening. She didn't. and you know what was in her heart. She tells you it's hatred, ill will, spite, and venom. This is not a self-defense case under the law. Go back and follow the law. You cannot feel sorry for her. You cannot feel sorry for him. You cannot feel angry at her. You cannot feel angry at him. It's maddening to see their relationship. It is maddening. Nobody would want this life for yourselves or your children. It is violent nonsense, but it does not affect what she did and what her duties were under the law that night. She wanted to punish him. She did, and then she left him there. And she had an obligation, if you even believe her story about the imminent threat for him fighting for his life, she had an obligation to do something about it and not just go upstairs and let him suffocate. Thank you.
Thank you both. Members of the jury have some additional instructions.
Oh, fuck. Will J, man. Just
He,
go ahead and hit me right in the heartstrings. Like, just right in the, like, everything that we were saying about all of the different arguments being made one way or the other. Just way to lay it out in a very concise statement. This relationship was horrible. I wouldn't wish this on anybody, but it doesn't justify the conduct that was engaged in. I mean, that was no fucking wonder it was an hour and a half. You say the closings don't matter, but that last rebuttal close was it. That was it. That was the end.
The thing is closings don't normally matter. In this close, he's making new arguments that we don't see anywhere else in the trial. So yeah,
he did that because of how shitty Owens did.
Oh, he
You
came out
can't
just
get there.
punching.
Wow, that was something else. Well, you know what? Thanks, Will J, for saying what we all were kind of thinking. Like, we're not being gaslit. That's what he came into the jury. He goes, I'm not gonna let them gaslight you again. I'm gonna clarify everything that just happened. I'm gonna give you a very concise understanding that you are not crazy. You saw what you saw. It is horrible, but it doesn't justify the conduct.
Yep.
Wow. All right. Well, glad we watched that. Sorry we can't do YSL, but you can probably get a mistrial on Monday. Shanta Runkle, you would have defended her. If so, why? Every person deserves a defense.
Yeah, everyone deserves a defense, and you just do what you do, right? So that's pretty much it, right? It's just you do what you do, and that's the job. Like a lot of the time you're defending people who are guilty. That is what you do with the job. So you can't really complain too much. And the thing is you defend everyone because they have a right to a defense. So not, I've only said that I couldn't represent a very few people afterwards. One of them was a guy who was a child sex offender who was bragging about it. And I was like, no, you're done. And he's like, why? I'm like, you need somebody who doesn't hope you get hit by a truck, and that person isn't me. So yeah. The thing is I have been the lawyer who takes on the client who is on their sixth lawyer. And, where they're just where legal aid here was we need somebody to represent this giant problem case. And I'm like, okay. And it sucks because usually those people are miserable. But yeah, and same narcissistic has note there. The same reason nurses have to treat racist and other vile people. You sign up for it. My brother's work he's a doctor, and he does anesthesiology. He works in an emergency room. A guy can come in with a giant swastika tattoo on his forehead, and my brother can be like, yeah, this guy is an absolute piece of garbage, but you still treat him because that's the job. So yeah.
Random commenter's question. Lawyer has seizure in closing. What's the result? Likely a
Probably a
mistrial with
do-over.
re-prosecution.
Maybe they might just do a
Maybe.
do-over too, on the close. It's
You
possible.
could, yeah, sub attorney in. I think you could probably argue for a mistrial and then get a re-prosecution.
Yeah, I mean, they would be able to re-prosecute it, but if I was the defense lawyer, I'd be like, can I just get a do-over and like
sub
start
in.
at the beginning?
It's true.
So,
Snoopykins, good morning from the Netherlands. Hey, Snoopykins, glad to see you here. As I won't be here next week, don't forget to join in on Runkle's extra live stream next week. Much fun stuff to be auctioned for a great cause. Hope everyone has a great weekend. Snoopykins, thank you very much for that very, very generous member chat. And I do owe you a lazy Susan, which is en route as soon as I can find the boxes that hold them. I am taking little chips every single week and trying to make little dents in the stuff I have to do. For example, I put staples in the wall. I got yelled at by both children and adults for the staples in the wall behind me to just hang this so that I've got something that looks like a studio, even though my entire house is a chaos monster.
Rob, I got something similar. I'm gonna hijack things to go on a brief rant.
Go.
I bought this little set of lights.
Yeah.
And that's because in the US they have the Teal Pumpkin Project, and in Canada they have the Teal Light thing. And the idea is for kids who have food allergies. I had very serious food allergies as a kid, so I picked up
that's really clever.
Yeah, I picked up a box of like inexpensive fidget toys, and I'm gonna have the lights up so that kids can know, hey, if I've got food allergies, this is a house that is acceptable. So just encouraging chat, like, hey, if you have stuff, if you can get like safe stuff for kids, I really recommend it, because my allergies sucked, and when I was a kid, so maybe you can make a kid's Halloween suck a little less. So
love that idea.
Yeah,
great idea. Sir Merrick, I don't know if I feel this way. Two horrible people out of the public. I honestly I'm not a big fan of any of that. I don't agree with anything that happened in that relationship. I don't know that the remedy is one of them dead, the other one in jail.
yeah. I mean, I would have been happier if they both just moved on to other people and maybe grew as humans, right? So
not zipped one into a suitcase.
Yep.
Saying that part. Andel Feinstein, Runkle Leatherwork stream after party. That's on him. That's not
maybe
my decision.
My wrist is starting to get a little sore. I'll see.
But as it stands, it's 6 hours and 27 minutes in. It is 3:02 a.m. my time. I have to end the stream. Thank you guys for being here. I really do appreciate it. Ian will be live on Monday for his Monday Fun Day live stream. Hopefully I have the shop up and ready with possible camera setup in there. It'd be phenomenal if I could pull that off. And we're seeing progress on Ian's Cthulhu journal. Oh God, I love the handwork, man. I love when you do that. I like the handwork more than any of the stenciling. Like, I know you stenciled the drawing, but it's so much cooler. So I love when you do that stuff.
Well, and at the end of the day, it's something that's handmade, as opposed to like, you can buy stuff with cool patterns that they just run off with a laser, or, a stamp, like one big stamp that just stamps the whole image down so they can run off 1,000 of them. When I'm done with this, I'm going to throw this piece of paper out, and this thing is unique. So there'll never be another one. So
like my hatchet cover that has the drop stitch that you hate, that I love talking about because it's my favorite thing in the world.
Oh God, that I was just like, I'm out of time. I gotta send it off.
That's what happens. Random commenter says, same for a stroke. Looks like defense had one today. It was something we saw. I don't know what it was, but it was certainly not getting their client a not guilty.
Was it a stroke or a jerk? Because
very funny. Okay. I'm gonna wrap for this evening. Thank you guys for being here. Ian, thanks for hanging out with me, buddy. I'm glad to see you in the shop. I love the camera setup in there. And I really hope to see a lot more of these streams. This is really cool. And trust me, I know what it's like to be able to be in the shop, like working and tuning in. It's so much more fun than sitting at a desk, isn't it?
It really it is. And Rob, you missed the invocation of this camera.
Yeah.
Because I did a shop stream and people were commenting on how much better the camera was, and it was like, okay, you know, we're doing this, and you know, it was still a better camera than the old one. And then I was like, wait a minute, and I pulled the plastic off the camera, and it was way better after that, because I didn't realize as like I did most of a shop
Yeah,
stream.
that's about as that's about as an Ian move as I can get, as you can get.
So yeah, I'll probably do a shop stream for at least a little bit after this, so people can pop over there. I'll leave it
Great
as
idea.
non-members only because there's a number of people here who aren't members. So
Let 'em
it'll
hang
take me a
out.
few minutes to get that set up, but I'll get it set up and go for there. So, but yeah, no, this is a lot of fun, and yeah, I always love joining in on these because it's a lot of fun.
I like seeing you in the shop doing it. It's a lot of fun doing that because, you know, I don't want you sitting at a desk the whole time. I like you actually doing something that you enjoy doing.
I mean, I'm always doing 7 things, even when I'm at a desk.
I know you are. I know you are. All right. I'm going to end the stream because I'm going to fall asleep. And there's a child that's probably going to wake me up in about, say, 2 hours and 48 minutes. So good night, all. I hope you guys had a wonderful time. Have a wonderful weekend. Get out there, make something. Follow Ian's lead. Please go to the extra live stream next Friday/Saturday. I will roll FNF directly into that at the end of next Friday. Okay, so Friday FNF will probably end at 2 a.m. So, you know, we'll be an hour shorter than tonight. And you guys can roll straight into Ian's 24-hour charity stream and we'll pick up from there. But good night, all. Thank you guys for being here. Much appreciated and have a wonderful weekend.